Every day in the USA, people find themselves in court.
So, and I think they have him down already, so. She was going to a DARE graduation. All right, let's take it up. This will be the state of Tennessee versus Heather Marie Tierson, and it is two cases, 2024 CR 66, and then also 2025 CR 34.
Got it. And then she has subsequently had charges that have been bound over, which are 2025 CR 34. We would enter a plea of not guilty. I mean, effectively, we're arraigning her on those charges and enter a plea of not guilty, and we've been provided a copy of it. But now we have a universal settlement on both 2024 CR 66 and 2025 CR 34, if the court would allow.
All right.
Your Honor, what we have worked out with the state is that on the first charge on 2024 CR 66, the charge will be amended to attempted child abuse and neglect. She'll be sentenced to 2 years in the TDOC as a range 1 offender. The 2 years will be suspended and she will be placed on supervised probation. Pursuant to the term and condition of the plea, she is to take an A&D assessment, but Your Honor, she's already completed that through juvenile court and she's done that. And she is to follow the recommendations/treatment program that is set forth, and she is doing that through the juvenile court. There's going to be zero tolerance on drug use, and she will be required at a minimum to take monthly drug screens. As a term and condition of her probation, she'll pay the cost and she'll comply with all orders of the juvenile court for Dixon County. And again, Your Honor, on 2025 CR 34, she'll be pleading to count 1 of that indictment, which is simple possession of methamphetamines. She'll get 1129 suspended to supervised probation, $750 fine plus court costs, and it is concurrent with 2024 CR 66. Counts 2, 3, and 4 will be nollied by the state. And again, General, was I correct in my recitation? Thank you.
All right.
And so I have filled out the plea sheets. Mrs. Turgeson has signed those. I haven't passed them to the DA yet, so. Those are plea sheets. I hadn't passed them to you yet. I was just filling them out. So, Your Honor, we all have executed the plea sheets that we would request Your Honor approve.
Thank you. All right, Ms. Tierson, if you'll raise your right hand, Turson, if you'll raise your right hand, let's place you under oath. Thank you. If you'll step in front of that microphone, please. State your full name for the record.
Heather Marie Turgeson.
Ms. Tierson, you're here today on a two different indictments, and you've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges? Talked them over with Ms. Roberts and you, and she discussed the range of punishment you're facing, the possible evidence the state might have, and any possible defenses you might have to that evidence.
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty according to the agreement that was announced in one case and nolo contendere, or no contest, to the other charge. I want to explain to you the difference. In the case of attempted child abuse and neglect, you're going to be pleading guilty. That means that you could be asked questions about that particular case. In the other case, you're pleading no contest or nolo contendere. What that means is you're not admitting you did anything on that particular case, but you're not going to contest the state's evidence when they give me their evidence, and that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes.
You understand, however, that you will have the right to plead not guilty on all charges and have a speedy and public trial by jury.
Yes.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford one of your own. Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena? Do you understand that if you went to trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial? Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed and have a lawyer appointed if necessary to help you with that appeal? All right, you need to speak up a little bit because
Yes.
we're recording all
Sorry.
of this. Do you understand that by entering this plea of guilty and this plea of nolo contendere, you are waiving your right to a trial on all of these charges and also to the appeal that might follow?
Yes.
Do you understand this is going to result in 2 different convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime? Do you understand all the rights that I've explained to you? Do you understand that if you plead guilty on the one case, as I explained, the state could ask you questions, state or the court could ask you questions about that offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you are lying under oath?
Yes.
Is your decision to plead guilty and no contest today voluntary?
No.
All right.
Not voluntary. No, it's voluntary. Sorry, I thought you said involuntary.
That's the reason I asked the second question. Is anybody forcing you to do this against your will?
No.
All right. You understand that I have to have facts to support a finding of guilt in this case? All right, then, since we have a nolo contendere, it'd be easier if the state just gives me their factual basis.
That's fine, Your Honor. Can you hear me from here?
Yes.
Okay. In case number 2024 CR 66, on November the 10th, 2023, between that date and December 11th, 2023, Ms. Turgeson has a minor child, approximately at that point in time, 2 years old. There was an investigation that involved a traffic stop over in Humphreys County in which Ms. Turgeson was found in possession of drugs. She later pled to those charges in Humphreys County. Through that investigation, there was a DCS investigation as well that then came back to Dixon County where Ms. Turgeson resides. And during that time period, Ms. Turgeson, as well as her minor child, tested positive for illegal narcotics. The child tested positive for methamphetamine, cocaine, and THC, and that would be the basis of the child abuse neglect. In regards to the simple possession of methamphetamine, on September the 6th of 2024, there was a traffic stop of Ms. Turgeson due to a violation in which she pulled out in front of a ambulance that was had lights on. During that time, there was a strong odor of marijuana coming from her vehicle, and she admitted that she had a marijuana roach in the vehicle. A subsequent search took place of her vehicle, and there was a personal use amount of methamphetamine found in the vehicle.
All right, I'm not asking that you agree with all those facts, but you understand that's what the state's evidence would be if this case went to trial, if these 2 cases went to trial.
Yes, Your Honor, and if I could, just from a standpoint to clarify in the record too, is that in the juvenile court, what the general said up to the point is correct, but then there was a subsequent hair follicle test. The positive test for my client was a urinalysis. There was a subsequent hair follicle test that came back negative. And immediately upon it happening, but from a best interest determination, Mrs. Turgeson is the only person who has custodial rights to the child, and the biological father of the child, she allowed that person to have exposure to the child, or to have the child, and so again, the child was exposed. The child did test positive while she had the care and custody of the child. And so from a standpoint of a best interest determination, even though her hair follicle test was a negative test, she was the only person in care and control of this child when the child was exposed.
So are we saying that the child, I know you represented her in juvenile court. Did it come out in juvenile court that the child was exposed perhaps when the biological father was around? Is
Yeah,
that what we think
The
happened?
juvenile court, the child was removed from her in juvenile court until, and when we got the hair follicle test, the child was restored to her because the court determined, but she had gone through the whole process of doing all of DCS's requirements. And the child had been returned to her, and then the Department of Children's Services attorney, without knowledge and information to us, appeared and did a presentment to the grand jury on this case. And then she was subsequently arrested based on that, and so it was a situation where I felt necessary to
So
come
the
to represent.
urinalysis initially was positive, but the hair follicle taken right afterwards was negative on her. But there's no question the child was exposed,
Right.
and that your client's position that it was exposed was she was the primary caregiver for the child, but exposed by the biological father.
And and it was a failure to protect on her part.
Well, and
That's,
the only thing I would say to Ms. Turson is you understand how this all kind of boomerang back on you, and that might tell you what you need to do about allowing this other individual to be around your child if he's going to expose the child. I'm not saying that that is what happened. I know the state may have a different version, but
and
this
then
is.
she subsequently got arrested for additional, so the drug issue is there.
All right.
So, again,
I was going to add, in addition to, after she was charged with the simple possession of meth, there was another hair follicle, Ms. Turgeson, that came back positive.
Okay.
yeah, it was at the time, with the child scenario, it was a negative, but after that, this is a best interest determination, in my estimation, in my.
You have a
advice.
choice to make. If you want to do drugs, that's fine. I mean, nobody's going to stop you from doing that unless you get arrested. But if you do drugs, you're going to lose your child or you're going to kill your child. It's just that simple. So if you want your child to grow and be healthy and so forth, and I'm sure Ms. Roberts has preached to you about this as well, but you have that choice to make. You choose drugs or you choose your child. And hopefully you've learned a lesson from this and taken responsibility for it. And as a result of that, you will, move forward and avoid putting this child in that position. Are you satisfied with your attorney's services? You believe Ms. Roberts has done a good job of representing you competently. Ms. Roberts, do you know of any reason that she should not enter these pleas?
No, Your Honor, I do not.
Anything further from the state?
No, Your Honor.
Then Heather Marie Terson and docket number 2024 CR 66, upon your plea of guilty to count 1 and amended to an attempted child abuse or neglect, you're found guilty, sentenced to 2 years. Tennessee Department of Corrections as a range 1 offender and will be suspended to probation. You're ordered to, as a condition of your probation, to undergo an alcohol and drug assessment and follow the treatment recommendations. There will be a 0 tolerance for any positive drug screens. That means you test positive 1 time, you will go to prison for 2 years. Somebody else will be raising your child. You understand that? You will be undergoing monthly drug screens as a condition of your probation. You're ordered to pay the court cost and comply with the juvenile court order that's entered in your child's case. In docket number 2025 CR 34, upon your plea of no contest to the simple possession of methamphetamines, you're found guilty, sentenced to 11 months and 29 days in the county jail, suspended to supervised probation, a $750 fine plus costs. That will be served concurrent with the prior case, and counts 2, 3, and 4 are dismissed as a part of the agreement. She'll need to see probation.
Thank you, Your Honor.
Mr. Talbot, are you ready on any of yours?
Yes, sir. Gary Shadowins.
Gary Shadowins.
Your Honor, this was the state's motion to revoke bond, and I believe the public defender has an agreement to revoke the bond.
That's correct, Your Honor. With the asterisk, I suppose, we'd like to be able to file a motion to reinstate bond at a later date.
We will go on the record in the matter 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Christopher Stewart in person with counsel Nicholas Davis. We were set today in this matter for a 3-day jury trial. However, at the eve of trial this morning, both counsel wanted to meet in the chambers and needed to discuss an issue and requested an adjournment. Through much discussion and hesitation, the court did grant the adjournment. For the record, I will have Mr. Davis, you start with placing your information on the record, and then Mr. Schmidt can place his information and standpoint on the record as well.
Thank you very much, Your Honor. Your Honor,
Unless the state would like to start.
that's, I'll let the state start. That's fine.
Okay. Essentially, in this case, we came to learn that a woman named Cindy Stewart would be a witness for the defense. She was placed on the defense witness list. We were given some indication through correspondence and plea negotiations with Mr. Davis that she would say something about a statement Sophia gave at some point in the past related to this case. And that was believed to be some form of a recant of some sort. We wanted to set up an interview with Ms. Stewart. I tasked Detective Carlson with doing that. He wanted to have an interview with her in person for reasons really related to police experience and knowledge and getting effective cooperative statements from witnesses. That wound up not panning out through his efforts. He tried contacting her by phone. He was able to establish contact by phone. She originally said she didn't want to speak to him until she cleared it with Attorney Davis. Yesterday is when she made contact with Investigator Carlson. She interviewed with Investigator Carlson. Based on that interview, we decided we needed to interview the witness she was making a claim to her, who was also an important state witness, which is SM. We interviewed her, I believe around 3 or 4. Investigator Carlson was able to get me a written summary of that, not until 9 o'clock. I didn't see that till the morning. I sent it to Attorney Davis, I think around 6 o'clock in the morning. I didn't get the recordings of those till the morning when Attorney Davis got here, which was around 8:15. Those are the pieces of evidence.
All right, and they are critical to the case.
Under the Youngblood analysis, the interview of Cindy Stewart would be called what's apparently exculpatory evidence. The evidence related to what SM stated would be, it's directly relevant to what I believe the defense is going to be.
All right, Mr. Davis.
I just concur with that recitation. There's not much more than I can add on that. I know we're using the case Youngblood. I guess I could also use the Huggett case. I know the court's familiar with that. And the defense doesn't want to do that. I want time to have this discovery, which I think is exculpable. I think it's material, and I need time to look at it, research it, and speak to my client. And again, I don't know what's in it, but I have to concur. I believe that Miss Stewart Moody, she's a critical witness, and I believe that Cindy Stewart is a critical witness. And there may be other things that come out of that interview when I watch it. So with that, I join in the same request for continuation, Your Honor. Thank you very much.
All right, well, it would be your request, even though.
I should say the state's not objecting to my request for continuance. Thank you.
All right, and it's because simply you don't want to be thrown under the bus with this information and evidence.
Correct.
All right, and based upon that, the court did grant the adjournment, and it was through much discussion and argument in chambers, and I did grant that, but I am assessing the jury fee and jury cost to the defense. We are going to have another jury trial in this matter, and this one is going to go August 6th, 7th, and 8th. August 6th, 7th, and 8th, we already have Mr. Davis scheduled for another trial on that date and time. So we know his availability, and we will override that, and we will have that date and time. August 6th, 7th, and 8th.
Yes, Your Honor.
All right, anything further from the state,
No.
from the defense?
No, Your Honor. Thank you very much.
All right, then we are free to leave.
Advice of rights pursuant to MCR 4.201, Parents K, Parents 2. The following are the advice of rights as required by Michigan Supreme Court Rule 4.201, Parents K, Parents 2. This case is a landlord-tenant dispute, and the rules governing these types of cases require that the court make you aware of the following rights. Right number 1, the right to an attorney. Both parties have a right to an attorney to represent them at this hearing. Unlike criminal cases, no court-appointed attorneys are available to assist you. If you are financially able to retain an attorney, you may do so. If you need assistance finding one, you may wish to call the State Bar of Michigan at 517-346-6300 or online at www.michbar.org. In our area, Legal Services of Eastern Michigan may be able to assist you at no cost if you qualify for their program. They can be reached at 800-322-4512. MCR 4.201, Parents K, Parents 2, Parent I. Right number 2, the right to proper venue. These types of cases may be filed in a court different than the county where the property is located. If that has happened in this case, you have a right to have the case transferred to the county where the property is located. You can ask the judge to transfer the case to that county or court, and the request will be granted. MCR 0.4201, Parents K, Parents 2, Parents small a, Parent Roman numeral 2. Right number 3, the right to a jury trial. Both parties have a right to a jury trial to decide this case. However, that right will be waived if you do not request it today in court or file a written form called in demand within 5 days of hearing this advice of rights. You will also have to pay the jury trial fee, $50, when you make the request, unless you ask for and are granted a waiver of the fees by the judge. MCR.
Well, that's awesome. What? Is it Keisha French?
No, this is Stephanie with Stephanie Share Luxury.
Oh, shoot, I just passed it. That's being adjourned to next week, May 27th at 9:30.
Your Honor, since you're addressing adjournments, could I just briefly mention something?
Sure.
Your Honor, this is Alex Benson, and there just seems to be some historical errors here. And as you may have recalled, when we were here on April 29th, I had advised the court that I had a preoperative testing at U of M on May 5th for open heart surgery.
Yep, I remember you mentioning it.
Which I did then have on May 12th.
Okay.
I was in the hospital all last week and got home this weekend.
Sure.
Last night at 4:03, Mr. Sabo emailed me a supplemental motion.
Well, that's awesome. What? Is it Keisha French?
No, this is Stephanie with Stephanie Share Luxury.
Oh, shoot. Okay.
I was in the hospital all last week and got home this weekend.
Sure.
Last night at 4:03, Mr. Sabo emailed me a supplemental motion for today. I'm in no position to respond to it. I'm at this moment against doctor orders, even being on this Zoom with you. And there was an opportunity for them to come. There was an order entered by yourself on April 29th, which set forth what you wanted done. We were there on April 29th, and it suffices to say things didn't go as you ordered.
Okay.
But I'm just not in any position to respond beyond that at this moment.
Okay, sure. I think Mr. Sabo, you're.
Your Honor, as usual, Mr. Benson is starting to argue this motion. Your Honor, there's a two-prong on this. The second prong, the disputed items, I have no problem if we want to adjourn that a week and he responds. This is very basic. I'm looking for, Your Honor, to get the non-disputed items. Your Honor, as simple backdrop, we had the hearing.
Yeah, I remember. Yeah.
Remember, we were trying to pick a day, and Mr. Benson, the following Monday, was having heart surgery. So my client, it was a concession to say, all right, we'll meet in 2 days. So my client wasn't even there. He had to do it by FaceTime. So what we did there, we agreed on what could be taken. We took the small items. Your Honor, there's 400 chairs and bar stools, over 100 tables. So in 2 days, we could not organize a moving company. So thereafter, that same day, I shot Mr. Benson a full week of dates. And Your Honor, we don't need to be there. Mr. Benson, I don't need to be there. They already agreed on the tables, chairs, high tops, and stools that will be removed. So, and I simply, and it's in my supplemental, I sent an email, gave him a full week. We have all these days available. And they denied us any of those days.
Well,
So
Your Honor,
at a bare minimum, what I would like is at least that we can have back the agreed upon items. And then if Your Honor chooses to adjourn this motion for the disputed items, I fully understand.
Your Honor, that's not at all what he's asking for. What he's asking for is you made a ruling after a very lengthy discussion about getting the property, giving us a list, and your order was utterly ignored.
No.
Please don't interrupt me. I didn't interrupt you once. The order is so clear that you said, Your Honor, that was the day they were to remove the stuff.
Is this the new one? Is this the new one?
Yeah.
We went, there's a lot of noise going on.
I don't know where I'm getting the noise from. I'm sorry.
So we had a very, I'll wait until you
Hold
talk.
on, hold on. Yeah,
Yes, Your
hold
Honor.
on. Okay. I'm gonna mute everybody and then I gotta apparently mute up.
Yeah.
Hold on just a minute here. Mr. Benson, I've gotta have you on mute now again, and Mr. Sabo. There you go. Mr. Benson, there you go. Mr. Sabo, you're there?
Yes, Your Honor.
Okay. And Mr.
So-
Benson? Okay.
So when we get there, by the way, at no point in between April 29th and May 2nd, does Mr. Sabo reach out to me and say, hey, listen, I just want to be clear. We're not going to be able to take the stuff on the 29th. Zero, never. We get there and we say, where are your trucks? He says, oh, we're not taking the stuff today. And I'm like, what are you talking about? The judge's order says today's your day. So he says, no, we're just going to take some of the stuff that we can move, but we're not taking everything. We're just going to put Mr. Sabo, please. It's really annoying. He says, we're just going to put stickers on things today and come back another day. And we're like, what is going on here? The judge could not have been more clear in his order. So I called your court from the facility because we hadn't gotten the order yet. And they sent me the order. And it's a handwritten order from you. I don't know if it's actually your writing, Judge.
Yeah, it is. I
Oh,
got it.
okay. Parties or agents with authority and their respective attorneys shall meet at the property on 5/2 to allow agreed upon items to be retrieved by defendant. I don't see anywhere in there where it says it's the day to put stickers on items that you want to come back and get at a later date. It says, this is your day, cowboy. Get your stuff, get out.
It was my intention to get the things.
And Your Honor, with all,
yeah, sure, go ahead.
with all due respect, Your Honor, we wanted it the following week. The only reason we picked that day was because he was having open heart surgery the following Monday.
No,
So
he
we did this all for his convenience. We go back in the record, we wanted the following week. We have to get, Your Honor, a full moving company. There's 400. There's no way we're getting a full moving company in 2 days.
So let me ask both of you, are items there that were agreed upon, are they tagged of some sort? Is that what
Yes,
it is?
Your Honor, all it is, it's tables, chairs, high tops, and stools. That's it.
All right, so let's do this. We got, the order was clear, but you know what? This is why I never did any divorce work. Maybe I ought to have Mr. Haldy step in for me to do that part of it. You guys are cutting hairs on things. I wanted things removed that day because you guys aren't getting along somehow. The items that are tagged over there, and Mr. Benson, were you there on this date too then or
It
not?
sure was, Your Honor.
So there are items that are tagged? Is that what happened?
Yeah.
There
On
are
some of
items
them?
that we do not dispute.
Okay,
And then there are these things he attached to his motion that I should not have looked at last night, but I
Yeah.
did look at last night, which are clearly items that we consider all appurtenances and are not their property.
okay.
Your Honor, that day, we agreed on certain and we disagreed on certain. So yeah, that is in a
Okay.
nutshell.
So why don't we do this? Okay, when Mr. Sabo and Mr. Benson, I know you got your health concern. And I'd rather have you, is there some time that Mr. Sabo or whoever go over there and get the items that are tagged that say, yep, these are agreed on?
I think that is something that I can work out with my client,
Okay.
who
Yeah.
ironically is having a cardiac ablation right now.
Oh, jeez.
Must be a restaurant, yeah, but no, I'm teasing.
But I'll
teasing.
take an ablation 7 days a week over what I'm going through.
I'm not laughing at anybody. I really not.
And Your Honor,
Just-
we can do is push this sorry if I cut out. We can push this out to accommodate his client. I understand there's medical issues. We don't want to interfere with that.
Yeah.
So if maybe we could agree upon the week, sometime Monday through Friday, the week after Memorial Day, so the week of June 2nd. Mr. Benson, with that week, you believe he would be back in the saddle?
To pick up the undisputed items.
That week. And then, Your Honor, I
Yeah,
don't need to be there. I don't believe Mr. Benson does either. I think that's something that it's already tagged and agreed upon. So I was not planning on attending.
Okay. So and then why don't, everybody's got a phone of some sort. Why don't they just, for both your sakes, somebody, and I'm not ordering it, but it might be a good idea if somebody just takes pictures of the items that are tagged that are outside of the property. You know what I mean?
Yes, Your Honor.
Okay. So to pick up items agreed upon that are tagged. Agreed.
And Your Honor, I don't have a problem with an adjournment as to the disagreed upon items, even 2 weeks. If Mr. Benson needs it, I have no problem with that.
I'm not supposed to be working until after June 12th. I want to be clear on my timeline because you keep misstating it. On Monday, May 5th, I had a day of post-op testing at U of M. On Monday, May 12th, I had open heart surgery and remained in the hospital till Saturday when I came home. So those are the salient, accurate dates, Your Honor.
Okay, so I'll give both of you heads up. Quite frankly, I'm going to be tied up that June 14th for sure. That weekend goes into the next week, anyways.
That's fine.
When am I gone? So I think that's going to work one way or the other anyway. So I'm not going to.
I hope tied up
through
means
12 through 20.
I hope tied up means a vacation. Actually,
Okay. Yeah.
I meant for you.
Oh yeah. No,
Judge.
thank you. Well, I wish it was. Well, it is kind of a vacation. My daughter's getting married. So
Congratulations.
well, thank you, and I trade you places too sometimes, Mr. Benson, with that one. I got a lot going on with that.
Judge, that happened to me in October of last year. All that money's all gone too. My daughter got married. My daughter's a fancy lawyer in Washington, D.C., and she got married there.
Oh, so you're probably even worse shape than me. Mine are going out to California, so.
I got
so-
one, don't worry, I got one there also.
All right, let's, during the motion, and again, I'll leave it open. Do we just want to pick some date so I've got it on the, so I don't lose
Yes,
track
please.
of it, that's all. What,
What date, Your Honor?
24? Mr. Best, June 24th for the
Sure, that's
motion?
great.
Okay. June 24th.
Congratulations, Your Honor. It's gonna be the best day. Enjoy it.
Well, thank you very much. We'll see how, I'm trying to stay out of all the hoopla right now. I'm just signing things, signing checks.
That's,
all I'm doing.
your opinion really doesn't matter, Judge.
Yeah, that's exactly right.
Okay.
Exactly right.
All right.
Thanks, guys.
Thank
All
you.
right.
Thank
All
you.
right. Yep. Bye now. Okay. And let's see. This one's adjourned. Clover Tree Apartments versus Janisha Fells. Yep, I'm sorry, I gotta get everybody.
Hello there, it's Johnson Master.
Master, is this Master?
Yes.
And let's see, Janisha Fells. Anybody? Okay,
Okay.
all right. But I would probably pick up a copy of that. If you're gonna do that, just call the court, make sure I've signed it.
Okay.
Okay.
right,
Hopefully
thanks.
that helps you too. All right.
Yeah.
All right. Good luck to you.
Right. Thank you very much, Your Honor. Thank you, ma'am.
You too. Bye now. How about Linden Lane Apartments versus Gerard Scott? Gerard Scott?
Good morning, Your Honor. Brian Butchart for plaintiff, P66250.
I'm here.
Sure. And Mr. Scott down at the bottom, it looks like.
Am I here?
You're here, I think.
Okay, I don't, my video, I don't know. This is my first time doing this, but look, I'm so glad I got in verbally. So I don't know if you can see me or not, and I'm kind of leery about trying to switch over to video. I don't want to hang up. Just
no, yeah, yep. I'd rather be just like you are. You're fine. We don't have video, but that's okay.
Yes,
let's
sir.
see. Do you have an answer for Mr. Bouchard? I have oh, there's a jury demand on here, I guess. Is that where we're at?
and I'm asking for an adjournment as well. I'm trying to get my counsel together. I was under the impression that Mr. Kyle Laurie was going to send someone else from Eastern Michigan, but unfortunately he didn't. So I am right now, dealing with a few attorneys, and I'm just figuring out the best one that's going to represent me later on down the line.
Judge,
Mr. Bouchard,
I'm sorry, Judge. I thought your audio just cut out a little bit. I wasn't able to hear what you
Are
previously
you
said.
still there, Mr. Goggins, Judge Goggins?
Yeah, Mr. Scott, hold on just a minute.
Okay.
Let me hear from, first of all, from Mr. Lowry, just so we.
I'm confused as well, Your Honor. I indicated last week on the record that legal services was ending our representation entirely, and never indicated that we were sending someone else. I have documentation here that I told Mr. Scott he should seek private counsel through either the Genesee County Bar Association, whether he needed to search on the internet, or even the state bar legal referral number, that we were no longer going to be assisting. So I'm confused as to why he believes that we were sending someone else to help. Because I think I was abundantly clear even on the record last week that we were no longer assisting in this matter. So
Yeah, and that was my understanding as well. Mr. Scott?
Sorry to interrupt. My understanding is that I was going to get someone else from Eastern Michigan, but again, it's just a confusion, just human error. I may have heard it wrong, or I've been going through so many things and I'm on so many medications, so I do apologize to you both.
Okay. Yeah, Mr. Butchart, you were kind enough just to hold on there. Why don't you help me out?
Your Honor, certainly under the circumstances, I would never want to begrudge somebody the ability to have counsel if they choose to proceed with counsel. However, Judge, a couple of things. Number one, I don't believe that I've been served with an answer yet. I don't know if there's an answer in the court file. So I don't have an answer on the complaint.
I sent it in the mail.
I actually, it looks like it's actually it was time stamped yesterday. So looks like we just got it.
Okay.
I can, I'll have my staff just email it over to you. Do we have an email for you?
And Mr. Butchart, just for the record, so I did send it to you.
No, I've got it here.
Yes, sir.
Statement person.
Judge, I'm happy to add my email to the chat too. I see Janet, who I see.
Thanks. Yep.
Okay.
Can you write that down by chance? His chat message there. I mean, email, and then we'll send that to you by email. Well, at least you'll have that. And then, I guess with that, for the time being, I do see he's out for a jury. There's a jury demand. Mr. Scott, did you pay for a jury?
What do you mean? Did I pay for a jury?
Well,
I came in and they waived the fee.
Okay.
If that's what you're going to.
Well, that's
yeah. I was ready to pay the $50, and the ladies behind the counter were so delightful. They said, "Well, no, if you're disabled and and then they had me fill out the waiver form or whatever." So my hat goes off to them. Yeah.
Okay, Mr. Butchart, apparently we've got a jury demand here too. So
Understood, Judge. I understand the matter's going to get put over. I believe I may have somebody on from it looks like property manager April Warden is here. I guess I would request escrow, Judge, while we await this matter to proceed.
And as far as escrow, I want you to help me out with that too.
Your Honor, I'd have to refer to my client. May I have her unmute and identify herself?
Oh, sure. Yeah,
April,
I had to.
Can you unmute and state your name, please, April?
Yes, this is April Warden, property manager at Linden Lane Apartments.
And April, can you tell me how much Mr. Scott's monthly rental obligation is?
Yes, as of right now, his monthly rent obligation was $259, as well as HAP has been charging his account for his last repayment agreement where he did not report in employment as well, and that is $102.
So I guess I might go. I'm sorry, Mr. Butchart, I kind of cut in there.
So his total monthly obligation is $361. Is that correct?
Correct.
Okay.
At this time, we are in the middle of a new certification. That's what brought this whole proceeding up, is when we were redoing his annual recertification. We have found that he is still employed at the place that he was previously employed at, that he said he no longer works at. So based on our estimate,
I did let the people know that I was working there, Judge Goggins. I did let them know that I was working there. If not, they would not have increased my rent amount. My rent amount reflects an increase. Again, it was just a total mix-up. I was in the hall. April came to me and we filled out the papers, and I must have checked the wrong box, but my rent did go up significantly. So either the extra monies was either going towards the extra money was going towards the repayment agreement, or it was going towards the employment.
One of the people that comes in and see, he just had a question.
So just to finish verifying, based on what we have from the EIV for his current recertification, there's over $10,424 in income that was earned in 2024, which means that he should owe close to $3,500 going forward for rent, because his rent should have been more based on that income.
And
So
Judge Goggins, there was another lady that was running the apartment complex, and I attempted by letter, and you should have I have the letter. I attempted to let her know that I was working, and it was water under the bridge. She never increased the rent, and I never thought about it. If this is just a total mix up, I am willing to pay whatever I owe, and, that's just the big and the in and out of it. I'm willing to pay and go ahead and sign a new recertification agreement going forward. And I just want to keep a good relationship with the apartment complex. I'm willing to pay and work everything out.
Okay, so Mr. Bachar?
Based on the current numbers that were stated, Judge, we would ask for an escrow order in the amount of $361 per month. Judge, prorated amount for the remaining 11 days of this month, that would be $128. And then we would ask for $361 moving forward. And then if those amounts, if we're able to verify an income change and we settle on new amounts, I would motion the court at that point for some kind of variance on that order.
Sure. So we've got Mr. Scott, $489 that has to be placed in escrow.
I think your
I
sound.
can barely hear you, Judge Goggins, but yes, I heard you say 489, and again, this is yep, I can hear you a lot better now. 489 in escrow, meaning what? I could just give it to them. I'm totally prepared to pay the 489. Can I just give it to the front office, or how? This is totally new to me. I've never been a victim before.
That particular amount, I don't have any problem if he pays it right to him as long as we keep record of it.
Judge, I don't have any issue. Only my only concern is this is a termination case, and I don't want to run afoul of Park Forest.
Yeah. So, how do we want to do this? I guess. Why don't you, Mr. I guess honestly, Mr. Richard, probably easiest rather than getting in an entanglement with all that. Let's just have him place it in escrow with the court.
Okay.
You want to just do that? That makes
fine.
Just easier. So Mr. Scott, the 489 to be paid through the court.
I come there where I've
Flushing Court.
I've come on Pearson Road.
Yep. You got to pay that into the court for escrow.
Okay, and Judge, and like I said, this is totally new to me. What is this accomplishing by me doing this? This is just more or less like.
Well, you're still. This is just to assure that rent's being. This is just sure that rent's being paid while you're still there and we're making decisions.
Okay, yes, sir. All right, I am willing to pay that, and
so
and then you say escrow.
Yeah, the court's going to hold on to it.
Okay, I understand, and then they hold on to it until what? This matter is worked out.
Yeah, well, until I make a decision or something else gets worked out. Yeah.
Okay. All right. I'll learn more about it as I go.
Okay, so 489 by when can you pay the 489? Just so I've got something written down here for you.
This is 489. I don't know how long is Mr. Pritchard and Mrs. Warden willing to wait until I bring it. However long, however much rope they're going to give me. I can pay it, but this has just been so stressful for me. So I'm willing to pay it, and hopefully they give me a little time to pay it, but it definitely will be paid.
Well, Judge, the court rules would provide that the 128, which is the prorated amount for the rest of this month, would have to be paid within 7 days, and then the rest of it, which is the 361 for the month, which would represent the month of June, that would have to be paid by June 7th. So if the court wants to break it down in that fashion, I'm certainly happy to, of course.
Sure. I appreciate that, Mr. Butcher. I was just trying to make it simple in one amount, and that was it. But you, sir, the 128 has to be paid within the next, by the end of the month here, whatever that is, May, say 20.
So 128 within 7 days.
Yep.
and 361 before the 7th.
Yep.
I'm gonna write this down because I know that it probably won't be in writing because we're doing via telephone or Zoom, but I'm gonna write it down. 128
By within 7 days.
within 7 days of today,
Yep.
which would be, today is the 20th, so by the 27th, and then the 361 by June 7th.
Is it right out on June 1st? Is that what it is, Mr. Pachard?
Right, rent's due on the 1st, grace period to the 5th.
Yeah, so it's got it, I'm gonna put
Okay,
down
it'll be
June
paid.
1st, but, okay.
Okay, it'll be paid, and I appreciate you both, and we'll work this thing out. Me and April will work it out, or however it goes, or Mr. Goggins, or however it goes. I'll work it out, and the funds will be available probably sooner than later.
Okay, and Mr. Bashar, could you for me, just because I know what's gonna, can you get an order for me? Just to have an
Certainly,
order.
Judge. The scale form is a motion in order. I think I may be required to, I'll draft a proposed
If you
order.
could just yeah, it'd just be easier for me, that's all. Yeah, I don't care if it's just on a general, just the general scale for it, that's fine.
Happy to
Just
do
so we
that.
got those time on there. I think I'd rather leave it to you than me
Certainly.
at this point. Okay.
Do that, Judge. And then with respect to the jury demand.
Yeah, I put down leave on for jury trial, and my staff will get the date for that. I'm just not sure when our next jury trial. I
Okay.
assume you want it as soon as I can get it, whatever that date
Yeah,
is.
Judge, and does the court typically do pretrial dates for that or any motion dates?
I generally with these, we can do it if you want it. It may just be kind of a waste. I can keep that jury trial date as if it looks like it's going someplace, we leave it as use it as a pretrial date.
Okay. Yeah, happy to, whatever the court's current or.
Okay, so it'll come out as a jury trial date, and if the parties aren't, Mr. Scott, for your sake too, if things aren't going so well, we're just gonna have our jury trial, okay?
Okay, all right, and like I said, all of this is new to me. You're saying actually the date will be a pretrial date, but it could turn into a jury date.
You're gonna get a notice it'll be as scheduled as a jury trial. That's what you're gonna have. Now, if one of you, Mr. Bashar, I think you can, if somebody's asking for an adjournment, we'll consider it, okay?
Thank you, Judge. And just one other thing.
If someone asks for an adjournment at the jury trial, then you'll consider it.
I'll consider it. I'll figure out what we're gonna do. Yep. I'm
sorry.
sorry.
Just one other thing for Mr. Scott, if I may address Mr. Scott directly.
Sure.
Sir, feel free to give me a call. I've been hesitant to reach out to you directly because you've been indicating that you were seeking counsel, and certainly please give counsel my contact information, which is on your pleadings. If that falls through, if those efforts fall through and you want to speak with me directly, feel free to reach out at any point. I'd be happy to discuss the case with you, okay?
Thank you so much, Mr. Burchard. And just talking in person and hearing the person physically really, it really makes a difference in, just putting words on a paper. So, yeah, thank you so much. And I will call your phone definitely and reach out to you and keep you posted on my end. I appreciate you.
Okay. Thank you, Judge.
Yeah. Yeah. Thank you, Judge.
Thank
And you said just bring the money to the courts where I've been going.
Yes, yeah, we'll have an order. Wait, I guess I'm going to tell you to do that. Mr. Bachar, when can you get an order? Do you think?
I'll have some time as soon as we're done here at the proceedings,
Sure.
Judge. I should have it over to the court within the next half hour or so.
Oh, that's great. So I'll sign it. And Mr. Scott, just call first, make sure I've signed that order. But it'll be within an hour, couple hours, okay?
Okay, I will call before. I'll just give it because I know you're so busy. You got so much on your plate. I'll just give it to about 3 o'clock or something like that.
Yeah,
Judge.
that's perfect. That's perfect.
Yes, sir. And does the court accept cash, or I know they don't accept cash, but a money order, cashier's check? What should I get?
Money order, cashier's check will work. And if you got some concerns with that, just call the court and my staff can help you with that. Okay.
Yes, sir. Yes, sir.
All right.
Thanks for your time, Judge.
All right.
You're welcome.
Thank you all. Thank you all.
you.
Yeah. God
Thanks for
bless.
the pick.
Thank
Yeah,
you.
yes,
Bye-bye.
sir.
Yeah, you're welcome.
All right.
Bye.
All right. Yeah. All right. Bye-bye.
Mr. Haldy, I'm keep waiting. You're gonna hopefully get me back to a normal schedule. I get a couple others with just ones on here. Torrey Hills versus James Shotwell and Tasheen Shotwell.
Good morning, Judge. Kenneth Scott on behalf of the defendants Shotwell.
Matson, P87729 on behalf of plaintiff.
Matson, and let's see, I've got an order. Let's see, motion to remove. All right.
Thanks for your time, Judge.
All right.
You're welcome.
Thank you
Thanks.
all. Thank you
Thank
all.
you.
Yeah. God
Thanks for
bless.
the print.
Thank
Yeah,
you.
yes, sir.
Bye-bye.
Yeah, you're
Yeah,
welcome.
all right.
Bye.
All right. Yeah. All right. Bye-bye.
Mr. Haldy, I'm keep waiting. You're gonna hopefully get me back to a normal schedule. I get a couple others with just ones on here. Torrey Hills versus James Shotwell and Tasheen Shotwell.
Good morning, Judge. Kenneth Scott on behalf of the defendants Shotwell.
Matson, P87729 on behalf of plaintiff.
Matson, and let's see, I've got an order. Let's see, motion to remove locks. I don't know, is that what, oh, this must be Mr. Scott's motion.
Yes, Judge.
I've been trying to get my home since the last court date when you told her that locks here come off. Still in my home. Looks like this was by your client. Did he write
Correct,
that?
Judge. She filed the motion herself, and then she subsequently came in and retained my office.
Okay, okay.
And all it is, Judge, is a simple motion. What has happened is that she's been trying to have the trailer move, but the plaintiffs have put a padlock on the trailer, and then subsequently they put a truck in front of the driveway so she can't move the trailer. And they own the trailer outright. So the only issue was the lot fee.
Oh, so they're gonna actually move it?
My client?
Yes. Yeah.
Yes, Judge. But they've been attempting to move the trailer, but the plaintiffs put a padlock on the trailer, and then they put a truck in the way. And I have pictures of that.
Okay. Miss Matson, would it help if I give you a chance to talk to Mr. Scott? Maybe that'd be easier for me.
I would just like to state that my client has been trying to work with Miss Shotwell. They have reached out to her. They have told her that whenever she would like to have the home unlocked, that they're willing to do so Monday through Friday, 8 a.m. to 5 p.m. She has not reached out to them. She has been refusing to cooperate with them.
Judge, well, the trailer should not have been padlocked in the first place.
Okay, well, we got the pad. If we can just get it, Mr. Scott, just for the practical side, if we can get it unlocked, will that work rather than going through?
Well,
I mean, if you want to file a
unlocked.
motion, then yeah, just to get it
Just
unlocked.
get it
sounds like-
unlocked and move the truck. There's a
Yeah.
truck blocking the way.
And then if there's a motion with regard to something else regarding it being locked, I can deal with that later. But Miss Matson, does that make sense too? Can we do it that way?
Your Honor, unlocking the home without giving her access day and night, is that what you're saying?
Well, I'm just saying there's a date. If we can get a date that Mr. Scott, it sounds like she's going to move it as soon as it gets unlocked. Is that what's going on?
That's what you're gonna do. Yeah, that's what she's trying to do, Judge. So why don't we do this? Because I don't see a reason for the trailer to be padlocked. No one lives in the trailer. So it's not about unlocking the trailer so someone can stay there. It's making it accessible to the movers so they'll be able. So why don't we have them to unlock the trailer, move the truck, and give my client a week to move the trailer because we got a holiday coming up.
All right, Miss Matson, does that make sense? I don't know the situation there. Does that make sense to do that?
Your Honor, my client is willing to unlock the trailer whenever Ms. Shotwell or Mr. Scott reaches out and says that they would like to have it unlocked. However, they have failed to reach out.
Yeah.
Well, hold on. Judge, that's not true. She's been talking with management there, and they still have not unlocked the trailer. But what it is, Judge, is that we want the trailer unlocked, whether the mover comes during the hours of 9 to 5 or after 5, it doesn't matter. We just want to make sure that it's accessible so we can be able to tell the mover that they can schedule to move the trailer.
Miss Manson, maybe the easy thing for me is figure out if there's a time that they want it unlocked and you just get it unlocked, and I guess that's it. Is there a reason it's locked right now other than safeguarding things inside it? Is that what it is?
Yes, Your Honor, it's for the safety of Miss Shotwell's belongings and also the community as well, if there's just a home
Yeah,
unlocked.
Judge, that doesn't make sense to me because they want to put their lock on it, and my client already has a lock. So she's
Well,
not.
let's just get a time, and they're telling me they'll have it unlocked. Just give me a time, and I think that'll work, won't it?
Yes, Your Honor, if we could just have a date and time and the
Judge, she has to schedule it with the movers. So it's hard for me to give you a date and time right now.
Well, I'm not talking about having the movers. If she's saying I want to unlock now, I guess that's, I for the parks situation, I just can't have it unlocked indefinitely, just for their sake too. I don't want anybody to get hurt, that kind of thing.
Well, my client has indicated, Judge, that they can take their lock off and she can put her own lock on there and give the key to the mover.
Your Honor, I mean, the order of eviction was executed. She doesn't get unlimited access to the home anymore. So, like I said, they've been willing to work with her, and all she has to do is tell them when she wants to come, and they will unlock it for her, and she has failed to do that.
All right. I guess, Mr. Scott, let's just leave it like that. If she wants it unlocked, if she needs it unlocked right at a certain time, the movers are there. They're assuring me that they're gonna come right over and somebody can unlock it. Is that like, Miss Manson, just for my sake, is there somebody available? I want to say 24 hours, but is it Monday through Friday or something like that? What do you have?
Monday through Friday, 8 a.m. to 5 p.m. And they're willing to unlock it for an entire day. So she said that she needs it unlocked on Wednesday, May 21st. They'll come unlock it at 8 a.m. for her and then lock it back up at 5 p.m.
Mr. Scott, does that work? Can we do
No,
that?
Judge,
Start out with that?
no. I don't know. What if the movers come after 5? That's all I'm indicating. See, they're talking about, they want to give me a time limit between 8 and 5 p.m. We have to.
Well, if you can give me an exact time they're coming, a window, then I'll order, listen, somebody's got to have it unlocked then. And Miss Matson's not going to like that, but at least we have an actual time, but I can't have it just sitting there open either. I don't want to do that for anybody's sake.
Well, what I don't understand, Judge, is that it's not open. The trailer has a lock on it. The defendants have their own lock.
Okay. Listen, I'm going to put both of you back in. If you two of you can work it, I'm spending a lot of time on something that we're going back and forth on. If two of you can't work it out, I'm just going to say Monday through Friday. She's going to give them a call. They'll unlock it. That's going to be the order right now. I mean, that's for the practical side is, she's going to have free access to it, especially during those periods when the office is open. But they can't leave it vacant if they're worried about other people coming in and wreaking havoc on the property too. So that's up to you, Mr. Scott. I'll give you that window there, but if two of you can work out something else, then that's fine. Do you want to talk to Miss Matson on that?
You want me to respond, Judge?
Well, the response is just what I'm telling you. I'm going to order Monday through Friday, 8 to 5, or two of you can work something else out. Fine.
Okay.
Thank you, Your Honor. And
you want me to prepare the order, Judge?
Miss Matson, you want him just to prepare an order to that effect?
Yes, Your Honor, I can prepare it.
Oh, you want to do it? Let's let Miss Matson can do it. She'll get it. Send it over to Mr. Scott, but I'll sign it. If you want to send it over today, that's fine.
Thank you, Your Honor.
Okay. All right. Mr. Scott, anything else? Does that kind of cover at least that part of it?
No, Judge.
Okay. All
I'm not
right.
like the other. I'm not like the other Mr. Scott now.
Changing my whole docket. All right.
I'm gonna have to record his little speech to the court. He really know how to stall, don't he? You were so nice with him. You said, okay, okay.
Well, I'll let it go so far. So we're
Yeah,
gonna.
but then he
we're gonna call
says
it.
that, do I
All
bring
right.
cash or a cashier's check?
Yep. Yep.
You don't care how he pays, long as he pays.
As long as he pays, I don't care. As long as they'll take it.
Anyway, have a
All right.
good day, Judge.
You too, Mr. Scott. Bye. Miss
Bye.
Manson's. Thank you. All right. Oh, shoot.
Yeah.
Should be exit somewhere on there. Exit full string.
Where you see that?
Right here. Oh, hold up. Let me see.
But gosh, get it paid sooner than later would be better for you anyways, okay?
Okay, thank you.
You're welcome.
Bye.
And I'll sign that judgment on that matter.
All right.
Ms. Thompson, you're all set.
Okay, thank you.
You're welcome.
Bye.
Bye. Hunter's Ridge versus Carol Nelson. Carol Nelson, anybody? No, Carol Nelson. Looks like I got nobody on our Zoom meeting. Let's see. I do have personal service. We could proceed.
Right. Ms. Simpson, this is not an attempt to recover possession for non-payment of rent. Is that correct?
That's correct.
And it is in fact a request for immediate writ based on the tenant's violation of the rules and regulations of the lease?
Yes.
Right. What specifically are you referring to here that you believe would warrant that action by the court?
Rule number 30 in the lease, which states that you can't disturb the rights and conveniences of others that live there. We've had numerous conversations with Miss Nelson about the fighting that's going on in the apartment. I'm having other residents threaten to move out because they can't live under these conditions.
And what has been the tenant's response?
She said she knows there's arguing going on. She asked if there was anything we could do to work it out. I said no.
And you're asking the court for an order that will allow you to for immediate writ of eviction?
Yes.
Your Honor, I can't hear you. It's
I can't hear him either.
no.
I don't know if somebody's coming out.
Well, there
There
now
you
we can hear you. Yeah.
Boy, I don't know what's going in and out for some reason. That's my end. Help me out. I've got to fit it in the statute a bit. How do we get into an immediate eviction? It sounds like
Well,
there's
I'll
at
take
least
10
enough.
days.
Okay. Well, if we can get immediate, is it there's fighting going on at the residence? Is that what
Yes.
it is?
Yes.
Have the police been called out?
I don't
You know?
know.
Okay. Okay. Mr.
They
Halvey?
have been in the past, but I don't know she's moved a gentleman in with her and it's just gotten out of control.
Okay.
But the fighting is within the residence itself.
Yes, it is.
Your Honor, I think just maybe for fairness to everybody, if you would allow an eviction after 10 days.
I think I got to fit it that
Yes.
way, May 30th though.
And I note, Judge, that maybe the judgment you have, it should be blocked probably 4B checked. Instead of
Oh, okay.
4A.
Yeah, in
Sorry,
fact, I
didn't
just
do that.
no, that's okay. Yep, I just
Okay.
did that for you.
Thank
So,
you.
yep. Yep. So we're all set. So May 30th, ordering eviction. Okay, that'll take care of that one.
We're all set.
I think that's it.
I think it is.
Great.
Thank you.
Thank
Have
you,
a
both
good
of you.
holiday weekend.
Thanks, you too.
Bye now.
Bye.
Bye. How about Pasadena Mobile Home versus Anastasia Parnell?
Good morning, Your Honor. Brenton for the plaintiff.
Good morning, I'm here.
This is an adjourned date from May 6th. Ms. Parnell, did you apply for rental assistance?
Yes, I went in and spoke with the officers this morning and gave her the paperwork. And she said she was going to call my.
That, I believe we would like to move forward, and the writ date would be 5/30/25.
Very good. When a default judgment law writ eviction May 30th. How about Riverside Crossing versus we had Eleanor Hodges who's deceased, and then Sherry Davis, looks like. Do you have Sherry Davis? Yeah, gonna telephone lit up. Do I have Sherry Davis? Anybody? No, looks like nobody responding, I guess. It's an adjourned date. There was a rental assistance application in. I think we can continue if you want to, Mr. Ingram.
Thank you, Judge. Given the non-appearance, the fact that this has been adjourned, we were asking for a default judgment. There actually is a money judgment component for this one. It looks like the pro rata amount would be $1220.04 plus cost. The rent to retain itself, however, would be $1,390.72. Cost is $236 for a redemptive total of $1,626.72. The writ date would be 5/30/25, and I can submit that.
Okay, very good. We're under default judgment. How about Riverside Crossing versus Jessica Hosner and Bill Hosner? Nobody responding. This is first time up. I do have personal service as well as court mailing. We can proceed.
We would ask the court for default judgment. This is also one where we prayed for a money judgment. So the rent to retain itself is $656.69. The cost is $2.
And Shonda
Hello?
Jones. Hi, ma'am. What's your name?
Sherry Davis, my phone went out of service and then it went on mute. I was here, but I couldn't push the buttons.
Okay. Was that one of yours, Mr. Ingram? Sherry Jones? I can't remember.
Sherry Davis.
Oh, Davis. I'm sorry.
Yeah,
okay.
I was here and it kept on going in and out because I'm at a hot spot for
That was
internet.
for Hodges, I think, right, Judge?
Yeah, Eleanor Hodges for my deceased mother.
Oh, that's right.
Yeah, we can, well, if it's easy for you, Judge, if we can proceed with the Jones, Thompson, South Creek one, then we can jump back to that.
Sure.
Yeah, that'd
sure.
be fine. That'd
Okay.
be fine.
All right, just stay right there, ma'am. Hold on just a
Okay.
minute.
Okay.
And we can go back on the record with Jones and Thompson with South Creek.
Yeah, at this time, we're asking for a default judgment. This one's to be possession only. The rent to retain is $1994.80. I have cost of $206 for a redemptive total of $2,280. And we've got a writ date of
Hello?
5/30/25, Your Honor.
Okay.
Hello, this is Jones.
Oh, never mind.
Week, May 27th.
Yeah, I think that they'd be entitled to that based on the court rules.
Okay, ma'am, we'll see you back on May 27th. Hopefully we get it resolved by then, okay?
Okay, thank you so much.
You're welcome. Bye.
Bye.
Bye. And then we were jumping on with Davis there. There should be one there on the state. It's just about, just a couple back. Just I think it's Meadowbrook. There's the state. It's got Davis on there and Mr. Ingram, what were the names on that file?
That was Hodges. Hodges, yeah. I can give you the court.
Yeah,
the
nope,
number if you need it.
she just found it. I've got it in front of me. Riverside Crossing versus Eleanor Hodges and Sherry Davis. Miss Davis, you still there?
Yes, I'm here.
Okay. Mr. Ingram, I guess I'm not sure where we were at, other than I had Hodges.
Well, this
was
is,
deceased.
Right, this is an adjourned hearing. It's against all occupants, so I believe that she would fall under that rubric.
Yeah.
Yeah, at this point, we would want to move forward with a hearing judgment with the money component put on the record previously.
Okay. And I do have the rental assistance application that was in prior to. Ms. Davis, are there any updates on your rental assistance?
No, I'm still waiting, and they saying since my mother, did passed away, and she didn't, didn't do put everything in order before she passed. It's getting difficult to try to get everything out of her name since she's gone, and I didn't have no power of attorney over her. So it's like the only thing they said I could do was probably take the title to Secretary of State and have it put in my name. That's the other option. Or go to probate court and try to get her name removed off the title, which that's probably going to be hard too, because since she's not here.
Yeah.
So it's like,
Yeah.
I don't know what else to do.
Sure. And I understand for Mr. Ingram's, I think the practical side is just to proceed again. Let's go through the figures and everything, Mr. Ingram.
Yeah, no problem. The rent to retain is $1390.72. There's cost of $236 for a redemptive total of $1626.72. As far as the money judgment, the pro rata amount through today is $1220.04 plus cost.
And Ms. Davis, I understand the predicament you're kind of in too. Anything else you want to tell me with regard to payments or?
I just started a new job about a week ago, so I'm trying to work on getting my first pay stub so I can, figure out how much I'm able to pay. I won't know until about after the holidays, because I just came in on the tail end of the pay period, so I probably won't get my first paycheck till probably after the Memorial Day weekend or afterwards, somewhere around there. I'm still trying to figure that out.
Yeah. During I guess just use the normal statutory time period. So
Yeah, I mean, she's welcome to reach out to my client if she wants to work with them to go beyond that. She's certainly able to do that.
Yeah.
Communication is key.
Yeah.
So, but other than that, yeah, we would want to stick to the statutory time for this one.
Okay. All right, ma'am. I'll sign a judgment for the amount owed and allow writ of eviction after May 30th. Okay.
Yeah.
But still, like you're saying, just talk to them, okay?
Yeah, I know when I work like different hours, and I know she don't be in the office by the time I get off, because I get out late, about 9, 10 o'clock. And when I get up ready to go to the work in the next morning, she's not here. Well, she either here or she's not. She's been in and out the office here lately for over a week, so I don't know what's going on.
Yeah. Boy, I can't really help you with that part.
Yeah, I understand that.
No, I know. I just feel bad for you. I just don't know what else to tell you other than make contact with them, okay?
Yeah, I'm all right.
All right. Good luck to you.
All right. Thank you.
Yeah, you're welcome. Bye now.
Bye-bye.
How about Meadowbrook versus Tanya Neal? Tanya Neal, anybody? Nobody responding. Looks like I got nobody on our Zoom meeting. This first time up, I do have proof of service plus court mailing. We can proceed.
We would move. Uh-oh.
Hello? Hello?
Hi, ma'am. Are you Tanya Neal?
Tanya.
I know. I just feel bad for you. I just don't know what else to tell you other than make contact with them, okay?
Yeah, I'm all right.
All right. Good luck to you.
All right. Thank you.
Yeah, you're welcome. Bye now.
Bye-bye.
How about Meadowbrook versus Tanya Neal? Tanya Neal, anybody? Nobody responding. Looks like I got nobody on our Zoom meeting. This first time up, I do have proof of service plus court mailing. We can proceed.
We would move. Uh-oh.
Hello? Hello?
Hi, ma'am, are you Tanya Neal?
Tanya, yes, I am, sir.
Oh,
I had
okay.
to, I had to tune in. Sorry.
Oh, that's all right. I got you now. So,
Yes, sir.
did you want to talk with legal services or have you applied for rental assistance?
General Motors, they laid off all those people, as you know, I'm one of them. And I
Yeah.
talked to the landlord. It seems that she goes by what the neighbors say about me instead of me. They, the gestures type of stuff. But anyways, I applied for some of my 401k because we're considered in hardship because we'll be off almost 4 months and up to 4 months.
Yeah.
And I applied for the unemployment part. I get that check next Thursday or Friday. No, Thursday. Then the 401k I get it that Friday, which will clear everything up. It clears everything up.
Okay, so I'm sorry, Mr. Ring, I think she said by next Friday.
Yeah, the
Yeah, Friday midnight.
401k loans usually
Yeah,
take
that's a
around,
process.
they take
You said
around
what?
10 days or so usually
Yeah.
to
No,
disperse.
it was almost 900 people got laid off, sweetheart.
Yeah, no, I understand,
They
ma'am.
just got to me after almost 2 months.
Well,
So
you
mine has been done. Go ahead, Judge. I'm sorry.
I was just gonna say you hung in there for pretty long, so at least you made it past that.
Yeah, I did. Yes.
It's a
Mr.
first hearing. I'm okay with putting it out a week, Judge.
Okay. All right, ma'am, we'll adjourn your matter to May 27th. Okay?
Okay. Well,
27th.
what day is the 27th though?
Next Tuesday.
But I get the money after that, so I don't get
No,
it.
I know,
I mean,
but this will kind of keep it on my docket. But try to get, I guess the only thing I can tell you is try to get something paid by then. We'll address it
but
on that.
I'm telling you when the money is coming in though, I don't get it. I'm letting you know.
Yeah, no, I
It'll
appreciate
be
that.
there. One's coming Thursday and the other comes Friday. I don't see why I can't go till the 30th so I can clear everything up.
Mr. Ingram.
Because the 27th isn't allowing me to pay it.
Yeah, no, I understand.
I'm not really comfortable putting it out beyond that, Judge.
Why
Then we're
would you
getting,
not be
then we're
comfortable
getting,
putting it out?
then-
And I've been
then we're-
communicating. You're not paying it, sir. You wouldn't
Then
be
we're getting-
comfortable because you're not paying it. I'm
then
trying
we're
to
getting
talk
it-
to you.
well, my point is then we're getting into next month and then next month's
No,
gonna
you're
be
not.
due.
No, well, how you know I can't pay next month? You didn't even ask me. Next
ma'am,
month ain't here. You can't talk about next month because it's not here. I'm letting the judge know when the money's dropping, like it did the last time. It dropped, and I cleared everything up.
Well, ma'am, we can cross that bridge at the next hearing and we'll see where you're at and hopefully we can resolve it.
Well, I'm telling you, it's going to be the same Tuesday, the 27th. I won't get my money till the 29th, one check, and then the other will be in my account. The unemployment will be on the card that Friday. So it's going to be the same. That's what I'm telling you. I'm going to still be waiting on the money to fall Thursday and Friday.
I understand. Let's just rather than go through with it today, though, let's just adjourn it to next week. And if you tell me the same thing, we'll address it next week. Okay? That still gives you.
Yeah, it's going to be the same thing. So what's Tuesday? What is that? The same thing as today, a hearing or what?
Yeah, it's going to be set up the same type of thing. It'll be a hearing set for May 27th at 9:30.
And what happens then? I just tell you the same thing I'm telling you today. I get it 2 days. I get it.
Yeah, that's the best I can tell you. Unless you want to just go through it today, I can make a decision. It was not going to be. It's
feasible,
the
right?
week
Yeah,
gives you-
I know
the
when the
week
money's
gives you
coming
better.
in. Next, go ahead.
week gives you-
Okay, I'll see you next Tuesday then
Okay.
to
All
tell
right,
you the
let's do
same
that.
thing.
Yeah.
Okay,
and
thank you
Monday,
kindly.
Burger. You're welcome. Bye.
All right, bye bye. Have a great day.
You too. You too. Bye.
All right, bye bye.
I don't know if I was winning that one or not, Mr. Ingram. I don't know that I. How about Flushing Estates versus looks like Carrie Basarge and Sophia Langley. Anybody? Curry Basarge or Sophia Langley? Any?
Yeah, I do too. We
Good.
get through it.
You better hang up before you get a last
I know.
call there.
Enjoy the rest of your day, Your Honor.
Thanks, you too, Mr.
It's always a pleasure.
Very good. You too. Bye, guys. Bye. How about Arthur Meyer versus Leanne Moore? I got Mr. Moore here.
Yes, sir, I'm here.
Yep. How about Arthur Meyer? Arthur Meyer? Anybody?
I'm Leon Moore, sir.
Yep. No, I got you, Mr. Moore. I'm just looking for Arthur Meyer. Set aside default. Mr. Meyer has failed to appear. We set today's date for payments. Well, Mr. Moore, I guess I'll just dismiss your matter. Looks like he didn't show up this time.
Sir,
Yes.
this is Leon Moore.
Yep. Yeah, I understand, Mr. Moore. I'm gonna
Location program, and I moved in this room. I gave him $900, and my nephew had passed, and I gave him a text message saying I'm gonna be a couple of days late for rent. But he had texted me, and I got all these messages and these voice messages. I got mad at him because he called me the female dog. You know what I mean?
Yeah.
And so, and when I found out the water wasn't good here, I was gonna move out anyway. But since he called me that female dog, I say I'm gonna make him go take me to court. But I wasn't planning on staying here too long anyway. But I'm gonna be out of here. But I'm gonna try to go to legal services or whatever to try to get assistance on what I owe him. But I had the money until he called me that B word, and I just had buried my nephew, and he know that. He seen. I even showed him the money because he came over here a couple of days before I supposedly even paid rent because he was doing something to. He was showing another room to another client, a potential client.
Okay.
But after that, I had got mad and was dealing with all this death, and I wasn't gonna stay here too longer anyway.
Okay. So
Judge,
here's what I'm gonna do,
But
Mr. Moore.
Judge, I just wanted
only
to
thing
help.
I'm asking for is a few days and not be up out of here because I don't own a vehicle and I got to get my belongings out of here.
Okay. Hold on just a minute, Mr. Moore. I think Mr. Lowry may give me some insight here.
I don't want to waste Mr. Moore's time because it sounded like he said he was going to try and contact legal services for money to help pay. We do not have any funding to do that. We only handle the legal side. So if the court is inclined to dismiss this case today, my advice to Mr. Moore would be to vacate as soon as he possibly can. If the money thing is an issue, that's something he can work out with them. I just don't want him wasting his time or spinning his wheels coming to our office seeking funds that we don't have. We strictly handle legal cases. So I just wanted to be clear so he's not wasting his time. If he's looking for funds, he's going to have to try DHS or GCART or Catholic Charities, but I don't know that they will do anything, especially if the case is being dismissed. I think he should focus on moving and dealing with that as it may come in the future or not. So. We can't hear you again, Judge. I don't know what happened to your sound.
It's weird.
Now I can.
Yeah, it's like I don't know what's going on. I'm not covering anything. It's just going in and out for some reason. Must be our connection. Mr.
It's
Moore,
like it's going up and down the volume.
Yeah, I know it. And I'm watching the mic. Sometimes it's going and sometimes not. It's on again. Mr. Moore, do you understand that though? I think the biggest thing is just focus on it. If you're moving, just go ahead and move. I'd do that. Okay.
All right. I'd like to ask the court, can I have a couple of days so I can move my belongings? I don't own a.
Well, here's what I'm telling you right now. I'm dismissing the case. So he's going to have to refile. So that gives you, by the time he refiles, you could be gone. Okay.
Okay.
So I'm just dismissing. I would
I've been
move
looking for
soon as you can.
employment. Beg your pardon?
Yeah.
Sorry.
Yeah, no, I'm just telling you the best thing to do right now is just, if you're going to move, just move. I'm just dismissing the case. There's nothing pending right now. Okay.
All right. I could be out of here within a week easily.
Okay. Well, I would focus in on that.
Okay. So it wouldn't be no help for me to go down to DHS or nothing like that because they don't have no funding, right?
Well, he was asking for a termination anyways, as I'm looking at it. It looks like he just wants you gone. You want to leave. I'd leave. I just leave right now before anything else.
All right, I'll be out of here within a week.
Okay.
Easily.
All right. Mr. Moore, you take care, okay? You're all done then.
Yes, sir. Thank you for your
All
help.
right. All right, you're welcome. Bye now. Bye. Let's see. How about Justin Grizzle? I think I got you up in the corner versus Richard Robinson, Mary Robinson, and
Yes.
Brandon Robinson. Anybody? Any Robinsons?
Your Honor, they may be here on the Samsung, but this is Kyle Lowry, P79631 here on behalf of the Robinsons. I filed an appearance this morning.
Anything else?
All right, I'll be out of here within a week.
Okay.
Easily.
All right. Mr. Moore, you take care, okay? You're all done then.
Yes, sir. Thank you for your
All
help.
right. All right, you're welcome. Bye now. Bye. Let's see. How about Justin Grizzle? I think I got you up in the corner versus Richard Robinson, Mary Robinson,
Yes.
and Brandon Robinson. Anybody? Any Robinsons?
Your Honor, they may be here on the Samsung, but this is Kyle Lowry, P79631 here on behalf of the Robinsons. I filed an appearance this morning.
Okay. Okay. So, are you asking for adjournment then?
No, I'm not actually, Your Honor. I would actually be asking to move for summary disposition on two bases under MCR 2.116C4 for lack of subject matter jurisdiction, and MCR 2.116C8 as the plaintiff has failed to state a claim in which relief can be granted because this property, it's come to my attention, is actually owned, or the interest in the property that Mr. Grizzle has is under a land contract under his LLC, AEJ Holdings LLC. So he is not the real party in interest. So he's actually committed the unauthorized practice of law by operating as the LLC and filing in his name. The notice is defective, the pleadings are defective, and I don't think the court has jurisdiction and the case should be dismissed. So we're asking that the case be dismissed and the caption be amended to all occupants to protect their interest because it's an improper filing.
Okay, I appreciate that.
I can't hear you, Your Honor.
Mr. Grizzle, I did see somebody. You see a lot of articles.
Judge, you are quiet again. I don't know.
Wait, I don't know why that's doing that.
Yep, I'm having trouble as well.
Let me. I think I got. If it's an extra speaker, maybe.
Okay, I can hear you now.
Let's try that. I wonder if my
There
speaker's having.
It's much better now. Whatever.
It's got to be the speaker that's wired in it. I think that's what's having issues. Mr. Grizzle, that the articles of organization show it in the AEG Holding LLC. You can't represent that LLC. You got to have an attorney for that. Unless you're an attorney, I guess I talk about that.
No,
but
I guess I'm not understanding, Your Honor.
And my further concern, Your Honor, is I believe he filed this in his name individually as Justin Grizzle. It should be filed as the LLC as well. So
yeah. So you got a combination of things. So this looks like the rental properties in the AEG Holding?
Yes, AEJ.
Okay, and for one thing, you got two things, concerns for me. One is, let me make sure I got it here. Yeah, it was filed under your name, Justin Grizzle, and you're not a party to it, really. It's the AEJ LLC. It's in the LLC. I'm sorry?
Right. I own the LLC.
Yeah, but that LLC is who has to file it. It's that corporation, that limited liability company corporation that's got it. So you can't do it. You got to have an attorney do it.
Gotcha. So it's been 2 months and I'm just now getting this information.
Well, that's in your court. If whatever you file, you're taking the risk of not having it filed properly. And apparently that's what you did. You filed it. You really should have talked to the attorney or a attorney. It's not the court's fault. It's not anybody else. It's your fault.
Gotcha. Now, also, Judge, this is a motel that they're living in that is daily. Why can I not evict them? Because they
I
were
can't-
paying rent daily.
Again, I can't give you legal advice if this case here is not filed properly, though. So I can't even, I wouldn't give you legal advice anyways, but you got to get it filed properly and you got to have an attorney representing the LLC. You just do.
Can I talk to
can't,
legal services?
I'm sorry,
Or
what?
am I allowed to talk to legal services or no?
It would be a conflict of interest at this point because we represent the Robinsons. So we would not be able to assist you in our office. So
Talk
But they
to
have
some
not
other,
even made attempts to pay rent. They're over $6,000 behind in rent.
Your Honor, I would object to what we're getting into because the
Yeah,
court
I
lacks
can't-
jurisdiction to hear the matter. So the merits of what Mr. Grizzle's asking for are irrelevant at this point. You know, I would ask that the court dismiss this and amend the caption to all occupants to protect my clients. I would be happy to draft an order and submit it to the court to that effect.
Yeah.
That this
It-
matter is dismissed and that the caption be changed to all occupants. Because I believe this is an improper filing. You know, I'm not trying to make this hard on Mr. Grizzle, but we have laws and court rules the right way. Well, Mr. Grizzle, I could ask for more. I could ask for sanctions and court costs, but I'm not trying to do that to you. I'm just trying to protect my client's record from, you know, what is an improper filing. And I think they're entitled to that. So, you know, I could ask for more. I'm not trying to do that. I just am asking that it be done the right way. That's all I'm asking.
And I understand that. So you don't want the sanctions of a couple things, and not that you willfully doing it, but you can't act as an attorney unless you're an attorney. That's part of it. The case is just, you know, it's just easier. It's just not filed properly. Motion to amend caption will be granted to all occupants, but the case itself will be dismissed. And then, Mr. Grizzle, you've got every right to file it. It's just got to be filed properly. I talked to an attorney, okay? The best I can tell you before we get into trouble and I got to call the Bar Association, and I don't want to do any of that, okay? Yeah, and you don't want that either. I don't think that's the intention, that you're trying to operate as an attorney, so, okay?
No, not at all. I had no clue.
Yeah.
Right?
Yeah, I know it. I know it. And sometimes, trust me, this happens, I don't want to say regularly, on a regular basis, so it does happen once in a while. Okay.
I mean, it is part of the protections that come with an LLC.
Yeah.
You get the benefits of personal protection and your liability, but there's higher standards and things that have to be done. And you know, this I also agree with Judge. I don't think you're trying to do this intentionally or personally, but we have requirements but I have ethical duties that I can put my own self in trouble by not raising this. So, you know, I don't think you're trying to be, you know, difficult or trying to do anything illegal or wrong. I think it's just something that I would just suggest, like Judd said, to contact an attorney so you can do this the right way. So my only question for you, Judge, is are you just going to sign an order to the effect to ask for the caption, or would you like me to do it?
Mr. Lowry, why don't you do an order for me? It'd be easier just to do it as I've granted a motion to amend the caption to all occupants, and I'll sign that. Also include in their dismissal. It'd be easier for me to do it that way.
I mean, it'll be a quick order for me to draft, so I can get that over here right away.
Okay. Okay, so the case.
So do I have to start all over?
Yeah.
Correct. You will need to serve a new notice under the.
I'm sorry?
Do I have to give them another 30-day notice?
You will have to give them a new notice whether you would like to file for the non-payment or before a termination if you just want them out. But you need to do it under an LLC, and those documents need to be signed and drafted by an attorney. So.
Yeah. Talk to an attorney, Mr. Grizzly. You're going to get yourself into a predicament. Honestly.
Courthouse?
I'm sorry?
Do you have a list of attorneys at the courthouse that I can contact?
You can call. The only one we have is legal services things, and you can sure call and see if I don't know if we've got Mr. Lowry. Do you know who else?
I would
is doing?
suggest the Bar Association.
Yeah.
I think they do a I think it's $25 or $35 consultation, but they'll put you in touch with a landlord tenant attorney. And I think that number is 810-232-6000.
Yeah, that's the one I usually do. It's just the bar. Yeah.
Yep, 232,600.
All righty.
All right, Mr. Grizzle, good luck to you. I'm sure I'll see you back on at some point. Okay.
Absolutely.
All right. Good luck to you.
Thanks. Bye.
You're welcome. Bye. Let's see. I've got. Gosh, I got a Samsung. Anybody on that Samsung? I'm asking you to mute right now. Man, that Samsung SM-F936U1. Anybody? Nobody responding on that matter. Oh, there you go.
Every day in the USA, people find themselves in court.
Court does call the case, the people versus Alicia Brinson.
Echelon people. Good afternoon, Your Honor. Simon Khalil for the defendant, Alicia Brinson, who was present via Zoom and consents to the Zoom
Yeah,
proceeding.
she was the one that let us know that she needed me to get out here as soon as I could. Well, didn't quite put it that way because she had things to do. Miss Brinson, can you unmute and turn on your camera? Really? So she was so impatient waiting for me, and I can't get her on the camera. Thank
Judge,
you.
I'm right here.
State your name.
Alicia Stevens. How you doing today?
I'm okay. Counsel,
That's
go
good.
ahead with your petition.
Oh, it's going fine. I'm just trying to get this little last thing off of my record so that I can carry on with my life.
Okay, so maybe you didn't hear me. I said, counsel, go ahead with your petition. That'd be
Oh,
your
I'm
attorney.
sorry.
Thank you,
Go
Judge.
ahead.
Thank you. This is my client, Ms. Brinson's application for an expungement for a 2009 conviction for operating while intoxicated. My client is now 42. She is self-employed. She works primarily in the cleaning business, and she also has her own food truck. She volunteers very consistently in the community in the city of Detroit. She participates weekly in making sure that the homeless in her community are fed. She does have one minor child who's 10 years of age. The reason that she's asking that this court grant her application for an expungement is so that she can explore other employment opportunities. This conviction has impacted her ability to obtain employment. There is a letter from the Attorney General's office wherein no objections were stated, and we respectfully request that the court grant her application.
Any response from the people?
Your Honor, I wanted to be clear if the application is to the OWI account only or all three accounts.
The petition here I have is only to the OWI.
Then I have no opposition.
All right. Brenton, is there anything you want to say?
I just want to say that over time, of course, like I said, this was a situation where hello, can you see me? Okay. This was a situation where I was trying to do the right thing by parking and, realizing we all went out that night. My friend who was supposed to be the designated driver left with her boyfriend, so had to drive. I realized I was too drunk to drive. I pulled over at Tim Hortons to go to sleep. And that is why I got the DUI when the police came up to my car. So I tried to do the right thing. That I was young-minded. A lot has changed since then. You know, I'm now a home health care worker for the state of Michigan. I have a client that I have to be to at 2:30. So that's what I was. So I wasn't rushing you, but a lot of things have changed since then, Judge Simpson. I was before you, before, and I was telling you that a lot of things have changed. It has gotten better. I do have my food truck in the driveway now. So things are good. Things are different. I've grown into my adult phase, and I just want to say respectfully that I apologize to the community for, you know, the things that I was accused of doing.
Thank you.
No problem.
The court, having heard the allocution of the defendant, an opportunity having been given to the Attorney General and prosecuting official to contest this application. Court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the conviction as it and is consistent with justice and the public welfare. The petition is hereby granted.
Thanks, Your Honor.
I've signed that. Thank you.
Thank you. Have a great day, Judge Simpson. Take care.
You do. You too.
Services and Carrie Zane and these roles. That matters.
R&J Group Holdings versus Stafffield.
Your Honor, claims ready. Defendant just advised me she needed to use the restroom and walked out. Wait a minute. Up to the court.
Yeah, I'll wait.
Thank you.
Sycamore Meadow versus Autumn Meadow.
Good morning, Your Honor. Attorney Carrie Zane, Good morning, Your Honor. Emily Rule, PA 827, defendant.
All right.
Judge, I did give counsel updated ledgers this morning. I got them late yesterday, so I did hand for that and any of the research that we have that they requested.
No, never.
Well, I wasn't sure if you were winding your way there.
Winding? Wow.
Oh, is that why I go straight in?
That's right. That's right. She's winding into that.
Sorry.
All right. Court recalls the case of R&J Group Holdings versus Stafffield et al.
Plaintiff is ready, Your Honor.
Counter plaintiff is also ready.
All right. Where are we on this, folks?
Good morning, Your Honor.
Good morning.
God bless you, Your Honor.
I have trying to figure out exactly where our posture is on this case because I received 2 emergency ex parte motions. You have those counsel? Pardon?
No, I received one some time ago for an adjournment that's long since come and gone.
No, these were filed yesterday.
I have no such, I haven't been served with anything. I had no idea those were even in existence.
Well, and I'm trying to figure out why are they ex parte? Why is the request ex parte?
Permission to speak, Your Honor?
Yeah.
Okay, good morning. They are ex parte because the order that Your Honor signed for $5,000 a month bond escrow, we are trying to revise that to $250,000 refinancing proceeds of another property.
This case is this case currently before the circuit court?
It is currently it's been appealed. Your Honor's judgment has been appealed and we filed a motion to dismiss the appeal. It's still pending, but that's all I can tell you about that, Judge.
So we'll get copies of these to you, but that's what I mean, I'm not clear I understand these motions, because the first motion is to have a lending institution, you want the bond changed from 5,000 a month, which was the escrow order,
Correct.
to customarily then become your bond on appeal. You want that changed to a $250,000 bond.
Correct. And may I speak the reason?
You can, but I'm not even clear that at this juncture, I would have the jurisdiction to do that. Because I think you would have to request that of the circuit court to change the bond. I've set the bond when the case was before me. It's appealed. That, in my understanding, that's the only thing I can do once the appeal is filed. I can set the bond on appeal.
Likewise,
After that, it's the circuit court. So I don't even know that I can address this. I would also note, counsel, and like I said, we'll get you a copy. There's also this motion to have the R&J Group Holdings pay $250,000
Escrow bond.
for an escrow bond. I don't even know what that, they were the prevailing party, so I'm not even sure how that works. But
yeah, I can't comment on it. I haven't seen any.
I know, and that how these got on. I set this for a hearing on the escrow.
That's what I was under the impression was here today.
I didn't know anything about it. They are not on this document.
For the payment out of the escrow? Is that what I set it for? And I'm not gonna, well, the appeal is still pending, correct?
Correct.
The court set the hearing and I called the court.
Yeah, I
said that they wanted us to come.
Sure,
So
why did I do that?
When is the hearing?
I must have been under some determination that something had happened with the appeal, but you're telling me it did not.
no, the appeal is pending in the circuit court on this matter.
Okay, then I can't do anything with escrow, so.
May I ask you a question, Your Honor?
Sure.
Okay, Mr. Mamina's client has made several threats out loud, even in the hallways of this court.
So, ma'am?
To burn the house down. Does the court have authority to issue a PPO against him? I am protecting 4 underage children, my mother on the wheelchair. I don't want him to burn the house because we have a pending case. It's totally out of order.
Your Honor, that's preposterous.
No, it's not.
It's
You even
absolute.
heard.
I didn't hear anything like that. I
Oh,
don't,
yes,
I've heard,
well, a lot
I've
of
seen a
people
lot
did.
of things in this case I've never seen before, including ex parte motions seeking a $250,000 bond.
Yeah,
That's
it's a breach of
preposterous.
contract, sir. This is a breach of contract case and a jury demand.
Everybody done? No, I can't deal with anything. I have no jurisdiction. The jurisdiction at this point of this case rests with the circuit court.
Yes,
So
thank you.
Are you denying the ex parte motion?
I am,
Or refer.
yes, I'm denying them because they are improperly filed before me. Because I can't do that. You'd have to file those with the
Yes,
circuit.
we'll do that, Your Honor.
All right.
Thank
So,
you.
all right.
Thank you, Your Honor.
Thank you.
Appreciate it.
Here, this is so that no, that goes with it. Trust me. Then court is stand in recess and give me about 5 minutes and then council come back.
Your Honor, I just want to make it clear, Mr. Campbell and Ms. Brule would like to join us in the back. Is that okay?
Campbell, yes. Her, no. No, I'm kidding.
Against her, you're gonna have to fill that out. She'll explain it. And then we'll set them for the same day. Okay? I don't know what day she's gonna give you down there. Any questions?
No, just go down to, well, I guess I go down to the,
Civil Clerk.
okay.
End of the hall to your left, okay?
All right, thank you.
You're welcome. Consumer Portfolio versus Joseph A. Daly, 2402515. Appearances, please.
Good morning, Your Honor. David Drasnin of the Law Office of Richard Green on behalf of the Plaintiff Consumer Portfolio Services.
And sir, your name?
Joseph Daly.
All right. So you filed a motion for installment payments, correct, sir? Mr. Daly?
Yes. Yes, Your Honor.
All right. You want to go ahead and proceed with your motion?
Okay, well, basically, I mean, what I offered him is all I can afford. Today's not even payday and I have $0 to my name already. This is probably already going to put me underwater.
I'm going to ask you, Mr. Daly, to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
All right. So tell me how much you gross. You're telling me your income is $12.99 every week. Is that net or gross?
That's net.
All right. So you're making closer to $1,700 a week, correct?
Yes.
How much do you make per hour, or are you on salary?
No, I am making $28 an hour.
How many hours do you typically work?
55.
So that means 28 times 55. All right. And you get overtime on that, 1540, so you're getting $42 an hour for the last 15, right?
Yes.
All right. Okay, tell me your bills.
Okay, well, yeah, I'll start with utilities. My gas and electric is about $300 a month. My phones are around $139 a month. Water around $150. Sewer is around $150. Internet is $45 a month. My food bill a month is around $1,000, about $250 a week. Transportation, my car insurance is $305 a month. My car payment is $704. And I spend about $280 in gas.
All right, counsel, do you have any questions for him?
No, Your Honor, I did have an opportunity to speak to him in a breakout room before this hearing this morning, and I don't really have any questions. I just, for the record, I'm going to say, Your Honor, that my client has, filed this objection, indicated it would accept $350 a month, and I certainly leave it to the court's discretion in this matter.
It was set at $350, right?
Yes. No, that's what my client countered at $350.
And you want to pay $50 per week, Mr. Daly?
Yes, Your Honor. I actually, my other bill, I have housing, which is $614 a month.
All right, here's what I'm going to do. And I'm going to ask you to submit the order. Will you do that for me, please, Mr. Drasnin? I'm going to have him pay $50 per week beginning on, we'll just make it June the 3rd. And every Monday thereafter until paid, and this order is subject to review on or after, on motion of either party, on or after October 1st. Okay? It behooves you. What interest rate is this calculating at right now, Mr. Draston? Can you tell me?
Your Honor, it's the statutory rate. I'm not exactly sure. It's
I got it.
$5.
Okay, so I'm just telling you, it'll behoove you to pay this the sooner you can, okay, Mr. Daly?
Oh, yes, sir.
All right, understand that this installment payment order, he's gonna present an order to me, I'm going to sign it. Remember, they still could garnish bank accounts, and they still could garnish tax returns. Some of them don't at all, some do. But I just want you to be aware of that. So defendant to pay 50 per week beginning September the 3rd. Beginning June the 3rd.
And Your Honor, just to confirm, starting June the 3rd and every Monday thereafter.
Correct.
And
correct. And the order subject to review on motion of either party on or after October 1.
My payday is actually on a Wednesday.
Well, look, you just figure it out. You're going to get paid this Wednesday, and you're going to get paid next Wednesday, and your payment isn't due until the following Monday. Okay.
Okay.
I mean, Your Honor, I have no objection if he wants the payments to be on some day every week other than Monday. That's fine.
You guys figure it out. What do you want, Mr. Daly? It doesn't matter to me. I mean.
Oh, well, I was just hoping that, I could still have my boss do direct payments to them.
You're set up for that, right, Mr. Draston?
Your Honor, we at this point strictly have a judgment. I don't believe anything else has been done. So there's been no garnishment, as I recall, in this case yet. So if his employer can do that, we are happy to work with them.
Yeah, so you get a hold of Mr. Draston and you guys figure it out, okay? Otherwise, you have to send a check that gets there on June 3rd or before June 3rd, and then on or before June the 10th and 17th, and so on and so forth. Okay?
Your Honor, could the court put us back in a breakout room? Maybe I can get these details resolved with Mr.
Sure. Put them in the breakout room, Jennifer, please.
No problem. And Judge, there is a garnishment that was entered 12/23 of 24.
Oh, I'm sorry, Your Honor.
He does have a wage garn.
Okay, so you're gonna suspend that. You're gonna put that in the order too, right, Mr. Draston?
Yes.
Thank you. Have a good day.
Thank you, Your Honor.
Is Virginia Swindle here?
She has not checked in. And Judge, if I may, I have someone with a Samsung. I need her name.
You gotta put your names on the phones. I think our instructions are pretty clear. We can't tell who Samsung is. You got to tell us your name, ma'am, in the green top, it looks like. Thank you. You have to unmute and tell us your name.
Hi, I'm Christy Horner. I'm sorry about that.
Mr. Saloom, have your permission to sign your name to that proposed consent judgment, setting forth these terms on that proposed judgment that I will sign.
Yes, sir.
All right. Anything else, Mr. Saloom?
No, Your Honor. We'll get that to the court as soon as possible.
Thank you very much. Midland Credit.
Thank
you. Luck, man. Best of luck. Midland Credit versus
Thank you, sir.
Gin. 2404225. Is Ms. Ginn in here? There you are, ma'am. Your name?
Good morning, Judge Andrew Perry, P69402 on behalf of plaintiff.
Ma'am, your name?
Good morning. I'm Tiffany again.
Good morning. So today is the date scheduled for a pretrial. Did you two talk about this at all, Mr. Perry?
Judge, I offered to discuss the issues with Miss Jim, but she wanted to see you. She didn't want to talk about the case.
Okay. Let's see here.
We filed suit to collect on her credit card account, originating with Web Bank. It's alleged that she owes $584.34.
Do you agree that you owe that amount, ma'am?
Your Honor, I respectfully request that the case be dismissed. I did file a response to this case, and they haven't provided me any type of burden of proof.
Well, I don't know what you mean by that. You filed an answer. Why would I dismiss the case? You don't think you owe any of this money?
They failed to meet the burden of proof. I have not seen a wet signature.
Okay. All right. Now, wait a second. This is just a pretrial. They don't have to prove anything today.
Okay.
All right. I'm just asking you, listen, I mean, I don't have a problem if you want to make this, you want to go to trial. I have no problem with that. Sometimes You can make life a little easier on yourself. If you agree that you owe the debt, maybe you can get him to conditionally dismiss the case, subject to you paying a certain portion, weekly, monthly, or maybe
I
he'll.
just request that he provide me with full proof of ownership of this account. I haven't got any wet signature, any electronic agreement or anything. All he's showing me are statements.
Judge, perhaps we can get a discovery order so we can exchange some more information. Attached to our complaint, though, was a copy of the assignment showing the transfer from WebBank to Midland, as well as the billing records. So it looks like we might need some more time to exchange information. I'm not really sure what she's talking about when she refers to a wet signature, but I could send her some more records on the account. It's not a problem.
Jennifer, I want a trial date for it from you. I'm going to permit discovery for 60 days. Let's see. Discovery is permitted until July the 20. Witness list due June the 20. I'm going to make it July 15, July 15, discovery permitted until then, June 15. Witness list due. You don't have to file a trial brief at the time of trial. If you choose to file one, you have to file and exchange it not later than 7 days before the trial. I'm going to give you a date. All motions for summary have to be filed and heard now, not later than 20 days before the trial date. We're going to give you a trial date in August.
August 12th, Your Honor, at 10:30.
So I'm not going to adjourn this. Does anybody have any issues with vacations or anything at that time? August 12th at 10:30.
No,
Ms.
Judge.
Ms. Ginn, do you?
I'm sorry, what was the date?
August 12th at 10:30.
No.
Okay, so I'm going to put August 12th at 10:30 as the trial date. Discovery permitted until July 15. Witness lists are due June the 15th. Take a good look at this, if you would, please. And we're going to have this discovery order, this pretrial order out to you guys probably I'm sure by the end of the week, okay?
Okay, Judge.
Good luck. We'll see everybody here. Thank you very much.
Thank you.
Thank you.
America versus Christy Horner, 2500383. All right, Mr. Kirschneider, good morning again. Your name?
Michael Kirschneider for the plaintiff.
Is Christy Horner here? Yes.
She is, Your Honor. And Your Honor, just so you know, the parties have not spoke. I tried sending her to a breakout room, but she wouldn't accept, and now she's disappeared. Oh, she went to the breakout room now. Let me get her back.
Be seated.
Doors back in session.
All right, we have anything ready?
You got the 9:30 second
First choice, MH LLC versus Marshall Shearer and Robert Rice.
Judge, that one, they are in the breakout room. That is the only one that is in the breakout room.
How about Citibank versus Kelly?
Right to the podium.
Citibank versus Diane Kelly, 2404885.
Good morning, once again, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff.
Good morning, ma'am. Your name?
Diane Kelly.
All right, so people come in looking like they're going to a ball game or something.
I appreciate that.
Have a good day.
Thank you.
All right. I don't need them out unless they're ready on that. I'm going to call.
They are out, Judge.
All right. Let me take you, Ms. Kingsley. First choice, MHLLC versus Marshall Shearer and Robert Rice, 2403493. Good morning, Ms. Kingsley.
Good morning, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
All right. Where are the other two? Rice and Shearer.
Here,
He just needs to unmute and turn his video on.
Oh, there you are, Mr. Rice, bottom corner. Can you unmute and start your video, please, Mr. Rice? And then I'll need Mr. Shearer in here.
Mr. Shearer is not here.
So he's going into default.
Mm-hmm. And Mr. Bryce and I have an agreement to
Mr.
place
Rice,
him.
you got to start your video, sir, and state your name, please. I love Zoom. I mean, I really don't mind it until I feel like, I don't know. I don't know what to say. I mean, I don't mind it, but then I get this kind of nonsense. Like, where's he at? He should, can you chat with him, Jen? Mr. Rice, I need you to, there you go. Okay. Now, that's all right. You're fine. Now unmute in the bottom left-hand corner of your screen, please. Your name. Okay, so I'm going to call the case against First Choice MH LLC versus Marshall Shearer and Robert Rice, 2403493. Mr. Rice, your name.
Robert Curdington Rice, Jr.
All right, Ms. Kingsley.
Brianna Kingsley for the plaintiff. So,
And,
Your Honor.
Go ahead.
So, Your Honor, this is an action for claim and delivery for a manufactured home that is currently in default. So, Mr. Shearer no longer lives in the home and evidently lives somewhere in Maryland, unsure of his exact location. We've gone through the appropriate methods to obtain alternate service and had submitted a request for a default, and then the court had set this for hearing on entry of the judgment. So Mr. Rice and I have actually come to a resolution today, and I've spoken with my client. We're going to enter into a consent order for possession of the home. Mr. Rice, so this will enter by default as to Mr. Shearer. This will be consent as to Mr. Rice. So they can retain possession of the manufactured home so long as the past due, well, the accelerated balance of $58,422.34 is satisfied on or before May 30th of this year. If it's not paid in full by that date, then my client may submit an affidavit of noncompliance and a proposed judgment for possession. Mr. Rice and I have already gone through everything. He indicated that he was approved for a loan through Rocket Mortgage and intends to have the entire accelerated balance paid, and thereafter the loan would be satisfied.
Okay, so.
But I know that's a lot, Judge.
Oh, that's not 58,422.34. You're sure you're going to have that, sir?
I believe so. This is what my daughter tells me. She's the one taking care of this for me.
Well, okay, so
I was told that this would
hang on. So you want to submit a consent order of dismissal that says, consent order of possession that says that he's going to pay $58,422.34 on or before the 30th. It's going to be a default as to Shearer. If he does that, then he obviously retains the property. If not, your client is going to submit an affidavit of noncompliance and take ownership. True?
Correct.
Do you understand and agree to those terms, Mr. Rice?
Yes, sir.
Well, I want to make sure you can pay it. You positive you're going to have the loan go through in the next 11 days? I mean, we have Memorial Day coming up and everything.
That's what I was trying to explain to you a moment ago. It should be done by the 27th, but it could be done by the end of the week.
Listen, why don't you give them another week or so, will you, please? Tell them the judge wants you to give them another week. June 10th. Can we make it June 10th?
Can I call my client? It would have to be an updated accelerated amount as of that date. So I would just have to get the new balance because as it continues, I mean, late fees are going to continue to accrue.
Why don't you wait right there, Mr. Rice? Why don't you wait right there? But if he does June 10th and he pays by May 30, you still only have to pay the $58,422.34. You can put that
Correct.
in the judgment, right?
Correct. Yeah. Let me just call my client really quick to get the
Fine.
updated.
I'll go on to another case. Just stay right there, sir. I just don't want you to lose it because something weird happens. You don't get the loan out, right?
Yeah, and now I mentioned this tablet.
I got it.
And me losing you.
All right, give me Cornell and Plumbing, Edwards Plumbing. Do we have that file here?
Right to the podium there.
I need the file first, so wait 1 second. Virginia Swindle versus Tracy Linville. Nobody appeared on this. This was a show cause scheduled. Nobody appeared. I'm gonna go ahead and just reschedule the show cause, Jennifer. Ms. Swindle has a hard time getting here. So let's reschedule the show cause and give her another date. Put it out about 3 weeks. Will you do that for me, please?
No problem.
All right, now. Robin Cornell versus Edwards Plumbing and Heating Inc. 2404088.
Yeah, are you part of this? Yeah. Right to the podium.
Well, she doesn't need to be, just the lawyers.
Is she good, Your Honor? Sit there.
Yeah. Mr. Gutner, your appearance?
Good morning, Your Honor. Patrick Gardner, P70106, appearing on behalf of the plaintiff, Robin Cornell.
Mr. Kavanaugh?
Good morning, Your Honor. Philip Kavanaugh appearing on behalf of defendant Edwards Plumbing, 59404.
All right.
I believe, Your Honor, that we have reached a settlement.
Okay.
Put that on the record.
Perfect. Go ahead.
Your Honor, may it please the court, and we'll have defendant's counsel present at the end of the day. We've agreed to settle the matter in its entirety for the sum amount of $12,000 payable within 30 days from the defendant to the plaintiff through my office.
And a release will be executed, release of all claims by either party or just the plaintiff?
By the party.
All right, you agree to that, Mr. Kavanaugh?
We do.
Why don't you come on up here, Ms. Cornell? All right, so no question but that the defendant can pay that within 30 days?
I believe, yes, 30 days is fine.
Ms. Cornell, come on up here, tell me your name. Do you understand what your lawyer just said? You got to keep your voice up for me, okay? Your lawyer just told me that he's settling this case and you agree to settle the case for $12,000. That would be a full and final settlement of this claim. You would be releasing any and all claims arising out of this event, transaction, or occurrence for all time against Edwards Plumbing in exchange for this agreement. Do you understand that?
Yes.
So you understand you can't go back and sue them for any reason arising out of this claim that you have as set forth in your complaint?
Yes.
You could go to trial, you might get more, you might get less, you might get nothing. Do you understand that?
Yes.
But knowing all that, you wish to settle for this amount?
Yes.
And you're authorizing this claim on behalf of this resolution on behalf of your client, right, Ms. Kavanaugh? All right, good enough. Submit your paperwork. Is this going to be in the form of just a stip in order to dismiss, or are you guys doing it by way of a judgment?
I'd like a judgment, Your Honor.
Yeah, and you're going to enter into a judgment for $12,000, correct, counsel?
Yes.
All right, you guys submit that judgment, hopefully in the next couple days, and I'll sign it, we'll be done with it, okay?
Your Honor, appreciate your time.
Thank you both, have a good day. And good luck, ma'am.
Judge, I don't know if this matters, but she just showed up.
Oh, jeez. Where is she?
She's right here. Page.
Why are you showing up late?
I couldn't get out of work. Your Honor.
You can't do this.
It's happened so many times.
You can't do that. All right, I got it. Just wait 1 second. All right, Ms. Kingsley, did you get a chance to talk to your client yet?
Judge, they're fine with the June 10th date.
Let me call the case. First
I just
choice,
have to add
MHL. First
the
choice.
numbers really
wait.
quick.
First choice, MHLLC versus Marshall Scherer and Robert Rice, 2403493. Mr. Rice, your name again?
Robert Crittington Rice Jr.
All right, Ms. Kingsley?
Brianna Kingsley for the plaintiff.
All right, so did you get an extension for Mr. Rice here?
Yes, I did, Judge. I'm just adding up the final numbers with the legal fees and late fees, so. The accelerated balance alone on the loan is $58,422.34. And then there's legal fees of $2,330.30 so far. And then I'm just waiting on one more invoice for an additional legal fee that I need to add in.
So the agreement between the plaintiff and the defendant calls for attorney fees, does it?
Yes, these are attorney's fees that have accrued during the pendency of this case that my client is entitled to reimbursement for.
Yeah, as per the agreement that was reached. Let me just double check. Not that I would ever think that you would ever ask me for something that you're not entitled to, but I do want to check on attorney fees here. What page of the agreement is it on? Can you tell me?
Yeah, let me look at the purchase agreement really quick. Let me pull it up. Here it is. Okay, it is of charges.
Well, I'm just paging through it. I don't see anything that's entitled attorney fees.
Just give me 1 second, Judge. I'm going through the purchase agreement. It's always on the.
I hope you're not gonna. If lender elects to accelerate this note, lender may require borrower to pay all costs and expenses during the enforcement of this note and those incurred during the recovery, restoration, and liquidation of any collateral specified in this or any attendant collateral attachment agreement to the extent not prohibited. That doesn't specify strong enough for me that they're required to pay attorney fees. I don't see anything. I'll tell you what, I'm going to go on to another case here, okay?
Yeah, can we just pass this matter for just 1 moment?
Stay right with us, Mr. Rice, okay?
Okay. Yes, sir.
Virginia Ann Swindle versus Tracy Lynn Linville. 2402676. Your name?
Tracy Linville.
Boy, between you two, I feel like this case has been going on since I was a kid.
I know, right?
And that's not true, but I mean, it's been going on for a small claims case.
Yes.
So you didn't appear for creditor's exam on April 21. You can't miss these. That's a subpoena. That's an order. Where is, right. Okay, thanks. Okay, thanks.
Judge,
Yes.
okay, my client's gonna agree to do the consent for the 58,422.34.
Wait a second. Wait, I gotta go back and call it. Is that what you want?
Yes, please, I'm ready.
First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Everybody's name?
Brianna Kingsley for the plaintiff.
Sir, your name? Mr. Rice, I need your name, sir.
Robert Crittenden Rice Jr.
All right.
All right,
So-
Judge. So we've agreed to enter into a consent order for possession of the manufactured home. The final accelerated balance due on the loan is $58,422.34. And my client has agreed to give Mr. Rice until June 10th, 2025 to have that paid.
Okay, now this does not include attorney fees because I was right?
This well,
John, you have to take off your hat.
Oh, I'm sorry. Good morning. I just making sure, just getting logged in here.
hold on one second. I grabbed the wrong
You just muted again.
I grabbed the wrong document. I'll be right back.
Okay.
Sorry, Judge.
We're so nice, this would be disturbing, but go ahead. Go ahead, take your time. Jeez. All right. Let's do this. John and Aaron Purcell versus Gawk and Sons Towing, 2404841. Sir, your name?
My name is John Purcell.
Where's Aaron? Is she with you?
No, she is at work. As I was explaining to your secretary, Your Honor, is that I didn't get the second notice of the rescheduling for today, May the 20th. I did get a notice and a telephone call in regards to having to reschedule the last time, as well as gotcha.
Proper going on without being a car removal, because it shouldn't be explained.
Right. You better, why don't you talk to a lawyer, Mr. Purcell, please?
We already have, Your Honor.
Okay, good enough. I'll see you guys.
That's why we're coming here.
Thank you very much. Thanks.
Thanks.
First Choice versus Marshall Shearer and Robert Rice, 2403493. Ms. Kingsley, your name.
Brianna Kingsley for the plaintiff again.
All right. Mr. Rice,
Yes, sir.
your name.
Robert Crittenden Rice Jr.
Now you can go ahead and tell me what the deal is.
Thank you, Judge. Okay. After I removed all of the legal fees, the total payoff amount that is due by June 10th, 2025 is $56,092.04. While I do understand the court's position that paragraph 9F of the purchase agreement is not sufficient, we do disagree with that, and I would just like to note that for the record.
Yeah, I get it, but you know, to me, if you're gonna start collecting attorney fees, it better be abundantly clear, and it doesn't say one, it doesn't even mention the word attorney fees. It does say costs. Let me just double check.
Yes, it does reference costs. I believe it says costs and
Expenses.
yeah,
And
costs
that
and
isn't
expenses.
good enough for me to have me give you attorney fees. They have to be specifically spelled out as far as I'm concerned. So, sir, you saved a couple of $1,000 and you're gonna get till June 10th, but don't play with this. If you get the money today, pay it tomorrow. You with me?
Yes, sir.
All right, so that'll be a default versus sure by consent. You understand everything and agree to everything here, Mr. Rice?
I sure hope so.
Well, you have to pay 5609204 by June the 10th. If you don't, they're going to submit an affidavit of non-compliance and they're going to get the home. Do you understand that?
Yes, sir.
And you're sure you're going to be able to pay this, right?
According to my daughter, she's helping with this situation through Rocket Mortgage. See, Your Honor, I come into this with an 815 credit score before I signed for this loan, and I'm down to 635.
What happened?
I signed for this loan and they're not paying it. My daughter can't because Marshall left. Marshall Shearer left.
I see. You co-signed.
Yes, sir. That was a big mistake. I'm trying to help people and this is what I get.
I know. I get it. Yeah, it's not a good idea to co-sign. I know we want to help our family, but sometimes some people tend to get with the wrong people in relationships. They're not very, let's call them responsible.
This is her stepfather, Marshall Shearer.
Okay, well, I don't
Of all
know.
things, you know,
Anyway,
here
that's up.
I'm signing for a loan for my ex-wife's husband because she died.
Well, you're a good man. You're going to be taken to the right, you're going to go to the right place, sir. I don't know what to tell you. And I mean that. I mean that.
Thank you. That means a lot.
What's that?
Thank you. That means a lot.
I really wish you well, sir. Good luck. Just make sure you pay that and then you got the home. Good luck.
Thank you.
One
Have a great day.
One
too.
final
Thanks.
question,
Sure.
Mr. Wright. Do I have
Yes.
permission to sign your name to the proposed agreement and e-file it with the court?
Yes.
Okay, all right. I will get that drafted and filed with the court.
Thank you very much, Ms. Kingsley. Always a pleasure.
Thank you, Judge.
Good luck. Thank you.
Thank you for your patience this morning, Judge. I appreciate it.
No problem.
It's an 11 o'clock.
Do I have everything done until 11 now?
Everything's done till 11.
What's this, the set aside of the conviction?
Yes.
Give me the docket, will you?
Sure.
I'm completely messed up here. Are they back out of Pelletz's office with First Choice and Shearer and Rice?
No, they're still in the breakout room, but I can ask them to come back, Judge.
Don't worry about it.
Okay.
Small things, Jen put the judgments at the back for you.
Give me Rufus Watson versus DoorDash.
That's me, right to the podium here. All right.
2501347.
Good morning, Your Honor.
Good morning. Your name?
Rufus Watson.
Is anybody here for DoorDash?
No, Your Honor, I've not had anyone check in.
Do we have,
It was served by certified mail. I believe a copy of the signature card is attached to your packet.
looks like Uvalde or Uvalde. I'm not gonna swear you in yet. Just tell me what happened.
On March 18th this year, I received a deposit from DoorDash of $88.18. On March 21st of this year, there was a reversal of what my bank had sent the money back because they thought it was fraud, but it wasn't fraud. It was a mistake on my bank end. I reached out to DoorDash and let them know the hiccup that my bank had made and sent the money back to them. And all they keep telling me was, where we paid you on March 17th.
You work for DoorDash or something?
Yes, Your Honor.
So you worked for DoorDash, you were DoorDashing, they gave you money, and then somehow the bank reversed it?
Correct, Your Honor.
Have you called them?
I called the bank. When I called the bank said, and when I communicated with them, they said there was nothing that they could do about it because the money has left their account. I had to communicate with DoorDash. So I called DoorDash and they just say, we already paid you. They're not paying the money that they.
And that's for how much?
$88.18.
Why do you have 116.17 it looks like circled over here?
$12 for the.
I see, the court costs?
And then there's also the $4 for the ATM fee. Because court costs, court fees, all.
What was the $4 ATM fee? What do you mean $4 ATM fee?
I had to withdraw from the ATM that's in all the way out here.
Yeah, I can't really give you that. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole truth so help you God.
I affirm.
Okay. Why did you need to take the money out of the court ATM? I'm not sure. Is that to file the complaint?
Yes, I had to pay $12 and then I had to use the ATM machine because for the thing, so it was $16.
I can't give you that.
It was a total cost of $16.
I know, I just can't give you that. So the total amount that they owe you is $88.18. I can give you the 12. For your filing fee. So unless I'm missing something, this should come to $100.18. Is that right?
Yes. Correct.
It seems like this could have been handled. You called them and they just said, we're not paying you?
I have sent multiple emails. I have sent multiple chats. I have called them multiple times. They just keep saying, we already paid you.
Well, they didn't do anything. They didn't show up. They could have. At any rate, I'm going to go ahead and I'm going to give you the judgment. Default judgment. Defendant failed to appear. It seems strange that you're suing you deal with the San Francisco, California company as opposed to a local company here?
I do not understand your question.
Well, you're suing DoorDash in San Francisco, right?
Yes.
Isn't there like a local DoorDash regional office or something here or not?
It's an app that you download on your phone. So I had to look up their headquarters and send it out to them. There's no faces. know about no offices or anything.
In Michigan?
Not that I'm tracking, Your Honor.
Okay, all right, good enough. They didn't answer, so I'm not gonna question it. I'll give you that judgment. I filled it out. I wish you well. You can go down the hall. They'll give you a copy of the judgment. That judgment's entered by default. Thanks. Good luck.
Thank you, Your Honor.
Have a good day.
Where do I pick up the?
You can go right down to the civil department. He'll bring the file down and they'll give you a copy of the judgment.
Thank you.
Have a good day. Hey, you walked in here looking like a lawyer, and that's a good thing. Too many people come in looking like they're going to a ball game or something.
I appreciate that, Your Honor.
Have a good day.
Thank you.
All right. I don't need them out unless they're ready on that. I'm gonna call.
They are out, Judge.
All right, let me take you, Ms. Kingsley. First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Good morning, Ms. Kingsley.
Good morning, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
All right, where are the other two? Weird happens, you don't get the loan out, right?
Yeah, and now I mentioned this tablet
I got it.
and me losing you.
All right, give me Cornell and Plumbing, Edwards Plumbing. Do we have that file here?
Right to the podium there.
I need the file first, so wait 1 second. Virginia Swindle versus Tracy Linville. Nobody appeared on this. This was a show cause scheduled. Nobody appeared. I'm gonna go ahead and just reschedule the show cause, Jennifer. Ms. Swindle has a hard time getting here. So let's reschedule the show cause and give her another date. Put it out about 3 weeks. Will you do that for me, please?
No problem.
All right, now. Robin Cornell versus Edwards Plumbing and Heating Inc., 2404088.
Yeah, is part of this? Yeah. Right to the podium.
Well, she doesn't need to be, just the lawyers.
Is she good, Your Honor? Sit there.
Yeah. Mr. Gutner, your appearance?
Good morning, Your Honor. Patrick Gardner, P70106, appearing on behalf.
I'll tell you what, I'm gonna go on to another case here, okay?
Yeah, can we just pass this matter for just 1 moment?
Stay right with us, Mr. Rice, okay?
Okay. Yes, sir.
Virginia Ann Swindle versus Tracy Lynn Linville,
Right to the podium.
2402676. Your name?
Tracy Linville.
Boy, between you two, I feel like this case has been going on since I was a kid.
I know, right?
And that's not true, but I mean, it's been going on for a small claims case.
Yes.
So you didn't appear for creditor's exam on April 21. You can't miss these. That's a subpoena. That's an order of the court, ma'am.
I'm sorry. I missed so many
I
days
want you
from
to,
work.
I
that
know,
just started.
well, I get it, but you cannot miss court. I mean, I could hold you, listen to me, listen. When'd you get the job?
Just before court started. When did we start coming?
I know, but you can't ignore a subpoena. Are you kidding?
I didn't even know it was a subpoena. I'm sorry. Just court date.
And now she's not here.
She's never here.
Well, no, she's been here a lot more than you have lately. Where do you work at and what days?
I work at Novellis Lab.
What days?
I work midnights, weekdays, 7 or 5 days a week.
Well, tell me what you work, what hours?
I work midnights.
I know, but what hours? 11 to 7?
No, 11 or 12 to 8.
Okay, so why can't you get here? You're making it sound,
Well,
oh, wait a minute.
Sorry.
You're making it sound like you can't get here because you can't take off of work. Wait a minute. We don't conduct court at 1 o'clock in the morning or 3 o'clock in the morning. I just don't want to hear that.
I understand.
You cannot ignore subpoenas. I don't get this society of ours. We don't think court orders mean anything anymore. I'm rescheduling the show cause. I'll set it for later in the morning for you. Don't miss.
I appreciate that.
What time were you supposed to be here this morning?
I couldn't find my paperwork.
8:30.
8:30. If you walk in at 10:10.
I'm sorry.
I just want to know what everybody would think of me if I scheduled cases at 8:30 and showed up at 10:10. You know what they would think? I wouldn't blame them. I'm going to reschedule this show cause. I'm going to set it later in the morning. I expect you to be here. You better bring all your papers for the credit that you were supposed to bring for the creditor's exam. Do you understand? Jennifer, I want you to give her the subpoena, a copy of the subpoena.
Okay.
And you're gonna bring all those papers to the show cause with you, okay? We're gonna give you a date right now, so it doesn't get lost in the mail or the dog eat it or anything else, all right?
Sure. I
Give-
never got those full paper.
Jennifer, give me the date, please.
June 17th at 10 a.m.
June 17th at 10 a.m. I don't believe my packet has the subpoena. I trust you do.
Yes, I do, Your Honor. I'm
But she's
printing it
gonna
right
give
now.
it to you. And you have to bring tax returns. It's gonna spell it out. I expect you to bring everything, so you better get started on that, okay? June 17th. You got it?
Yes, thank you.
You're gonna go down the hall and get your date. Send it out to Ms. Swindle again. June 17th at 10 a.m. Good luck.
Thank you.
John and Aaron Purcell, is anybody here on that? Versus Gok and Sons Towing, 2404841.
Good morning, Your Honor.
Every day in the USA, people find themselves in court.
Resolvable generally. But nobody on the jury is going to be intoxicated. So frown on that sort of thing. So what are you going to do? Let me know?
Yeah, I'll let you know.
Okay. Zachariah Atterbury, Mr. Adams, Langston Adams, there's no answer. The attorney's not here. Zachariah Atterbury is called. No answer in the courtroom. I asked the bailiff to call into the hall for Zachariah Atterbury. Thank you. Do we have any pleas off this docket that we're aware of?
I've got two that I am pending on pleading, Judge.
Okay. Zachariah Atterbury, that's you?
Yes, sir.
Mr. Adams, have you talked to him?
No, sir, I have not heard from him.
You know, we're in trial. You're going to be in trial today.
Yes, sir.
That's the way you're dressed?
I have to tuck my shirt in, yes, sir.
Yeah, it's always nice to have a tie.
Yes, sir.
You want to borrow one
I
from
don't
me?
have one. Yes, sir, it'd be nice. I don't have one.
Well, why don't you have one?
I've never had a need for one.
Ever in your life as a male?
Yes, sir.
All right. That's all right.
Yes, sir.
All right. If we need to supply one, but you know, jury's going to be, the men are always dressed up in ties, so they kind of go, why this is important, what goes on in here. You're charged with aggravated assault with a deadly weapon. That's going to be a second-degree felony.
At the first degree, Your Honor, and we also filed a notice of enhancement on that as well.
So 15 to life?
Yes, Your Honor.
if you're found guilty, you're looking at a minimum of 15 years in prison and parole on this type of, with a deadly weapon, you can't get parole until you serve 1/2 of the sentence at least. What I'm saying is, do you understand and appreciate the magnitude and the importance of your life's destiny here with this case? You need to be wearing a tie. You need to dress up like your future is at stake, because it is. All right, all I can do is give advice. I mean, but you make the last decision finally. But I'd be dressing differently, and I wouldn't be looking like I'm going to a clam gig, like that. You just with your shirt out. I mean, that's sloppy. This is important. What goes on? Well, you have to act and dress like it is. There's Mr. Adams here. Yeah, between his shirt being out and no tie. I mean, he'll tell you that doesn't impress a jury, and they're the decider of your fate. Okay. You got to act like this is important if you don't really believe it is, but we all know it is.
Yes, sir. I mean, I have a job and everything else.
Yeah, well, you got to dress to the part. You just can't come in. Well,
I've never
to
been
dig for clams.
I've never been.
No, don't say that. You've got prior convictions, right? Don't say that you're foreign to this atmosphere. You've been in courts before. These are felonies. They're serious. You go to prison for a long time. And I always am amazed where just the lack of importance some people take to this. Well, y'all ready for trial?
Yes, Your Honor.
All right, but yeah, okay. It's going to be one of the. We're going to send it somewhere, if not here. Next is just have a seat. Sean Broussard, Mr. Burbank. There's no answer. I asked the bailiff to call in the hall for Sean Burbank. The RV with reset, and then Corey Hillman is 4. Okay. And where's Langston Adams? We were what's going to happen on Zachariah Otterbury? Do we know? That's Daniel?
No, sir.
Are they talking about it right now?
I see Mr. Atterbury. I don't see Mr. Adams, so I'm not sure.
Okay. Okay, we're in.
Does you have Mr. Rose still signing somebody?
Who is it? Who's David's case? What's David's case?
It's on the other docket, Judge.
Oh, it's one off this 9:30. Who is it? Centuria Guillory?
No, Centuria got set on both dockets just to make sure she was on a docket, I suppose.
Is it?
Centuria got set on both dockets just to make sure she was on a docket, I suppose.
Is it Cameron Martin?
She's done.
Is it Cameron Martin or William West? Thank you. Thanks. John, what are we doing on Robert Stroud?
Let me get front. I thought we were gonna play to make sure.
Okay.
And then on the trial docket, Your Honor, I'm number 4. Do I need to be back at 1:30 or just
be on safe side?
I'll be here, just be on safe side.
Yes, same.
That works. Works for me.
Bruce, what are we going to do on Kerry West, please?
That's just a motion asking the court to reinstate his file.
All right, where's Mr. West?
He's in custody.
All right, you need him right now? Let's bring him out.
Yes.
Kerry West. Here's.
The other stuff.
It's in order. There's West.
Okay, I think that's it. Anything else? John, what did you have?
Robert Stroud.
Okay.
I thought, no, but you already said MTRP on that? No?
You already did what?
Set it for an MTRP.
Oh, yeah, I mean, we can have a Gary on it, but I mean, I
Hold
don't,
on, can you give me the files?
I don't know where I do what we're doing.
That's what the note was.
Well, he wants to do it now.
Well, I don't think we have ever.
Who's on this one? Is it yours, Dan?
I think it's, is that Jimmy? Yeah, Mr. Hands.
When you said it for an MTRP already, but not for today.
The MTRP is just in one case, right? Or not?
Both.
Wait,
No.
no, I have, you gave me Robert Stroud and Robert Stroud. Right? Is that it? It's Robert Stroud.
Yes, they are both here.
When's the MTRP? 5/28. 24. It's a year old.
Next to the
Now, I'm gonna give you this to look for it. I'm gonna look in the other file. I don't. Oh, there it is. There it is. I have something filed a year ago, May 28th. Is that the only one? Where he failed or refused to participate in the SAFE program? Is that the violation?
Yes, sir.
That's the only violation?
All I know.
What do we, okay,
evaluated. Well.
well, let's. Who is it? Who's the?
Mr. Hand.
Can you ask him to come down on this one, please? Placed on probation on January. And then in May, refusing to participate in the SAFE program.
I think he has a medical issue going on with this diabetes. Like he had to leave real quick to Mr. Ham.
Oh, okay.
But if you have any questions, I mean, I can look up whatever. I just.
Well, I'm looking at the administrative hearing. Okay, he was placed on probation January of 24, ordered to go to SAFE, entered SAFE, began his treatment on March, and about 3 weeks later, he advised staff he did not wish to participate in the treatment anymore. He signed 2 refusals to participate. And he repeated his desire to return home and advised the committee he's refusing to be treated. They recommended a program removal. And then he was released from the program. And that was on May 8th, a year ago. And so an MTRP was filed on May 29th a year ago. And then I guess what's probation?
Yeah, because he, participated in the program.
Okay, I understand okay, he was released a year ago. What has he been doing for a year? Did he show up?
No, you saw him get a competency, get a value of competency, and then he went to get competent.
Okay, that was.
He just got back recently, sir.
He just got back. Okay.
Yes.
And he was declared competent.
Yes. Yes.
So. But he has been kind of on a year without any supervision or anything like that.
He's been gone, sir. The last time we saw him in court.
Yeah, I understand, but he's been without supervision.
Yes, sir.
For whatever reason.
Yes, sir.
His own. But. So. Have you talked to him at all?
No, sir. Matter of fact, I've been checking on him. He went from here to Pulaski to Livingston. And I looked up, he was here. Then when he was here, he was coming to court.
John, you've talked to him?
Yes, sir. So,
what's he say about the safety?
He doesn't want to go.
He's not going to go.
He
Oh,
doesn't
okay,
wanna go.
well, that's going to make it
Yeah.
kind of cut and dry.
Yeah, that's why we're having a hearing, because I thought if he wanted to go, then we could just do it. But he said, no, he doesn't want to go.
Okay. When do we?
I can set it for a hearing in a few weeks.
I don't know. I want him immediately. No,
Whatever,
this to tomorrow, if possible. Let's do it before the trial.
I think I gotta be here in the morning.
We'll bring him back, bring him back.
Right,
But I mean, I don't want him
think
in there. He needs to. We need to move on. If he's flat making a decision, holding him in custody in the jail is just burning daylight for everybody else. I mean, the decision seems to have been made. Unless we just got to put it on the record.
yes, sir. Ma'am, what time in the morning? I have a bone and joint appointment at 1:45.
9 a.m.
Okay, thank you. Just want to make sure.
It ain't gonna be that long.
Okay, because we're gonna be in trial,
Yes, ma'am.
so we'll do it before we
See, I'll
start.
tell Jerry to come back at 9:30 in the morning and then I can do some things before.
Okay,
That'll be real quick.
okay, thank you.
All right, that's on Robert Stroud, 2 cases. All right, maybe he'll change his mind. You never know. Okay,
Does he have any other holds, John, that you know?
Not that I know of.
David, what do you?
Finished.
You're finished. Okay.
I'm back at 4.
All right, because we had Centeri Guillory, we disposed of. Cameron Martin, we disposed of. William Weston.
There's a motion.
Okay.
Brandon. Yes.
We have a motion to revoke pending on this?
Yes, we do, and that's set at a later date.
When?
I think it's the 28th.
Next week?
Yes.
Because,
Yeah,
yeah,
see,
that's
this
been
motion was
languishing.
supposed
That thing's been languishing since October.
Yeah.
That's too long for a
That's right.
TRP.
Yeah. It's set for the 28th. Yeah.
All right.
The reason, we were supposed to be heard last week, except getting the client here and,
First of all, you're Kerry West.
Yes, sir.
Junior, here with your attorney, Mr. Smith, and the state's attorney. This is cause number 23 CR 1038. And you are currently, you have disposed of your case. This is a 3rd-degree felony of evading arrest or detention with a motor vehicle. You were placed on 10 years deferred or unadjudicated probation back last year on, 23, September 26th of 2023. So this September, you will be on probation for 2 years. And this motion for revocation of probation states that you committed the offense of unlawfully carrying a weapon in October of 2024, illegal possession of a dangerous drug on October 6th of 2024, at a location other than your residence at 4:40 a.m. on October 6th. You missed your curfew. You illegally possessed drugs on or about February 14th of 2025, marijuana. And you used or possessed drugs on or about February 28th when your drug patch showed the presence of cocaine on or about April 7th of 2025. So these are 5 grounds of violations that are alleged. Only take 1 to revoke your probation if proven by a preponderance of the evidence or greater. What is this motion all about?
Your Honor, on April the 17th, we were here. This is a drug patch issue. I've had this problem in drug court on several occasions. The defense community is contending and trying to inform the courts that the drug patches analysis are not accurate. On 2 occasions in drug court, the drug patch showed that my client had, on other cases, had tested positive, and I immediately got a hair follicle, which went back 90 days and shows that it was negative. Well, that's exactly what happened here. So on April the 17th, the drug patches showed that he had tested positive. So you raised his bond, I believe, to $250,000. That day or the day after, which I sent somebody down to do a hair follicle. It was sent. The hair analysis came back negative, which went back 90 days, which proved that the drug patches, again, were not accurate. That lab is attached to the motion to reinstate the bond. So we're just asking the court to reinstate his bond so he can be out. And that's what we're here for. That's it.
Still something about being a good person to take it. Okay, no big deal.
What did the court do when this new first amended motion came out on 4/16, which alleges, among other things, the drug patch showed the presence of cocaine, which doesn't have anything to do with a hair follicle, and then also the drug patch on February 14th, 2 weeks before the February 28th, 25 drug patch showing.
We were here on April.
Hold on, let me finish for the record. That showed while I had placed him, I had given him the bond for the first motion to revoke probation. Thereafter, while on 1785 and 1787 charged with assault on a public servant in each of these 2 cases. What do you want to do on this?
I'm going to file a motion to have him examined, to ask the court to have him examined.
Competency?
By competency.
All right, then those will be reset for that reason. I now call 24 CR 2394 and 2395, the state of Texas versus Cameron Jesus Martin. You are Mr. Martin?
Yes. Yes,
I'm sorry. Yeah, Mr. Martin, and you are here with Mr. Grove, your attorney and the state's attorney. What are we going to do here today, David?
We have a plea in the burglary of a habitation case.
2394.
Yes, sir. And the other case, an aggravated assault case, will be dismissed.
Okay, I'm going to put that on the side. I have a first thing I'm looking at is an analysis from Edward Crepon. I think,
yes, sir.
Mr. Grove, in an abundance of caution, filed a motion for competency evaluation, and have the parties had an opportunity to see the manifested result from the report signed April 22nd, 2025 by Dr. Ed Crepon, licensed psychiatrist.
Yes, sir. Yes, sir.
All right. And any objection? That one being introduced for the purposes of evidence for this issue of competency?
No, Your Honor.
Without objection, then it is made a part of the record. And in summary, it states that and declares that the defendant is competent to proceed to a resolution of his legal issues at this time. Any contrary information by either party?
No, Your Honor.
No, Your Honor.
Then it is made a part of the record and it will be part of the, it will be sealed and placed in the file. Wait, Mr. Martin sent a letter to this court. I don't have a file stamp, but it was dated April 30th of 2025. Has anybody seen that?
I believe I have.
Okay.
Your Honor.
Anyway.
He said it last year, and this was during the time when he was incarcerated and before Dr. Rapon.
No, he didn't. He sent, this says 4/30/25, David.
Oh,
That's
I'm sorry.
last month.
That might have been my most recent one I sent,
Yeah, this is last month. He talks about a previous letter that he had sent in. Oh, I have it in the file, but it was a previous letter, but nonetheless, the letter, this recent letter, it purports to not be the ravings of a madman, but he writes lucid and intelligently here about his situation and contrasts his current mental stability with his previous, what he would call probably sounding like the ramblings of a madman. But it does fit within the analysis of Dr. Rapon, who determines that the defendant does have the diagnosis of a schizophrenic disorder, but yeah, it could be in the early stages of developing schizophrenia, but does not meet the criteria for the diagnosis at this time, which doesn't mean that he doesn't have some of the elements toward that, but he does not fit a mental illness nor defect that would require inpatient psychiatric treatment, and he is able to understand the legal proceedings, his charges, and is able to communicate with his attorney with a reasonable degree of rational thought and understanding. So all of that fits. He is competent, and we're going to move forward. So does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about November 11th, 2024 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you were charged with, sir?
Yes, sir, Your Honor.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir, Your Honor.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Another case 24 CR 23. What is that number? That other case?
The dismissal is 2395, Your Honor.
Will be dismissed. Is that your understanding of the agreement?
Yes, sir, Your Honor.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir, Your Honor.
Both cases. How do you plead to this one? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will
Yes, sir,
because
Your
you are guilty. Yes. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes, sir, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 made a part of the record for all purposes without objection.
With no objection, Your Honor.
It is made a part of the record. Pre-sentence report is waived.
Yes, Your Honor.
I'm going to follow this agreement, sir. With nothing further, I'm going to find you have pleaded guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on deferred or unadjudicated probation for 10 years. You do well, it can be shortened to 1/3 of that.
Thank you.
3 1/3. There will be terms and conditions of probation, which are normal and customary here. Which include the theft class, but we need something for the issue of the determination of for mental illness. I want him on the what kind of caseload do we have that just keeps an eye on it to make sure that he stays stable and that your medicines or whatever it is that you're taking are taken regularly to keep you, because obviously something's got you in the right track.
Yes.
And you feel comfortable with the medication that you're taking?
Yes, Your Honor.
Okay, let's keep him on that. I think we need to do that, monitoring him through the probation office.
Yes, sir.
Okay, that will be added, and that's to help you so that you can complete this satisfactorily and successfully. Okay. What are you going to do now? Because you're going to get released here. Where are you going to go? What are you going to do?
I'm probably going to get a ride home with my grandfather, and then I'm probably going to go to the probation office. And we'll have our first.
Were you going to? Do you have employment opportunities?
I was planning on going to workforce first, and then trying to find a career path, or a stable job, and then apply for other jobs as well.
Good. Well, best wishes to you. Good luck on this. Okay.
All right. Thank you. Your Honor.
Be successful. Yes, sir. I think you're certainly capable of it, but you gotta do the batting.
Yeah.
Okay. Thank you. Good luck. All right.
Thank you, Your Honor.
Yes, sir. Bye-bye. All right. Now, did he have a second case?
We committed his main.
Okay. That's going to get dismissed here.
Yes, sir.
Let me find this. I've got 24 CR 2395, Cameron Martin. That is to be dismissed.
I got it.
It's done. Okay, I think that's it. Anything else? John, what did you have?
Robert Stroud.
Okay.
I would know, but you already said MTRP on that?
USA, people find themselves in court.
Okay. Good morning, Mr. Gopal. I'm going to put you and Mr. Mathis in a breakout room 2.
Thank you, Your Honor.
Okay, Dakota, good morning.
Hello, good morning.
Okay, first, you're Dakota Daniels, correct?
Yes, ma'am.
Okay, all right. And well, thank you for removing your hood since you're in court.
Yeah, I took my hoodie off.
I'm sorry, what's that? Mr. Daniels?
Did you take my hoodie off?
You know, I see, thank you for removing your hood, but we're having some connection issues, sir. So if you can't get a good connection, you're gonna have to come in person, please.
My much is tweaking right now. Can you hear me now?
I'm sorry, what was that?
Can you hear me now?
You're still a little bit broken up, so I'm not sure if, you're outside, can you go inside?
Yeah. Yeah, your phone.
What's that?
Yeah, I'm an hour away from home, so that's why my connection's bad. I'm trying to get it fixed right now.
Why are you an hour away from home, sir?
I'm sorry, what was that?
Why is it that you're an hour away from home?
Oh, I went to work today.
Okay. Well, wherever you're at currently seems to work. But okay, just stay right where you're at there, okay? And don't move.
Okay.
All right, thank you. In just a few minutes, I'm gonna put you in the breakout room with Mr. Gopal, okay?
Okay, thank you.
Because that is where your connection is pretty good, okay. All right, and so, good, the iPhone that just joined, can you please unmute, sir, and tell me your name?
Theodore Marshall. That's one of mine, Your Honor.
Daryl.
Theodore. T-H.
Theodore, okay, that's why I was getting confused, because I thought I heard, I heard Daryl. We don't have a Daryl, not today. Okay. All right, so Mr. Katz, I'll put you and Mr. Marshall in breakout room 3.
Thank you.
Okay. Okay. Okay, Mr. Obama, I'll hand you your matter in just one moment.
Okay, all right. No, I'm sure you haven't shown him.
Okay, let's see here. Okay, so. Okay, good morning, Mr. Gopal.
Good morning, Your Honor.
Okay. So we are on the record in the matter of the State of Michigan versus Nicholas Mathis, 25284. And counsel, your appearance, please.
Your Honor, for the record, John Gopal, P 30758, on behalf of Mr. Mathis. Mr. Mathis, would you please put your name on the record?
Nicholas Mathis.
Okay, thank you. And so today is the date scheduled for sentencing on your client's plea to assault and battery and domestic violence. CSC 4th was dismissed as a result of the resolution reached between counsel and Counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we have, Your Honor. No additions, deletions, or corrections to be made. I have discussed this with Mr. Mathis. He does understand what we've reviewed. He also understands, and I would like to place on the record, there was a mention of some sort of a VOP, but I believe, to speak, it doesn't exist because he was incarcerated on the last date that was supposedly set for sentencing on another matter, so on a co-matter. Anyway, I just
I don't
wanted to-
show anything for a probation violation.
I don't either, but I was told that when I first
But he's not on probation, so how
No,
would
he's
it be a
not.
probation violation?
thought maybe it might have been something else, so just wanted to make sure. Your Honor.
No, there's not even anything in here regarding a bond violation. It does show he's watching out Allen Park.
And he's aware of those, Your Honor. As I've indicated, Your Honor, he is incarcerated this time. That's on a felony. He's been in jail now for 90 days. He is, at this time, Your Honor, I've indicated, we've reviewed the pre-sentence report. There are no additions, deletions, or corrections to be made, and we'd ask that that recommendation be adopted. He is not eligible for early termination. However, he is eligible for 769.4A as to count 3 only. And so we're asking the recommendation be adopted.
Right, I believe that your client is in custody on the felony matter pending out of this court.
That is correct, Your Honor.
That is for fleeing and eluding third degree, and there is a jury trial scheduled in Third Circuit Court in July, correct?
No, but yes and no. That's why, well, yes, that's why he's in jail. No, there is not a jury trial.
Did it get resolved?
It has been resolved. He informed me that he is scheduled for sentencing on that charge. What day is sentencing?
June 13th.
June 13th. And who's the judge?
Kiefer Cox.
Okay.
Okay, and so what was it that you pled guilty to then, sir?
That is correct, Your Honor.
Okay, so what did you plead guilty to? Did you plead guilty as charged or to an amended charge?
I pled guilty to fleeing. It said I dismissed a vehicle code adult advisory. That's what the paperwork says.
Okay. Okay, all right, well, so was there a COBS done, counsel?
It's my understanding, he's told me, and of course I wasn't privy to it, that it was for 2 years probation, and obviously attendant matters. I believe, Your Honor, clearly that the recommendation here for the, for the 24 months is more than adequate. I think this is an excellent recommendation under these circumstances.
I would agree.
I agree. I agree with that, Your Honor, 100%. And I've warned him, to be quite honest with you, that if he were to violate probation in any way, shape, or form, he'd be going to jail for a long time.
That is accurate. Sir, one violation, no matter how minimal you may think it is, one violation will erase all of your abilities to have count 3 dismissed. And there would be max incarceration, which would be at a minimum, let me just see what the client was charged under, 93 days at a minimum.
What's that you do?
All right, so anything else, Mr. Mathis, that you'd like to offer before the court imposes sentence?
No, Your Honor.
Okay. The court will note after hearing from counsel, hearing from Mr. Mathis slightly, reviewing the report, the recommendation, the circumstances surrounding this matter. Cheyenne Schultz and Mason Putnam, do they happen to be out in the lobby, Bobby? Okay. Not being present.
Yes.
If it is not in your matter, you need to stay muted. The court does find that there is reasonable grounds to depart MCL 769.5. The court will also note that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of these matters, as well as taking into account the circumstances surrounding Mr. Mathis and the legislative guidelines. Because if I recall correctly, isn't Cheyenne your client's daughter?
No, Your Honor, she was his, she was the mother of his child. There's been a breakup.
And Mr. Putnam was
Right.
Cheyenne's.
That's correct, Your Honor.
Okay.
And the allegations here, that came to the CSC
Yes.
were.
An unwanted touching of the.
That's correct.
Yes.
Of her, and that unwanted touching was also domestic violence.
Correct.
And that's why we resolved it. And Mr. Putnam came to her rescue, so I use that word. It wasn't a violent beating, but.
I understand.
And he was then.
I got these facts confused with a different matter that, it was the defendant's child, but this is not Mr. Mathis.
No.
All right. The court's going to order the following: 24 months probation. You're not eligible for early discharge. The court will note as to count 3 only, you are eligible under 769.4A. You're not to violate any criminal law of any unit of government. You are not to leave the state without the consent of the court. You are to report truthfully to your probation officer as the office of probation officer may require, in person, writing, or virtually. You notify your probation officer immediately of any change in address or employment status. You're not using alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in intensive outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms so that you can maintain sobriety and hopefully prevent relapse and reoffending. The court's going to also order you to participate in fan meetings once per month. The rehabilitative goal for that condition serves so that you can have additional sobriety support as well as receiving recovery resources. You're not to have any contact. Well, how old is your child?
2.5 years old, Your Honor.
Is there a parenting time order or custody order from the Third Circuit Court?
No, Your Honor.
Okay. So here's what the court's going to do. The court's going to order no contact with Cheyenne Schultz and Mason Putnam. The court's going to indicate, with the exception of third-party contact, to arrange any parenting time pickup and drop-offs.
Thank you, Your Honor.
If that's what happens, I'm not ordering that happens. The rehabilitative goal is to maintain the safety of the victims. The court's going to order not to return to, counsel, if you have to have a conversation with your client, please step out in the lobby.
We're done, Your Honor. I apologize.
You're not to return to the home on 15th Street. If there's any sort of parenting time exchange, it can be done in a third-party location.
Yes,
The
Your Honor.
reason for that condition is to maintain the safety of the victims in this matter. The court's going to order no weapons or firearms, which I don't believe. I don't think I've ever seen somebody hide a dismissal, but in any event. The court's going to also order domestic violence 26-week course. The rehabilitative goal for that condition is to further increase your understanding of how to take responsibility for your own actions and to educate you about how to change your behavior to manage your emotions and potentially abusive situations so that you may understand how to adequately resolve issues or leave before it rises to the level of this type of offense. The court's going to order you to obtain your GED or high school diploma. The rehabilitative goal for that condition is so that you can learn skills to increase your likelihood of employment and expand your knowledge. The court's going to also order $0 in restitution. There was not any requested. And the court's going to order mandatory maximum incarceration and revocation of probation for any probation violations or any. So for your random testing, sir, if you end up testing the DNA, and if you don't time it correctly, and you wait till the last moment and a train is stopped and you can't make it to your testing, that's a violation. Any violation, sir. Any questions regarding the conditions?
No, Your Honor. It's all understood.
Your Honor. Oh, I'm sorry. The court's going to also order that you are to obtain full-time employment. The rehabilitative goal for that condition, I think, is obvious, but that way you can have financial stability as well as be able to support your minor child.
Yes, Your Honor.
Now, and before we go to cost of fines, Your Honor, you do understand that marijuana is a prescription drug.
Yes.
And you don't have a medical marijuana card, do you?
Not currently, no.
Okay.
Does that mean I'm not able to obtain one?
Pardon?
Does that mean that I'm not able to obtain one, or if I obtain one, I'm allowed to, or?
Let me clarify. I'll clarify.
Thank you very much, Your Honor.
Sir,
I wanted to bring that up right away.
let me be very, very, very clear with you. If you are using marijuana for medical purposes, then you are to make sure you have something from your treating physician, somebody that you have a medical relationship with, somebody that you're going to have continued follow-up appointments with, somebody that knows your medical history. That doctor then needs to submit something to the court. You don't have to actually go through the steps of getting your card, but that doctor has to submit something to this court indicating that that is the preferred course of treatment for whatever the medical issue is that you are indicating, or that the doctor's indicating.
Understood, Your Honor.
You just walk into a medical marijuana clinic, talk to a doctor for about 22 seconds, and then get your prescription. That's not sufficient.
So if I were to go to the doctor that I previously had it through, that would count?
Was it a treating physician, somebody that treated your mental health issues and such?
No, not currently, no.
Okay.
So that's what the court is explaining.
Counsel, just one moment.
Yeah, I understand.
So was that a doctor that you saw regularly, sir?
No.
No. Okay. So then that probably wouldn't count.
Okay, I understand, Your Honor. Thank you.
All right, because if you are using this for medical purposes, if you need it for medical reasons, just like insulin, high blood pressure, high cholesterol, anything of that nature, sir, you have to go and meet with your doctor on a regular basis to confirm that the medicine is working. So that is what this court requires, which is in its judicial discretion.
I understand, Your Honor. Thank you.
You're welcome. Okay, as to fines and costs, as to count 2, the court is going to order a $400 fine, $100 screening assessment fee, supervision oversight fee of $1,200. It's $50 a month at 24 months. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. $2,125 for count 2. As to count 3, $500 fine. The court's not going to order a screening fee or an oversight fee because it's in the same, it's already been assessed on count 2. $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $825. And the total between both matters is $3,000, $3,050. Nope, $2,950. So, sir, what I'm going to do is I'm going to indicate that you are to set up your payment plan through probation upon employment. I'm also going to add one more condition, and that is that you are to submit proof of providing 30 job applications per week. That way, that will assist you in helping in your diligent search for employment. Now, sir, if you're going to be sentenced to probation on your felony matter, please keep in mind that you're going to have 2 different probation officers, 2 sets of requirements. So what's not going to be accepted is, oh, my other probation officer said I didn't have to do this. That's fine and dandy for that 3rd Circuit Court probation officer, not for the 27th District Court probation officer. Got it?
Understood, Your Honor.
Okay. So what I'm going to indicate, sir, is that right now, it doesn't serve any purpose for you to meet with probation for your instructions because you're still incarcerated on your other matter in 3rd Circuit Court. So what I'm going to indicate is that you are to contact probation (27th District Court probation) upon release. I'll say within 24 business hours upon release from Wayne County Jail. Okay?
And Mr. Mathis, if you end up getting a tether on your other matter, then that includes being released from the Wayne County Jail. So if you get out, don't wait till after your other court date. Do you understand that?
Yeah, I understand. So just call the courthouse any type of way and figure it out, or is there gonna be a specific number I'm given?
If
you're going to have to come in person, sir, so that you can get set up with your instructions and all your information.
Come in person? Okay.
Yes.
I understand, John. Thank you.
In other words, I just want.
Or you can email in, sir. You can email into the probation department, and they can then set up an instruction. Okay?
Thank you, Your Honor.
Okay. Good luck to you, sir.
Good luck, Mr. Mathis.
Thank you. And then all right, let's go off the record for a moment. Mr. Holmes, were you able to speak to Mr. Doherty and Ms. Rakowski? You're muted, sir.
John needs to go into a breakout.
You're still in the breakout room, so I'll just put Mr.
Thank you.
Daniels in there. Mr. Daniels, make sure you unmute, please, and join breakout room 2.
Okay, I'm sorry, Your Honor, you wanted me to go into?
We're going on the record in the matter of the City of Wyandotte versus Robert Allen, 241508 A. Good morning.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually 2.
Okay, just a moment. Mr. Allen, your name for the record, please.
Robert James Allen.
Okay, so today's date scheduled for sentencing in this matter. This was adjourned from April 28th. And, counsel?
Yes, well, just so the court's aware, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. Is without breaking attorney-client privilege. He doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice. If he so chooses, all the witnesses are police witnesses and all the evidence is captured on body cam and video. So I don't think the prosecution will be prejudiced. The second motion.
Well, hold on, before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done in writing, so that the prosecutor has an opportunity to respond.
Understood.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file the motion. I don't know if they want to file against their hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about?
Well,
did it come about this morning?
We have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained in a candor with the tribunal. I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen instead of back to the third party?
To the third party, but basically if they wanted to help him again, I can't in good conscience or refund all of the retainer. I've been down here several times and put quite a bit into this matter so far. So I will be refunding $1,000 to that individual.
Okay, so my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that there was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know, you didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts were aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it, but it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier. That's when it basically clicked that this is something that I need to bring forth and make these requests.
Okay. Mr. Allen, you have been to court a number of times with Mr. Iwata, correct?
Yes.
And you've had opportunity to speak to Mr. Iwata on a number of occasions, correct?
Yes.
And you also have had the opportunity to review discovery with Mr. Iwata, is that correct?
Yes.
Okay, and Mr. Iwata has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
Yes.
All that is correct, right?
Yes.
Okay, and so now here we are at the date of sentencing, and you want to have a different attorney, and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking you were gonna sentence me accordingly to what the first offense misdemeanor is for.
Okay, so
You're
what is
trying
that,
to put me
sir?
on
So,
probation and
hold
that's
on.
not even part of the punishment.
Pause just 1 moment. What is it that you believe is the punishment for a first offense misdemeanor?
MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 30 to 90 day license suspension, and up to 4 points on your license. I already got the 4 points, I already got the 90 day maximum suspension. I know you're gonna charge me the $300 maximum fine. I feel like that's more than enough punishment for a first time misdemeanor offense. I've never been arrested for anything alcohol related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. Not the probation department lady already lied on me, put stuff on my record I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is, it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence. And those
Probation ain't part of the
Stop
punishment
interrupting
though.
the record, Mr. Allen.
So I want to pull my plea because
Stop interrupting the record. Your attorney is speaking right now. Just 1 moment.
And I do not recall telling him that yes, probation could be part of the court's sentence or that no, probation wouldn't be part of the sentence. I just assumed that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
So
it's not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship and I can no longer in good faith continue this representation, Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen.
Yes, ma'am.
So you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law and it was my understanding that my past record would not be brought up against me. But here I am. And everything on my record is.
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law. So what does that mean to you?
The lady the representative told me that we went over my record. The CCW on my record, the false report of a misdemeanor, the attempt to receive and concealing, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So therefore, the probation
lady. Which convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The CCW conviction from 1997, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You ain't even supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for the attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so everything else, so there should be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record then.
You have a number of criminal convictions, more than just what you spoke of. And the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law.
Yeah.
Sir, the court is looking at some of these, and if you're
trying to prosecute me for my past, say it.
Sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions, sir, to be removed from your record, then you have to follow the steps that have to occur, right? There's motions to set aside, there's the application to set aside convictions and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something though? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself.
Okay,
As a
well,
Wayne
sir,
County resident, that's what I was told.
Detroit resident or
A
Wayne County?
Detroit resident, I'm sorry, as a
Okay.
Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, well, I have to tell you, that's the first I've heard of that. I haven't heard that anything is resident
Well, you
specific.
probably haven't had to go down there and talk to somebody that had your record expunged either.
Sir,
Ma'am,
I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
ignorance ain't an excuse for not knowing the law.
You're correct,
Ain't that what
sir.
you tell me? That's what you would tell me?
Don't presume what I would tell somebody or you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay? Probation is something that the court would order in lieu. Sir,
Excuse me.
those gestures are not necessary. The gesture of money, money, money,
That's what you
not
want, right?
necessary. No. Probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay, well, I would suggest you review it, because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So,
With all due respect, I apologize, Your Honor. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor offense. That's all I'm saying.
okay, and
If
sir,
you
you
want
have the right to
punishments or
have, sir, you have the right to have that opinion.
I
You
just
absolutely have the right to that
I just wanted
opinion.
to say that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure. That's
And
all.
why is that?
Because first of all, I'm on SSI, my $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended
Let's
for
clarify, you're
90
not giving
days.
it to me, sir. Let's clarify, you're not giving me money.
But I'm saying I don't have any money to give anybody, is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
Okay, sir, I can understand and appreciate all
I
of
feel
that.
like
But let me just clarify.
This is my first time.
Let me clarify,
I
sir.
feel like this is more punishment.
This court does not suspend your license. The Secretary of State did that.
I understand it, but it's still a punishment, a part of the law of the punishment. And I've gone through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you?
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother.
Okay, so where does your daughter live?
In Woodhaven.
Okay, and you reside?
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
Okay, what a bicycle? What about a bicycle? What about somebody
I'm
else?
disabled. I'm gonna ride a bike from Detroit to Woodhaven.
Sir?
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is the first time misdemeanor offense. It should be a fine and my license suspended and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is the first time misdemeanor offense. I feel like you're being way too harsh on me.
Sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom and watched you sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay.
This guy just got all this for all these probations and 2 years probation, and he did assault and all this, and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
Sir, first of all,
how could they even recommend that, bro?
Your conviction is eligible for early discharge. So if you wanted to start comparing the
It's
cases,
not eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
It's a simple misdemeanor charge, man.
That's your opinion, sir. That's fine.
Blown out of proportion. That's all I'm saying.
Well, sir,
If I come back 2 or 3 times.
you also have the
drinking-
option of after you consume the beers to have somebody else drive you home, then you wouldn't be here.
You're right. And I really want to go to trial because making me blow 13 breath flies and charging me with something that with only one, you know, I was falsely arrested anyways. I was falsely arrested. The officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly
Okay,
conduct.
stop, you're done. I'm gonna.
I want to withdraw my plea and go to trial.
Sir, stop talking, please. Stop talking. The court's going to grant Mr. Arlotta's motion to withdraw. Based on the breakdown of the attorney-client relationship as far as the direction of resolution, it appears that there's a clear difference of opinion. Mr. Allen, are you intending to retain
Oh, yes,
other counsel?
yes, I'm gonna hire another lawyer. Somebody that's gonna fight for me. I took this plea to be cool, you know? I wanted to go to trial the whole time. I took
Sir,
this plea
you don't need to
under
keep
my
talking.
lawyers.
Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when you have when whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There's not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity it has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial? I'm just gonna be able to hire another lawyer for sentencing? Or am I gonna be able to?
Sir, do you listen to what's being said, or are you just wanting to say what you gotta say?
I'm listening to you,
What
I'm
else?
asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing, because that's what's currently procedurally scheduled.
I
There is
understand that
not,
part.
there has not been a written motion received by this court yet. So once there's a written motion, it will be set for a motion date. But as of now, this court's not just going to set it for a motion date, because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor, I just wanted clarification, I'm sorry, I apologize.
You will adjourn sentencing to be June 18th. At 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a day that's a wind-down day. So then that will be a motion hearing date. Now, sir, I'm sure Mr. Arada is going to tell you that there's procedure for motions. Notice has to be given so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
And when did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay, and so did your treating physician give you any documentation to?
My primary caregiver, she retired, Your Honor, so.
No, sir. I'm
Yes, she
asking your
did.
primary caregiver.
I mean, not primary caregiver, I mean, my primary care physician, my primary doctor that I used to go see.
Okay.
Wendy McKay, she retired, so I don't have no way of like going in and talking to her anymore or nothing, so.
Okay, when did
I would
she
have to
retire?
get a new, a couple years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they sent me, the new doctor that they assigned me was way out on 14 Mile and something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what the requirements
I
were.
told you a doctor, you can't go into your doctor and say, hey, doctor, can you write me a letter saying you feel like I need to be on weed? Doctors don't do that. You
That's
can't do
incorrect.
that.
That's incorrect, sir.
I don't know what doctor you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before
I
for
told you
that,
what the.
and that's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're gonna have to hold a hearing on your card and whether or not that doctor's going to come in to see how long
Let's
that
just
doctor's
handle
been
this
treating
first,
you.
okay?
I'm sorry?
Let's get the, let me hire the new lawyer, let's go get this, because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my bond. What are you
Sir?
talking about?
Sir, you're using marijuana. That's in violation of your bond conditions right now.
You told
And
me I
once,
can't
and once you've been under the
I know.
jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what I'm
Sir, if
talking
you have
about.
medical reasons, then you would have a doctor that you are treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then we'll have a bond violation. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
And we are on the record of the city of Wyandotte versus Vincent Coletti, 2514C.
Good morning, Your Honor. John McNally on behalf of the defendant Vincent Cioletti. The date, time set for sentence in this matter. We've had an opportunity to review the pre-sentence investigation report. Mr. Cioletti indicates to me that it's factually accurate, no corrections, additions, nor deletions.
Matter, just one moment, I just have,
Mr. McNally, is your brother in today? Oh, Judge, that's fine. I enjoy the show.
oh, okay, all right, I just have a couple.
I have cable phone,
to go here. Okay, and so Mr. Katz, we're going to go on the record in the matter of Green Trees Apartments versus Theodore Marshall, 2500723. And
good morning. Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
I'm sorry, I didn't hear that.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Okay, and so, Mr. Marshall, your name for the record, please.
Theodore Marshall.
And so, counsel, today is the date scheduled for the first hearing. And has there been a resolution?
Yes, Your Honor, we do have a proposed consent judgment. This is a non-payment of rent possession case. There's currently a balance due, including costs totaling $1,782.1782. Mr. Marshall has until June the 6th to pay that amount. He was advised of MCR 4.201 and did authorize me to submit it to the court with his verbal authority. No. Excuse me, Judge, Your Honor.
Yes.
He was being very disrespectful. I couldn't explain the situation to him. He was just being very rude. So I wanted to talk to you.
Okay, well, what's the situation, sir?
I even got an email. I got proof of an email. She said that the only reason she wants me to go to court is because I didn't pay the $200 court fee. I didn't pay a $200 court fee because I didn't have a court date. So I was waiting on a court date. So she said that she was making, so now I got to pay the full balance because I didn't pay that $200 for the month of May, I believe. April.
All right, sir, was there a time that rent wasn't paid and then there was a court date that was scheduled?
Could you repeat that?
Was there a time that your rent had been delayed and not paid and then there was a court date scheduled?
No, it was not a court date scheduled. She had a court fee for me to pay, but I didn't have a court date.
Okay, let me clarify. Maybe not scheduled, but there had been pleadings filed in the court for your eviction, correct?
Can you repeat that again? I'm having a hard time here.
Okay, hold on. Can you get the books back for the microphone, please? We had books on here, so we can elevate the microphone from in the back. No, Scott. And that can be, we can get a book and we can elevate the microphone onto a book from in you guys can come back to the library. So, Mr. Marshall.
Yes.
Was there a time that you were late on your payment of rent?
Yes.
Okay, and so then there was, the attorney ended up becoming involved in the matter and filed an action in court. Is that correct?
I just got a notice like a couple days ago. The first notice I got a couple days ago.
Was there an action filed in court?
Yes.
Okay, and then you made your rent payment, correct?
Yes.
Okay, so just because you didn't have a court date before you paid your rent, there was still the expense of the attorney in filing the action in court.
So I don't understand why I'm gonna pay a $200 fee for if I'm not going to court.
Well, sir, because you were late, and so because you were late, the landlord then retained the services of their attorney to file an action because you were not in compliance with the lease terms and you haven't made your payment.
Okay, so what about the late fee? So I gotta pay the late fee and the court fee, and I pay it all, and I don't get a court date. That's what she wanted me to do.
Sir, when is your rent due?
On the first.
Okay, and so when did you pay your rent?
I paid $900. I didn't pay the rest because it was a $200 late fee on it, and I didn't want her to just be charging me for anything. I already have a late fee on it. It was a court fee and a late fee.
That wasn't my question, sir. That wasn't my question. I asked, when did you pay your rent? When did you pay it?
Last month, I have the exact date.
Well, sir, this was filed on April 16th, and as of April 16th, you hadn't paid it. And so how much is the late fee per month, sir?
$100.
Okay, and so $1,049 is the rent for each month, sir?
It's about 1,100, and it's including water and all of that, so it's a little more than that.
Okay, so what is your monthly rent?
I believe 1,149.
Okay, so $1,149 is your monthly rent. And as of April 16th, it shows that $1,425 is due. Mr. Katz, what were those charges?
So, Your Honor, that was his rent, remaining balance of rent, as of the court date. As of the filing date, plus I think filing fees. And I believe he had indicated that he made a $900 payment in April, which reduced out his balance to somewhere around $500. It's not that he paid off his full account balance by the end of the month. He only paid $900. So there was still charges that were remaining on his account even at the end of April. And it was not just the filing fees, but it was some additional charges, which he might have paid in May, but there was a case filed well before he made any payments.
Okay, counsel, I appreciate that, but that wasn't my question. April 16th, you filed this complaint for not payment of rent.
Correct.
Shows $1,425 was due. Their rent was paid through March 31st. $1,425 was due. If rent is $149 and a late fee is $100, that brings it to $1,249. Then there's an additional $200. Then there's an additional $200 and I don't know, $40, $30. So
well, 175. 175 would be filing. I don't know what the other 40. Unfortunately, I'm in another court right now. I was in my office originally when we discussed this, and I did look at his ledger just to make sure that he was never at a zero balance. The only thing that I can confirm is that he wasn't at a zero balance. But I can confirm 1424 as of the date that we filed this. His monthly rent, he said, was how much? 1,000.
$1,149.
Oh, 1,149 plus the 100. Plus 175 is 1424, Your Honor. That's all I can confirm. I don't know where the other 40 is. There might be a carryover from the prior month, but I don't have access to his ledger at this point.
Okay, so does that clear up things for you, sir?
Yeah.
Okay, so are you in agreement to pay the $1,782 or no?
Yeah, can I get another week?
Your Honor, I've already
After June
extended.
6th?
Say that again.
Are you asking me for a week after June 6th?
Yes.
Well, it looks as though he's giving you 1 week extra from the 10 days. I'll put the two of you back in the breakout room so the two of you can discuss that any further.
It's okay. I don't want to discuss anything with him. I agree.
Sir, you have the right to discuss it and ask for an additional week if that's what you want.
He was rude and just over talking me and argumentative. I don't want to talk to him.
Okay, so Mr. Marshall, do you want to proceed with the resolution or do you want to set it for a court date and have an attorney represent you or represent you either way?
I want to set it for a court date.
All right, we'll schedule the second hearing in this matter for May 27th. At 2:15 p.m.
Thank you, Your Honor.
Okay, we'll see you back. Thank you.
Thank you.
All right, have a good day. Well, that's great. My thing froze. Okay, Mr. Daniels, please keep your hood off. You're in court. Okay, Mr. Holmes, I'm sorry, my computer seems to have, my file program here is not great. Let me just see if that's saved. Nope, didn't save one thing I just did. All right, just one moment, Mr. Holmes. Okay, so we are on the record in the matter of Daniel Shipman versus Damian Doherty, Madison Rakowski, 2500639.
Yes, Your Honor, did the court get the documents I submitted?
Sir, first of all, you're going completely out of order. Just one moment. Attorney, your appearance for the record, please.
Yes, Your Honor, Daniel Holmes appearing on behalf of the plaintiff, Dan Shipman.
Okay, and Mr. Doherty, your name for the record, please.
Damian Doherty.
Okay, and Ms. Rakowski, your name for the record, please.
All right, hold on, let me grab her. She's upstairs. Madison. She's coming.
Yes.
Say it.
Madison Rakowski.
All right, thank you. All right, and so counsel, the court had you all in a breakout room, and Mr. Holmes, you indicated that there was not a resolution, correct?
That's correct, Your Honor.
Okay, and then Mr. Doherty, you asked the court if the court received whatever it is you had submitted.
Yes.
When did you submit it and how did you submit it?
I had emailed it to the court clerk and it was threats and retaliation evidence against us of calling false CPS reports on us for not being out and just intimidating us.
Okay.
We don't want to be here any longer than we need to be. Like, we can be out in a week.
All right, let me, see if we've received anything.
Okay.
Okay, I do not have that. What email did you send it to?
I sent it to the 27th District Court.
Okay, let me, see what that looks like, and then we'll recall this matter, okay?
Yes, thank you very much.
Okay, and Mr. Katz, you have two more, so let's call those two. The court's going to go on the record in the matter of Green Trees Apartments versus Emily Feister, 2500719. And counsel?
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
All right, Ms. Feister is not present. And counsel?
Your Honor, this is a non-payment rent possession case.
Okay, so we are on the record in the matter of Daniel Shipman versus Damian Doherty, Madison Rakowski, 2500639.
Yes, Your Honor, did the court get the documents I submitted?
Sir, first of all, you're going completely out of order. Just one moment. Attorney, your appearance for the record, please.
Yes, Your Honor. Daniel Holmes appearing on behalf of the plaintiff, Dan Shipman.
Okay, and Mr. Doherty, your name for the record, please.
Damian Doherty.
Okay, and Ms. Rakowski, your name for the record, please.
All right, hold on, let me grab her. She's upstairs. Madison. She's coming.
Yes.
Say it.
Madison Rakowski.
All right, thank you. All right, and so counsel, the court had you all in a breakout room, and Mr. Holmes, you indicated that there was not a resolution, correct?
That's correct, Your Honor.
Okay, and then Mr. Doherty, you asked the court if the court received whatever it is you had submitted.
Yes.
When did you submit it and how did you submit it?
I had emailed it to the court clerk, and it was threats and retaliation evidence against us of calling false CPS reports on us for not being out and just intimidating us.
Okay.
We don't want to be here any longer than we need to be. Like, we can be out in a week.
All right, let me see if we've received anything.
Okay.
Okay, I do not have that. What email did you send it to?
I sent it to the 27th District Court.
Okay, let me see what that looks like, and then we'll recall this matter, okay?
Yes, thank you very much.
Okay, and Mr. Katz, you have two more, so let's call those two. The court's going to go on the record in the matter of Green Trees Apartments versus Emily Feister, 719. And counsel?
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
All right, Ms. Feister is not present. And counsel?
Your Honor, this is a non-payment rent possession case.
Hello. Okay, and so Mr. Holmes, has there been a resolution? You're muted.
Yes, there has been a resolution, Your Honor.
Okay, so the court's going to go back on the record in the matter of Daniel Shipman versus Damian Doherty and Madison Rakowski, 2500639. And counsel, your appearance, please.
Daniel Holmes appearing on behalf of plaintiff Dan Shipman.
All right, thank you. And Mr. Doherty, your name again for the record, please.
Damian Doherty.
Okay, and also, Ms. Rakowski, your name for the record, please.
Madison Rakowski.
Okay, and counsel, the two of you, the three of you were able to meet in a breakout room, correct?
That's correct, Your Honor.
All right, and there's been a resolution?
Yes, Your Honor. The parties have agreed to a total judgment, judgment of possession effective May 25 of 2025, or an order of eviction can be entered. We've also agreed to money damages of $2,075 payable in full before the end of 60 days from today's date. The plaintiff would reserve his claim for damages to the premises upon the tenant vacating.
Okay, so $2,075 to be paid in full by the end of 60 days from today's date. And you are, okay, Mr. Doherty and Ms. Rakowski, you are waiving your right for the 10-day statutory time from the judgment today. You're agreeing to reduce that time from 10 days to 5 days?
I didn't know that we necessarily had 10 days.
You have a statutory right to 10 days. You can certainly, by consent, that can be expanded or reduced. So I'm just asking your, sir, because it's been represented that you're all in agreement for the writ to be effective May 25th.
Well, that's because I thought we had to be out instantly. I mean, if we have 10 days by statutory, then I would like to have the 10 days so that I can make sure I have all my stuff.
Okay, Mr. Shipman or Mr. Holmes?
That's okay.
I could agree to that. The additional 5 days would put us to May 30th, I believe.
You said you could or could not agree to that?
I could agree to that.
Okay, so the writ will be May 30th. And I'm sorry, was there a request for money judgment, counsel?
Yes, Your Honor, there was in the amount of $2,075.
Okay, and so this dollar amount represents unpaid rent, correct?
That is the unpaid rent, including court cost as well.
Okay, all right. And so, Mr. Doherty and Ms. Rakowski, you do understand that the rights that you've received in your packet of information, correct?
Yes.
Yes.
All right, and that by entering into this resolution that you're going to be waiving some of those rights.
Yes.
And you also understand that Mr. Holmes represents the interest of Mr. Shipman and not your interest. You understand that?
Yes.
All right, do you have any questions, either one of you?
No.
Thank you.
Your Honor, I just wanted to make it clear that the plaintiff would.
Hold on, counsel. Ms. Rakowski, do you have any questions?
Thank you.
I'm sorry?
No, thank you.
All right, yes, Mr. Holmes?
Yes, Your Honor, I wanted to make it clear that the plaintiff would reserve his right to a claim for any property damage to the premises after the tenants vacate.
And the court was going to indicate that in its judgment, but I will also write it in here. All right, the court then does find the waiver of rights is valid. Oh, I'm sorry, counsel, did you go over the court rules with Mr. Doherty and Ms. Rakowski?
No, I did not, Your Honor.
You please do so.
Pardon me?
Please do so, counsel.
Your Honor, I'm not actually don't have court rules in front of me right now.
Okay, Mr. Doherty and Ms. Rakowski, you do understand that this judgment that you're entering, that the court rules do allow for in the event that there's some, I don't want to say buyer's remorse, but if there's an issue regarding the judgment and that there's been a mistake made or otherwise, that you have 3 business days to request the court set aside the judgment. Do you understand that?
Yes.
Okay. All right, that's a summary of the court rules. I didn't read them each individually, but that's a summary of the court rules.
No, I get the gist of it.
Okay. All right, the court does find that the waiver of rights is valid, the terms of the judgment are reasonable. The court does find by consent, plaintiff is entitled to recover possession of the property. If the defendants do not move out on it before April 30th, plaintiff may apply for an order evicting the defendant. I'm sorry, what is that, counsel?
I'm sorry, that date that you just indicated a moment ago? Did you say April 30th?
May 30th.
Okay, thank you.
The court will also note that $2,075 is now due and owing to the plaintiff. That amount is to be paid by the end of 60 days from today's date. The court also finds that additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant. A money judgment will enter and the court will sign it upon receipt. Do you have any questions, Mr. Doherty or Ms. Rakowski?
No.
No, thank you.
All right, anything else?
Nothing further, Your Honor, from me.
Okay. All right, thank you. The court will sign that upon receipt. Counsel, if you can submit that via e-file. Thank you. Let's go off record.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day.
Well, thank you, Your Honor. I'll spare you the jokes until I'm here the next day. But such an old case, I was going to comment, maybe he's operating on a sundial. I'm not sure because certainly I was here. Thank you, Judge.
Okay, thank you. Have a good day. And we are on the record in the matter of Dakota Daniels, 24892.
How you doing, Your Honor?
Hello, just one moment. Your attorney's got to place his attorney for the appearance on the record.
Good morning, Your Honor. John Goldport, P 30758 on behalf of Mr. Daniels. Mr. Daniels, please put your name on the record official.
Dakota Stephen Daniels.
Okay, thank you. While the trees are pretty, I need to see your face, sir.
Sorry.
Thank you. All right, I do apologize for the delay today. And so today is the scheduled for probation violation. Mr. Daniels is on probation for operating or visibly impaired. It's alleged that he tested positive for marijuana on April 24th, May 5th, failed to appear for probation on May 8th, and failed to attend outpatient. Counsel?
That is correct, Your Honor. I've had an opportunity to discuss this matter with Mr. Daniels and also go over the violations and the allegations. I've informed him he has a right to a hearing in this particular matter. At this time, he would waive that right and he would plead guilty to the violations.
Okay, and sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and sir, you heard the allegations that were placed on the record, correct?
Yeah. I missed the
Hold on, sir.
probation
There's a
treatment.
procedure. Sir, there's a procedure we have to do, so hold on just one moment.
Okay.
As to the allegations, sir, how do you plead?
I plead guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
What was that?
You've gone over your advice of rights for probation violation purposes with your attorney, is that correct?
Yeah.
Yes?
Yes.
Is that yes?
Yes, ma'am.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea, and that the recommendation in this matter is for probation to continue and you to complete all terms of probation, pay a $50 probation violation fee, $50 probation rescheduling fee, immediately enroll in outpatient counseling, and 15 days jail suspended. Do you understand that that's the recommendation?
Yes.
All right. And sir, knowing all of that, do you want to continue with your plea?
Yes.
Has
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No, ma'am. No, Your Honor.
All right, counsel, you may please order your client.
Thank you. Mr. Daniels, you were placed on probation to this court, correct?
Yes, sir.
And you were directed to refrain from smoking marijuana unless you had a medical marijuana card for that. Is that correct?
Yes, yes, sir.
And on 2 dates, you tested positive for marijuana. Is that correct?
Yes, but I did not consume any. I'm just around too many people that smokes marijuana. I'm trying to figure it out.
Well, as we discussed, you were directed not to have any contact and not to ingest or get marijuana into your system. Is that correct?
Yes, I'm.
And you got
positive.
marijuana into your system. Is that correct?
Unfortunately, yeah.
Okay. And you're also told to attain or get to your, I'm sorry, there was I forgot the assessment, not assessment, for counseling. Is that correct?
Yeah, I was having trouble, but I talked to my probation officer, and I'm supposed to come in there today, and she says she's gonna help me figure it all out.
Some time ago and it didn't get done. Is that correct?
What is that?
You were told to do it before and you didn't do that. Is that correct?
No, that's whenever I was experiencing tooth pain.
I understand that.
Experiencing what?
We'll get to that, sir. Let's go back to the, I'm sorry, the third one. You're right, I forgot to write the note down as to what the.
Failed to appear for probation May 8th.
No, that, before that, sir. The.
Positive marijuana May 5th.
No, we did that.
Failed to attend outpatient.
That's it. Failed to attend the outpatient. I know you're having problems, but you have not attended outpatient as of today. Is that correct?
I just signed up yesterday. I talked to my probation officer yesterday through email, and she kind of guided me through it. But I wanted to go in and see her.
Sir, up until you haven't attended yet. Is that correct?
I'm still trying to figure out how to attend it. That's why I said I was going to go and see my probation officer so she can help me do it today.
As of May 9th, when this violation was set, you have not yet participated or enrolled in outpatient treatment. Is that correct?
Yes, Your Honor. I've been constantly getting off work really late.
Okay, and you were supposed to go to a probation meeting, but you did not attend that. And the reason you didn't attend that is because you failed to, you had to have a tooth pulled and you never contacted them to say, hey, this is what's happening, I can't make the meeting. Is that correct?
I told her about the excruciating tooth pain, yes. I also forgot that I had a baby's appointment for my girlfriend. That's literally the same day as the probation visit and the tooth extraction. So it was just a bunch of jumbled up uh bull crap. Excuse my language.
So you didn't attend it and you didn't call to say, hey, look, I'm having my tooth pulled and I gotta get another date, did you?
No, sir.
And satisfied, Your Honor.
Okay, the
Yeah, I
court
was in.
is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate technical violations 1 through 4 will have occurred.
And we'd ask the recommendation be adopted, Your Honor. I've explained to him that the marijuana, however it got into his system, he can't be around those people, he can't be ingesting marijuana, and he indicated he understands that, and that if he does it again, hanging around the wrong people or ingesting marijuana, he's going to jail. I also explained what the 15 days suspended meant, Your Honor.
So.
Your Honor, can I say something?
Sure.
It's not that I'm just hanging around the wrong people. It's my job. I'm actually currently trying to find a new job, so I'm not around marijuana and stuff like that. Cause I'm a roofer, and that's, it's all they do on the roof and on the way to the job and stuff like that, So it's not like I'm just consuming it or hanging out with the wrong people.
Sir, did you just say that you're a roofer and that's what the people are doing when they're up on the roof?
Well, not considerably on the roof, but on the way to the jobs and stuff like that. So I've been trying to figure out a new seating position for myself, so I'm not around any of that.
A new seating position. So they're driving
like a new
their marijuana. That's great.
What was that?
So they're driving while they're smoking their marijuana.
Well, not necessarily the driver, no, just the passengers that is also in there with me.
Mm. And so what days of the week do you work, sir?
I try to work every single day I can, even on the weekends, to save enough money for the baby on the baby I have coming, and so I can save for an apartment. But I mean, it's serious enough to take days off for, to take care of my business.
So did you work May 4th? Mr. Daniels,
Hello?
Did you work May 4th? Mr. Daniels?
I'm sorry, you keep cutting out.
Did you work May 4th?
Yes.
Okay. So, sir, I will say that from the testimony this court has heard, thank you. Thank you so much. Well, sorry, Dad. Why didn't you appear for your probation appointment on May 8th?
Because I was experiencing tooth pain. I had like it was all right here. It was really bad, and then I had a baby's appointment for my girlfriend. Ultrasound and stuff like that, a checkup, and I honestly didn't know about the baby's appointment after I got my tooth pulled, but we went right there after, and then I didn't know I had a probation visit, and then my probation officer emailed me, and then I knew I was screwed. I was just in so much pain, I felt it in my ears and everything.
Sir, you have an iPhone, right? Or a smartphone of some sort?
Yeah, I have an iPhone.
Okay. So you have a calendar function on that iPhone, correct?
Yes.
Do you use it?
I don't know how.
Sir?
I can learn how though.
Oh yes, that'd be great, because this court's not going to give you any more leniency as it relates to missing any of your stuff. So learn how.
Yeah, I understand, and I'm very appreciative.
Okay. You're very what?
Appreciative.
So, sir, I can tell you right now, if you click on your calendar function, there's a button, I think it says add, and then you click on that, and then you click on the day, or maybe you click on the date first, and then you add, I'm not sure. But it's not that difficult, and I'm sure you can do it. So maybe I'll have to tell you to be in person for your next appointment, and then they can walk you through how to work, how to learn your calendar system.
Yeah, I was gonna see my probation officer to take with her.
Please step back outside wherever you're at, because you're breaking up now. When do you see your probation officer next? Hello?
Can you hear me, Judge?
Yes, please don't keep going inside whatever building you're in, because that's when you lose your connection.
Yeah, I was gonna see if I can see my probation officer today, so she can like guide me through all of like everything I have going on. But I'm more of a hands-on person than.
Oh, I can understand that. You may want to check in getting a life coach too then, because you're gonna need some more assistance after you're done with probation. So, the court's going to grant the court's going to adopt the recommendation. The court's going to order 15 days jail suspended, outpatient treatment immediately, submit proof of that, sir, $50 rescheduling fee to continue to complete all terms of probation.
Thank you, Ron.
And sir, I would suggest
Thank you, Your Honor.
how to, maybe whether you have to drive with your head out the window, with the window down when you're driving to work, I don't know, but.
Yeah, I'm gonna try to start.
That's not gonna fly next time, just so you're aware.
Okay.
Thank you, Ron.
All right. Let's go off the record for just a moment. I'm gonna check on that matter for, proof of service, and then Mr. O'Brien will handle your matter in just one moment, okay?
Thank you, Judge.
Am I still on the record, sir?
Okay, the court is on the record in the matter of the City of Wyandotte versus Melanie Groves, 2411781. And counsel, your appearance, please.
Good morning, Judge DeSantos, Leo Brand, on behalf of Ms. Groves.
All right, and Ms. Groves, your name for the record, please.
Melanie Groves.
All right, and so today's date is scheduled for sentencing on your client's plea to an amended charge of operating while intoxicated, visibly impaired. The original charge of operating while intoxicated was dismissed by way of resolution between counsel. And counsel, do you have an opportunity to review the report and recommendation with your client?
We did, Your Honor. We've both reviewed it. It's factually accurate. I'd like to make one, clarification.
Okay.
There was a mention of her medical marijuana card. Approximately 6 years ago, she was involved in a horrible accident in the Republic of Ohio. She's had continuing medical problems because of it. She's a surgical spinal candidate. She received her medical marijuana card approximately a year after the accident. She does have it on her. The report indicated that she didn't bring it, but it's current and up to date. Just two other things briefly about my client. She has a child who's a special needs child. And like I said, she's already has numerous legitimate physical injuries from the car accident. And she works, she's a homeowner in your community, and any leniency that you could extend to her would be appreciated.
All right, thank you. And so, Ms. Groves, you have 1 cup water?
I had 1.5.
Okay, well, I'm not sure if you reviewed the can, but there's a high level of alcohol in each one of those. So that combined with your prescription medication clearly was intending a disaster.
I didn't take my prescription medication that day.
Okay, but it's still in your system, is it not?
Yes.
Right, so, but if you look at those, I think it's like 11 or 12 or 13, some high level of percentage of alcohol in each can. So, pretty high concentration of alcohol in those. Okay, and so ma'am, if you were to test right now, what's in your system?
My prescription medication.
Okay. All right, and I'm sorry, Council, I kind of lost you a little bit regarding the medical marijuana card. That she does have it and she did already submit it, or she's going to submit it?
She does, she has it. I guess she wasn't aware that she had to bring it to the interview. She does have it though. And it's, I know like when they first came out, people said they had insomnia and all that stuff. I mean, it's legitimately prescribed from her treating doctor. So I think she probably actually benefits from the use of the stuff.
Okay, and the court does know that she is under primary doctor's care, and does list some of her injuries as well. And so ma'am, just make sure you get a copy of that to your probation officer at some point. The court does find after hearing from Ms. Groves, reviewing the report, the recommendation, and the circumstances surrounding this matter, the court does find there's reasonable grounds to Department MCL 769.5. The court's going to also state that the court does find the following sentence is in the best interest of justice, is reasonable, proportionate to the seriousness of the matter, taking into account the circumstances surrounding the incident as well as Ms. Groves, and taking into account the legislative guidelines. The court's going to order 6 months probation. You're eligible for early discharge. I'll go over that in just a few moments. You're not to violate any criminal law of any government. You're not to be disabled without the consent of the court. You're to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're notify your probation officer immediately of any change in address or employment status. You're not using any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition so the court can monitor your progress in maintaining the absence and sobriety. The court's going to also order you to participate in the chemical awareness program. The rehabilitative goal for that condition is so you can further educate yourself regarding drug and alcohol use and to make so that you can make better informed decisions in the future, hopefully preventing this matter from happening again. And the court's going to also order you to participate in the Mad Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and hopefully educate you about the consequences of such behavior so that this does not happen again. Any questions?
No.
All right. And the court's going to order a $300 fine, $100 screening assessment fee, supervision oversight fee of $300. That's $50 a month at 6 months. And since you're eligible for early discharge, half of that could be waived. Up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Chemical awareness program of $75. So it's a total of $1,200. You did post a bond of $500. Do you have any other funds to pay today?
No.
Okay. And so how much can you pay per month and what day of the month works best for you?
I can pay it in full. I could come today. I could pay it in full.
Okay. Okay. I'm slightly confused because I asked you to get any other funds to pay today and you said no. So that's why, if I look confused, that's why.
No, sorry.
That's okay. All right. So, all right, so let's do $1,200. We're going to less $150 because if you discharge early, then you won't have to pay that. So that's a balance of $1,050. You did post a bond of $500. Which leaves a balance of $550, and you can pay $550 out of pocket today?
Yes.
Okay. All right, as I did indicate, ma'am, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made good faith effort to making full payment. I went over some of that pretty quickly. But you can certainly go over that a little bit more in detail with probation, okay?
Okay.
All right, I'm going to have you email over to probation, or you're going to be bringing that payment in today, ma'am?
Yes.
Okay, then you can stop at probation, you can set up your instruction appointment when you get here, okay?
Okay,
Your appointment won't be today, but when you're here, you can set it up.
all right,
Okay, good luck to you. Thank you.
thank you.
Thank you, Judge.
Thank you. Have a good day.
We do.
All right, and then you know what, we need Ally. We need Ally for this one. Okay, we need Ally for this, so, okay. All right, we are on the record in the matter of Propel Property Management versus Ashley Long, 2500758.
Good afternoon, Your Honor. Adam Devlin, P 72877, plaintiff.
Okay, I'm sorry, it's really muffled.
Sorry, Your Honor. I'm here.
Okay, your
Adam
appearance.
Devlin, P 72877 for the plaintiff.
Okay, and today is the date scheduled for the first hearing in this matter. You will not permit the court of Michigan or to the defendant, and nobody judge will enter at this time. The court will sign.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you, you too.
All right, I'm going off the record on this one. And then I'm going to handle the Holmes matter, or the Shipman matter in just one moment. All right, we are on the record in the matter of the state of Michigan versus David Hanley. 25694. And officer, your name for the record, please.
Officer Cade Barwick.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. And you may proceed on the warrant.
On Tuesday, February 4th, 2025, at approximately 23:39 hours, Wyandotte Police Officers Saltzman and Coburg were dispatched to 3851 4th Street in the city of Wyandotte in regards to a motor vehicle accident with injuries. Officers arrived and observed a Dodge Nitro and a Dodge Grand Caravan involved in the crash. Both vehicles had major damage and airbag deployment. Officer Coburg observed the defendant, Davin Hanley, exit the driver's door of the Grand Caravan. While speaking with Hanley, Officer Coburg detected several clues of intoxication, including bloodshot eyes, slurred speech, and odor of intoxicants emitting from her person. Officer Coburg conducted standardized field sobriety test on Hanley, in which he again observed several clues of intoxication. After SFSTs, Hanley was evaluated by the Wyandotte Fire Department, and while in the rear of the ambulance, Officer Saltzman attempted to administer a portable breath test, in which she refused. Hanley was transported to the Wyandotte Henry Ford Hospital for observation and advised she was under arrest. Officer Saltzman completed a search warrant for Hanley's blood, in which it was signed by the 27th District Court Judge DeSanto. Officer Saltzman sent the blood kit to the MSP lab, and on February 13th, 2025, MSP lab detected 0.12 grams of alcohol. They also detected hydrocodone and alprazolam. Hanley was discharged from the hospital and taken to the Wyandotte jail. The driver of the Dodge Nitro, Diala Sukari, and the front seat passenger, Justin Gagler, were transported to Corwell Health, Trenton, for medical treatment. Sukari's medical records show the following injuries from the crash: displaced fracture in her right wrist, concussion, pain in both the left and right knee. Gagler's medical records show the following injuries from the crash: a 16-centimeter laceration to his scalp requiring 14 staples, fracture to a C7, contusion on his lower left and right leg, cervical disc displacement at C6 and C7, and cervical disc displacement at C5 and C6. Hanley's medical records show the following: complaint of having a panic attack and chest pain not related to the crash, and admitted to drinking 3 twisted teas 3 hours prior to the accident. Through the officer's investigation, they determined that the Dodge Grand Caravan failed to yield at the turnaround to the Dodge Nitro, which was driving northbound on 4th Street. The downriver crash team was activated, and the downriver crash team determined that the Dodge Nitro was driving 48 miles an hour in a 45 mile an hour zone. No data was able to be pulled from the Grand Caravan.
All right, upon examination of planning, what is that finding? The offenses charged were committed, and there's probable cause to believe the defendant committed those offenses. Would you like this that or mailed?
That, please.
Okay, and therefore the court's going to indicate a $30,000 10% bond.
Thank you.
All right, thank you. Are we doing Brian Joseph? Is this one? Oh, that's medium one. Okay. All right, so let's go off the record, all right, and, or do you want me to do this immediate warrant first? Kelly?
Yeah.
Okay, let's go back on the record in the matter of Ryan Joseph, 241724, defendant was scheduled to appear for a show cause hearing today at 9:30. It is now 12:16, defendants failed to appear. Therefore, given that this is a relatively old matter, defendant failed to appear for jail review April 9th, April 30th, and had previously failed to appear March 5th for the arraignment pre-trial and okay, so let's see here. Is this Tanya Buckley?
Yes, sure.
Okay. All right, we are on the record in the matter of these city of Wine Numbers, Tanya Buckley, 25693. And counsel?
Your Honor, good afternoon, John Goldport, P 30758, on behalf of Ms. Beckley. Ms. Beckley, would you please put your name on the record?
Hold on, we have to make sure you're, please unmute. You have to maybe hit the hashtag.
Can you hear us, Your Honor?
Yes, sure can.
Okay, we have no picture, unfortunately, so.
Okay, well, nobody needs to see this mug anyway, so. All right, and so ma'am, your name for the record, please.
Tanya Buckley.
All right, and so counsel?
Your Honor, Ms. Beckley has been charged with possession of drug paraphernalia as well as possession of controlled substance. She would waive a formal reading of those charges, stand mute to the charges, ask the plea of not guilty be entered.
All right, the court will waive formal reading. And enter a plea of not guilty for purpose of the arraignment. Schedule this matter for a pre-trial on May 28th.
8:45.
At 8:45 a.m. And counsel asks to bond.
Your Honor, Ms. Beckley is 48 years old. She does have some prior police contact. There may be an outstanding warrant, but she's not sure of that, Your Honor. She is unemployed. She resides with her friend, and Mr. Lopez, as I've indicated, she's 48 years old. Your Honor, she's been undergoing some serious mental problems resulting as a result of the death of her daughter, the adult daughter. Your Honor, I've discussed this matter with her, where she wants to get these matters resolved, and she wants to clear up her heroin problem. She clearly has some problems, and she needs some help along those lines. We're asking for a personal bond, Your Honor, because of her unemployment, and she assures me that she will be returning to this court. And if not a personal bond, something commensurate with the situation and the charges that have been brought against her.
Okay. And so, which matter is outstanding?
Outstanding.
I thought you were talking about, Mary, the information Ms. Beckley, are you currently on probation or parole?
No.
When I reviewed the reports, Your Honor, I did not see any outstanding warrants. However, she indicated there might be some.
Right, and that's about the police contact.
Yeah. She was a passenger in a car, Your Honor, in this particular situation. The car was stopped for traffic violations.
Leanne, if you're in a test right now, what's in your system?
Heroin and crack cocaine.
And you want treatment, ma'am?
Yes.
And you don't work?
Pardon?
You don't work?
No.
When's the last time you were employed?
I'm sorry?
When is the last time you were employed?
It's been a while. I have some medical issues right now. I just had surgery on my foot and I have some heart issues. I'm seeking my disability.
But in any event, here's what the court's going to do. The court's going to order you not to possess or consume any alcohol or drugs unless prescribed. The court's going to order you to be tethered to treatment to the Wayne County Jail. That way, ma'am, you get the treatment that you're indicating you would like.
They don't have treatment in Wayne County Jail.
It's not in the Wayne County Jail, it's through the Wayne County Jail. They tether you to a facility outside of the jail.
Okay.
Did you set a amount on that?
$10,000 personal bond.
Thank you.
Okay, good luck to you, ma'am. We'll see you guys next week.
Thank you.
Thank you. So, all right, we're on the record in the matter of the city of Rhinebeck versus T. Smith, 25121 A and B.
Good afternoon, Your Honor. Your Honor, John Gould, E30758 on behalf of Mr. Smith. Mr. Smith, would you please put your name on the record?
Marty Smith.
All right, the court's going to continue his not guilty plea as he already entered not guilty plea back in January.
That is correct, Your Honor.
He failed to appear on February 10th for a pretrial.
And Your Honor,
Okay, good luck to you, ma'am. We'll see you guys next week.
Thank you.
Thank you. So, all right, we're on the record in the matter of the city of Rhinebeck versus T. Smith, 25121 A and B.
Good afternoon, Your Honor. Your Honor, John Gould, E30758 on behalf of Mr. Smith. Mr. Smith, would you please put your name on the record?
Marty Smith.
All right, the court's going to continue his not guilty plea as he already entered not guilty plea back in January.
That is correct, Your Honor.
He failed to appear on February 10th for a pretrial.
And Your Honor, I spoke to Mr. Smith. He indicated to me that he posted bond. However, there was an outstanding warrant and it was a hold out of Macomb County. When he posted bond, they took him to the Macomb County facility and he violation. And he did his time out there and was in Macomb County Jail at the time he was supposed to appear back here. He indicated to me, he told them a number of times where he was supposed to be, and Macomb County Jail said, too bad. I mean, that's what he's.
Okay, so has he been in Macomb County Jail since,
No, he is not.
today?
No, he is not, Your Honor.
Okay, so, the court is going to continue his not guilty plea, set this matter for pretrial on May 28th. 10:45 a.m. Mr. Smith, when were you released from Macomb County Jail?
Say it again.
Say that again.
When were you released from the Macomb County Jail?
When was I released? And it was like was that February? The end of February, I say like the 23rd of February. So I was,
Sir, why didn't you come into court? You knew you had a court date in this court. Why didn't you come into court?
I didn't come to court because I was incarcerated at Macomb County Jail.
Sir, we've already established that, and you just indicated that you were released.
I wasn't. And when I was released, I didn't have any notoriety or like where I didn't have any mail or anything to contact you or anything.
Pause. Sir, do you know how to contact other individuals?
Yes, ma'am.
So it's on you. It is your responsibility to contact the court.
I understand, ma'am.
You were provided all that information. You didn't show up because you were in custody in another jurisdiction. Upon your release, it is your responsibility to reach out and contact the court. Not for the court to find you, try to find you, chase you down or otherwise. Your responsibility. Don't put it off on the court. You've been out of custody for 3 months. Out of Macomb County Jail custody. How'd you end up in custody today, sir?
You already indicated to me that the officers, based on the outstanding warrant.
What officers?
I'm sorry, Your Honor. There was nothing in the report to indicate that. I mean,
How did you end up in custody today?
They just pulled up on me and hopped out on me, and they said they remember my face and my neck tattoo from the last situation when they called me for the warrant.
Okay.
But it wasn't nothing that I did wrong though. I went to them respectfully and everything. I went into custody.
Okay. And so were you a passenger in a vehicle? Were you driving a vehicle? Were you walking, riding a bike?
No, I was walking from the normal neighborhood store. And they rolled past me the first time and saw me, I guess, and they came back around. And by the time I left out the liquor store, they pulled up and they just came and put me in the cuffs and everything. I didn't do anything wrong though, ma'am.
Okay. And so where was that, sir? That was in Minot?
That was on 4th Street off Goddard, like right across from the McDonald's and it's like a car wash right on the end of 4th Street and Goddard.
Okay.
And I was walking with my little brother, that's all. The same situation from before.
Hold on, sir. Where is it you live? Because I show you don't live.
Oh, where I live, I live in a homeless shelter, but I received my mail at my sister's home. I live in Detroit, Michigan, though.
Okay. So okay.
Yeah, I'm not from my.
Do you have any other pending matters, sir?
No, ma'am.
All right, well, based upon Mr. Smith's previous relationship here, based upon his housing status as unstable due to his homelessness, the court's going to
go to my.
Sir, this is the time for you to interrupt me. The court's also going to note, based upon Mr. Smith's prior failure to contact the court for, after he was released from Monroe County Jail, the court's going to order a $7,500 10% bond.
Thank you, Your Honor.
In the event bond is GPS tethered through the Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed.
So I got a 75.
What's in your system?
So it don't matter that I was already had the bond already.
So
I'm sorry, man. I'm sorry, man.
The previous
I can report to you from my sister home. Like it's no problem to go to an address that's stable for me to get to. I can go to my sister's home. I just choose not to be at her home. but I can definitely go there if that's any problem. Like I'm not running from you all whatsoever. I completed probation for East Point and everything.
Sir, you're not, no. Let me just be very clear, sir. You were released from jail in Macomb County 3 months ago. You were here in the city of Wyandotte. You did not turn yourself in. Therefore, the
I didn't have any notoriety
Sir,
about me turning myself in, ma'am, I promise.
Stop. I'm not arguing with you. I'm just putting forth the reasons why this court entered the bond it just did. Okay? So, you're not to possess or consume any alcohol or drugs that are not prescribed. And the court will see you back on May 28th. Thank you. Have a good day. We are on the record in the matter of the state of Michigan versus Craig Cunningham, 25692.
What's the name, Judge?
Cunningham?
Okay, we're getting them out right now.
Okay, in the meantime, Detective Carr, do you want to start on the warrant or the complaint and work?
Yes, he can.
Okay.
Sounds
All
good.
right, Detective, your name for the record, please.
Good afternoon, Your Honor. Detective Joseph Carr, Wyandotte PD.
All right, please raise your right hand. You solemnly swear from testimony about speaking this matter the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. You may proceed on the warrant. We are on the record in the matter of the state of Michigan versus Craig Cunningham, 25692. Detective Carr.
What's the name, Judge?
Cunningham?
Okay, we're getting them out right now.
Okay, in the meantime, Detective Carr, do you want to start on the warrant or the complaint and work?
Yes, he can.
Okay.
Sounds
All
good.
right, Detective, your name for the record, please.
Good afternoon, Your Honor. Detective Joseph Carr, Wyandotte PD.
All right, please raise your right hand. You solemnly swear from testimony about speaking this matter the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. You may proceed on the warrant.
Your Honor, on May 18th, 2025, about 4:08 p.m., Officer Syke reported that he and Officers Carpo, Sadowski, and Jones were dispatched to 9337th Street regarding an alleged CSC that just occurred. Officers arrived at the scene and met with the victim, identified as Arias Calhoun, and witness Michael Lisi. Officer Syke reported that while Calhoun and Lisi were pouring coolant into her vehicle, an unknown black male, later identified as the defendant, Craig Cunningham, approached them where he asked them both if they wanted to have some fun. Both Calhoun and Lisi appeared confused, but Cunningham suddenly gripped Calhoun by her shoulders and forced her to the ground. Officer Syke reported that Calhoun stated Cunningham was touching her breast, and while they were on the ground, she could feel Cunningham touching her under her clothing, eventually touching her buttocks area. Officer Syke reported that Calhoun further stated that Calhoun was able to slide his hands underneath her garment and touch her vagina area. Calhoun struggled and fought with the defendant while on the ground for several minutes, where he also pulled her hair. Officer Syke added that witness Michael Lisi did witness the entire incident and assisted in pulling Cunningham off of Calhoun. Officer Syke reported that after the initial assault on Calhoun, the defendant left the area on foot, where he was observed entering in a home located at 926 7th Street. Calhoun and Lisi stated they have never met the defendant and do not know who he is, and the assault was unprovoked. Calhoun and Lisi described the defendant as a black male about 40 years old, about 6'2", 240 pounds, and last seen wearing black t-shirt and light colored shorts. Officer Syke further reported that they checked the area to no avail and soon went to 926 7th Street in hopes to make contact with the defendant. Officer Syke reported that while attempting to make contact with the defendant at 926 7th Street, he observed a black male home matching the same description as previously given. Officer Syke also confirmed the defendant's male located in a trash can outside the home. Officer Syke recovered written statements from the victim and witness. Later that evening, the night shift officers Alex Stathakis, Morgan Gardaki, John Ames, and Tyler Grove had previously been advised of the incident and attempted to make contact with the defendant at 926 7th Street regarding the assault. Officer Stathakis reported that on May 18th, 2025, about 9 p.m., he and assisting officers were dispatched back to 926 7th Street regarding a follow-up for the CSC. Officers were advised that the alleged suspect in the CSC was now outside his home. Officer Stathakis reported that upon arriving at 926 7th Street, the defendant was no longer outside, and they tried to knock on the door in hopes to make contact with him. Again, to no avail. Officer Stathakis reported that he also observed the defendant through a window of the home where he was seen armed with 2 large knives. Officer Stathakis further reported that after several minutes of speaking with the defendant from the home, he refused to come out, but eventually opened the door where he quickly grabbed his arm. The defendant attempted to shut the door on Officer Stathakis, where a physical struggle began. Officer Stathakis reported that the defendant headbutted him where they fell to the floor inside the home, where the defendant continued fighting to resist. Officer Gardaki was able to deploy his taser to the defendant, at which time he was subsequently arrested and transferred to the station. Officer Stathakis sustained cuts to both his arms, bruising, swelling, and redness to the right side of his face from being assaulted by the defendant. Officer Gardaki also completed a report 2025-9508 involving a vehicle that was impounded, which belonged to the defendant. During an inventory search of that vehicle, 2 large knives were located in addition to a loaded 9mm handgun.
All right, upon examination, meaning witness, the court does find the offense charge was committed and probable cause exists to charge, there's probable cause to believe the defendant committed those offenses. And Mr. Cunningham, your name for the record, please. I'm sorry, counsel, your appearance, please.
Your Honor, John Goldport, P0758, on behalf of Mr. Cunningham.
And Mr. Cunningham, your name for the record, please.
Craig Cunningham, Your Honor.
Okay. All right, and so counsel, as to the arraignment.
As to the arraignment, Your Honor, I reviewed the charges filed against Mr. Cunningham. I explained to them, each and every one of them, and at this time he would waive a formal reading of those charges, stand mute to the charges, ask the plea of not guilty be entered on all charges.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. In fact, you've had an opportunity to speak to one today, correct?
Just briefly, yes, Your Honor.
Okay. I didn't notice the court-appointed attorney paperwork, so.
It is in there, Your Honor, I believe.
I didn't see it, but I'll look. The court, once I receive the paperwork, the court-appointed attorney for felony matters, I'm sorry, for appointing the attorney for felony matters, the court will sign that. The court also, sir, you have the right to be presumed innocent until proven guilty on reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Your Honor.
All right, the court is going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on May 29th.
10 a.m.
At 10 a.m. And counsel has to bond.
Your Honor, as to bar, Mr. Cunningham is 44 years old. He has no prior criminal record. He reports to me that he is a graduate of Cass Tech. He went to West Point Military Academy and served five and a half years with an honorable discharge. He is presently unemployed. He is from Detroit originally. However, he spent some time in Texas and just returned from Texas. Has lived in the Wyandotte area for approximately 5 or 6 months. He does, however, have additional family throughout the area. As I've indicated, he has no prior criminal record. He is on disability and he suffers from PSD. There's a number of basis for his disability, and he is presently under therapist treatment for all of those items. We're asking for, these are very serious charges. However, Your Honor, he does maintain his innocence, has been more than forthright with me. We're asking for a reasonable bond. We would ask something in the area, I understand the circumstances of, which would be acceptable under this situation. There are no, as I said, he has no prior criminal record. He was honorably discharged from the service, and he's on disability at this point.
Okay, Mr. Cunningham, the court does thank you for your service to our country. And sir, how long have you been in Michigan?
As Your Honor, probably a couple months. I want to say it's March. Not long.
And so what brought you to Wyandotte from El Paso, Texas?
Your Honor, I had a friend who's a real estate agent, and he mentioned it was a house available, and I said, oh, okay. And it seemed like a decent, place and time. So just need a place to stay.
Do you have any criminal matters in the state of Texas, sir?
Your Honor.
Have you ever failed to appear in court for any reason?
No.
Sir, it shows that, and counsel, just for the record, I actually had already signed the document. For some reason, it wasn't clicking that it wasn't there, but. So sir, on your appointment for attorney, you have indicated that you're married and separated. So which is it? Are you married but separated?
Married but separated, Your Honor.
And how long have you been separated, sir?
More than a year.
How long have you been married?
10, so 15 years.
Are you currently on bond in any other jurisdiction?
No, Your Honor.
All right, and detective, as to bond.
Your Honor, taking into consideration the seriousness of the alleged offenses reported by the victim and to protect the community, I would recommend a $25,000 cash bond. I do believe that the defendant does pose some type of flight risk. He does have an address in, from what I can understand, Plano, Texas. I'm not sure if that's his mailing address or what the status of that is, but and then he does have a Michigan driver's license as well. So I do consider that some type of flight risk. So I would ask the court to take those factors into consideration regarding bond.
All right.
Your Honor, we would ask at least the opportunity to post 10% on that bond. I understand the seriousness. I understand that situation, or at least 10% and or a surety.
Okay.
I think that based on his lack of record, based on no prior involvement with this community based on his military service and all that he has done, not just for this country, but just in general, showing his reliability.
Well, counsel, the court is taking that into consideration, but the court is also taking into consideration the nature of these charges, these very serious charges. Not only for the named complaining witness in this matter, but also as it relates to the officer that was injured as a result of these allegations. The court is also taking into consideration that the named victim in this matter is a neighbor of the defendants, it appears.
I don't believe so, Your Honor.
Well, let me confirm.
I may have misread that, but there was in the report.
Hold on, counsel. There's also an allegation of random requests from people at people's homes. And it does show that Ms. Calhoun resides on the same street, which I believe is probably across the street from your client based on the addresses. And so
that would be correct. It appears that the defendant does live directly across the street from the victim. And as far as the other party involved, there was no charges in those allegations, but there is some pretty good evidence indicating that that did happen. Although no charges were filed regarding that incident.
Good evidence, there's a ring camera or something, I don't know. However, I understand, but taking all of that into consideration, and the court has to take into account that the allegations in this matter are that it was completely unprovoked. The parties don't even know each other. And these are the allegations that are put forward. The court is going to order the following. The court's going to, for the protection of the victim and the public in this matter at large, the court's going to order a $250,000 cash surety 10% bond. There is to be no contact with Ms. Calhoun. That's phone contact, text message, email, social media, third party, anything of the like. There's not to be any contact with any prosecution witnesses. You're not to enter the premises at the home on 7th Street. And in fact, the court's going to order that you're not to enter the premises in that block on 7th Street at all.
Can you repeat that, Your Honor?
You're not to enter the block of the 900 block of 7th Street, with the exception of one visit to obtain your personal belongings as long as you're accompanied by a police officer. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those in your home, sir?
There are a few things I have in the home, Your Honor.
Weapons or firearms?
Yes, Your Honor.
All right, those should be turned over to the Wyandotte Police Department for safekeeping. And you're not to be released by GPS tethered to the Wayne County Jail. So, sir, some substances, in the event bond is posted, you are not to return to your home unless you have an officer accompanying you for the purpose of retrieving some personal items that you may need for your everyday living. We'll see you back on May 29th. All right, and we are.
There's something you said after.
I'm sorry?
There's something you said after. It was kind of echoing. I couldn't hear you clearly.
I said that we'll see you on May 29th.
Good luck.
Okay, thank you, Your Honor.
We're on the record, the name of the senior issuer is David Canoli, 25691. And counsel, detective, your, is this detective? Oh, this is detective.
1 second, Your Honor.
Please hold a second.
Okay, but you need to give a call, I know you have to be home in 15 minutes.
Yeah.
So maybe call
He said, please call.
whoever you're meeting at your house.
Oh, wait, hold on. A plumber. And he was supposed to be there at noon, but we moved it all. My phone.
Get right down in that chair.
Okay. So we are on the record in the matter of David Canoli. And so, detective, your name for the record, please.
Detective Steve Sable, Your Honor.
All right, please raise your right hand. Do you solemnly swear from testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You may proceed on the warrant.
Thank you, Judge. On 5/17 of this year, at approximately 9 p.m., Officer Ames was dispatched to 264 Superior Street, apartment number 1, for a domestic assault where the offender had taken the victim's vehicle, which is a 2011 Chrysler 200, bearing Michigan license plate Edward Mary Sam 686. The Chrysler 200 is gray in color, and he took it without permission. While en route to the scene, Officer Gardaki had informed over the radio that Officer Tyler Grote and Officer Alex Stathakis had initiated a traffic stop on the suspect at 3rd Street and Ford Avenue. The complainant, Kimberly LaRose, stated that she was assaulted by her boyfriend, the defendant. Officers observed LaRose to have a large bump on the left side of her head near her hairline. LaRose was visibly shaken to the officers. After an evening out, LaRose reports that she returned home to 264 Superior, apartment 1. The defendant began yelling at LaRose and accusing her of cheating on him. The defendant also stated that LaRose was not at the birthday party and that she was lying. The defendant left the residence and took LaRose's vehicle to the dollar store. When the defendant returned back again to the address, he began again accusing LaRose of cheating. While the couple was arguing in the room between the kitchen and living room, the defendant began to punch LaRose in the face with a closed fist approximately 2 to 3 times, causing LaRose to fall on the floor. LaRose decided that she was going to leave with her 12-year-old son. While LaRose was speaking with her son to get his belongings, the defendant took LaRose's cell phone and her wallet and ran out of the house. The defendant then took LaRose's car, the 2015 the Chrysler 200, bearing a Michigan license plate Adam Paul Frank 835. This is a 2015 vehicle. LaRose stated that Conley did not have permission to take her vehicle like she had before when he went to the store. LaRose said that the defendant was only allowed to take it to the store, and that was already a completed act. LaRose stated that she and the defendant have been in a relationship for approximately 6 years, and that the relationship has been on and off. While responding to the call, Officer Gardaki and Stathakis observed LaRose's vehicle near Walnut and 3rd Street enter the southbound lane of 3rd Street and pass another vehicle at a high rate of speed, which was well above the posted 25-mile-an-hour speed limit zone. Officers turned onto 3rd Street and activated their overhead emergency equipment and lighting in an attempt to catch up to the vehicle. Officers were able to catch up to the vehicle and the defendant who was driving it at 3rd Street and Ford Avenue. The defendant admitted to the officers to leaving the scene after that argument with LaRose. The defendant admitted that he did not have a valid driver's license. The officers confirmed via a lien check of the Law Enforcement Information Network that in fact, the defendant did not have a valid license. And he also had the victim, LaRose's phone with him on his person, and the victim's wallet was located in the front passenger seat of her car. Thank you, Your Honor.
All right, thank you. Upon examination of the plaintiff witness, I find the offense charges committed, there's probable cause to believe the defendant committed the offense. And counsel, your appearance, please.
Your Honor, John Goldthorpe, P 30758, on behalf of Mr. Cannoli. Mr. Cannoli, would you please put your name on the record?
David Cannoli.
All right, thank you. I feel as though you've been here before, sir. Have you?
Yes, I have.
Okay, well, that's an unusual name, so that pretty much stuck with me. All right, and so, counsel, as to the arraignment.
As to the arraignment, Your Honor, he'd stand mute to the charges, waive a form reading of those charges, ask that a plea of not guilty be entered.
The court waive the formal reading, enter a plea of not guilty for purpose of the arraignment. Sir, you do have the right to have an attorney. If you cannot afford one, the court will, you can have one appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today, is that correct?
Correct.
All right, the court has also signed the attorney for appointed attorney matters for felony purposes. And as to the balance of your rights, sir, you have the right to be presumed innocent to proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing is against you in court. Do you understand those rights?
Yes.
The court's entering a plea of not guilty, as I've already indicated on your behalf, scheduling this matter for probable cause conference on May 29th.
9:45.
At 9:45 a.m. As to bond counsel.
Your Honor, as to bond, Mr. Cannoli is presently on parole for home invasion. He has been on parole for approximately 6 months. He is unemployed at this point in time. He resides at a halfway house located at 15430 Lauder Street in Detroit. He does not live with the victim at this point in time, though there has been a relationship.
I'm sorry, what's the address?
Pardon? He lives in a halfway house at 15430 Lauder Street in Detroit.
Interesting, because the part of paperwork you filled out put a completely different address on Superior. Not even the one where the offense occurred is alleged to have occurred.
Well, where?
So interesting.
Where do you live? Pardon?
It's what's on my ID is 10 Superior Boulevard. That's my mom's residence. That's where my mother lives.
Sir, when it asks for the address, it's not what's on their ID. It's where can you be found? All right, go ahead, counsel, sorry.
There is no. Okay. As it indicated, obviously, he does have some prior involvement with the justice system. We're asking for, obviously, a bond which is reasonable in these circumstances, one that he can be expected to make, so that he can contest these allegations along with that situation. Your Honor, I believe that because of the parole, he's not going anywhere, that's for sure. There is not a parole hold, as far as I know. He has been in contact with his parole officer, but not since this. And everything seems to have been going smoothly. We're asking for a bond that he can make. As I've indicated, he's unemployed at this point in time, and he's living at this halfway house, getting through the remainder of his parole, which is approximately a year and a half.
So, sir, why aren't you employed?
I'm in a working program right now, Chance for Life.
So in other words, at this halfway house, you're also going through job training?
Yes, that's what I just started maybe like a month ago. I'm in job training right now.
And sir, the matter in Calhoun County, who is the named victim in that matter?
I'm sorry, excuse me?
The matter in Calhoun County, second offense domestic violence, who is the complaining witness or the victim in that matter?
In Calhoun County?
Battle Creek?
The incident that happened last time, or it was with Kimberly LaRose?
Okay, we still missed the Rose. Okay, and the home invasion that you're on parole for?
Yes.
Whose home was that?
I'm not sure. I don't know the person's name, or I didn't know the victim.
Okay, and so interestingly enough, that was in 2016. And then in 2021 is when you were charged with domestic violence second offense. And so were you paroled? And then you had a parole violation, you were back in custody and you were re-paroled?
Yes.
There we go. Well, it shows on here that he was sentenced to 3 to 15 years in 2016, and the matter in Calhoun County occurred in 2021. So that, and then he just has been paroled 6 months ago, so I was confused as to how something happened in 21 if he was out in custody, but he was not in custody. And so, sir, were you back in custody as a result, it was a parole violation?
Yes.
And are you not required to have employment, sir? As a,
yes, ma'am. Yes, I am, yes.
And sir, you don't have a license.
No, I don't.
And somehow you ended up here from the home in Detroit. Detective asked to bond.
I think it's more than reasonable, Your Honor. $25,000 cash for the UTA, for the bond, domestic, et cetera. No operator's license. No contact with the victim or the family of the victim and or witnesses in this matter, please. Not to return to the address of 264 Superior Boulevard, apartment number 1, and not to drive unless valid license in possession. Thank you, Judge.
Do you and Ms. LaRose have any children in common? So 0 reason to have contact with her. Given the defendant's current parole status, that he's violated parole before, given the nature of these charges and the concern this court has for the safety of the public and Ms. LaRose, and for the defendant's inability to, it appears, follow the laws and the rules surrounding his parole, the court is going to order a $500,000 cash 10% bond, no surety, with the following bond conditions. You're not to have any contact with Kimberly LaRose or any family members of Kimberly LaRose. That's phone contact, text message, email, social media, third party, anything of the like. Do not attempt to contact her from being in custody. You're not to have any contact with prosecution witnesses. You're not to return to her home on Superior Street. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those, sir?
No.
You are to not operate a motor vehicle without a valid license, and in the event you post bond, you're not to be released without a Wayne County Jail tether, house arrest. Any questions?
No, Your Honor.
We'll see you back May 29th.
Thank you, Your Honor.
Ms. Cobal, 5 seconds.
Let's go off the record for a moment.
Okay, I'll get you next time.
And Mr. Bartlett, good morning or good afternoon.
Good day, good day.
All right, and this is for Chantal, correct?
Correct.
Okay. All right, we are going on the record in the matter of the, you're not to be released without a Wayne County Jail tether, house arrest. Any questions?
No, Your Honor.
We'll see you back May 29th.
Thank you, Your Honor.
Ms. Cobal, 5 seconds.
Let's go off the record for a moment.
Okay, I'll get you next time.
And Mr. Bartlett, good morning or good afternoon.
Good day, good day.
All right, and this is for Chantal, correct?
Correct.
Okay. All right, we are going on the record in the matter of the City of Riverview versus Beth Chantal, 25135A. And counsel, your appearance, please.
Yes, sir. Yes, ma'am. James Bartlett, P57249 from Ms. Chattel, who is sitting to my left, stage right, I guess.
All right, ma'am, your name for the record, please.
My name is Beth Chattel.
Okay, and counsel, today is a date scheduled for sentencing on your client's plea to operating while intoxicated, operating while visibly impaired. The original charge of operating while intoxicated and refusal of PBT were both dismissed by resolution reached between counsel. And did you have an opportunity, counsel, to review the report and recommendation with your client?
Yes, we reviewed the report. It appears accurate in its contents, although we did wish to allocute in regards to its recommendations.
All right, counsel, you may proceed.
So, on behalf of Ms. Chattel, I appreciate that. I appreciate they're recommending an 18-month term of probation. I believe that that's fairly high in regards to someone with her record and her standing in life. She is gainfully employed, as noted in the report. I'll try not to be too redundant. 3 children, limited criminal record. At the time of this particular offense, I know that there is a record, but she hasn't stepped in anything since 2005. She had just wrapped up a divorce, although amicable, certainly painful. This offense certainly caused her a good deal of embarrassment. I know that she's been terrified. She's been one of my medium active clients in regards to guidance. She's absolutely frightened and has certainly learned a lesson. This is not something that is normal in regards to the way that she conducts herself. She's from a good family, high school grad, has an associate's degree. The last time she consumed alcohol was this particular offense. I can tell you, I know there was a refusal on the PBT here as well. And not that you're not supposed to listen to the police or obey the request. Back in the day, in 2005, only because I'm licensed in both states, gaming it a little bit, which I wouldn't advise anyone to do, a refusal was certainly something that didn't come with that penalty. She was otherwise cooperative with the police. She didn't mean it snotty. She wasn't filing along. She was terrified and she didn't know the right decision. And so unfortunately, she plinkoed into the wrong decision here. In either event, Ms. Chattel has been a joy to work with. I don't expect any violations. When we get to it, if the court wishes, there were a couple of days where she was going to be, assuming the court would approve, out of state. I had sent a request earlier, probably about 3 weeks ago, to the clerk. I imagine that they figured that they would wait to see what the court did impose today. If you want me to go over those dates with you today, I'm prepared to do so. If you wish her to approach the probation department after sentencing, that's fine too, but I want to let you know that I had those at my fingertips. But in either event, I appreciate there has to be some type of punishment here. She has certainly learned her lesson. I would ask for a shorter term of probation and whatever the court might consider. Thank you.
Okay. And so, counsel, one of the concerns that this court has is that this is not your client's first alcohol-related driving offense. So she knows at what point how she feels at certain points as to whether or not she is capable of legally driving or not. And so that is obviously concerning for the court. And while 0.12 isn't considered the highest that this court has seen, right? In terms of the imagination, it's still, a good amount. And while I can appreciate that your client had some significant emotional stressors that may not be available not available, but applicable all the time. The court does have concerns that the court does think that your client would benefit from some of the recommended conditions that have been put forth. And what the court has concerns with is that if the court were to amend or not adopt the recommendation of probation, maybe sentence your client to a shorter term of probation, that your client would then rush through the conditions that this court would impose, where just to check off the box and not necessarily heed all the messages and the information that your client could receive. The court also will know that it has been a significant number of years since your client's last alcohol-related conviction. What the court's going to do is the court does find, after hearing from counsel, reviewing the report, the recommendation, that there is reasonable grounds to depart from MCL 769.5. The court also finds the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Chattel and the legislative guidelines. The court's going to sentence your client to 12 months probation. You're eligible for early discharge. I'll go over that shortly. You're not to violate any criminal law of any of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer, as often as your probation officer may require, in person, writing, or virtually. You're notified probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you providing coping mechanisms so that you can maintain sobriety and hopefully prevent this matter from happening again in the future. The court's going to also order you to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so that you can further understand the danger of driving while under the influence and to re-educate yourself regarding the consequences of such behavior. The court's going to also order 80 hours of community service. The rehabilitative goal for that condition is to help you further develop life skills and get back to the community. Any questions regarding those conditions, counsel?
I just wanted to double check that it was 80 hours of community service, Your Honor?
Yes.
Okay, thank you.
Okay.
And earlier I had inquired about dates that she was hoping to be out of state. Would you like her to address those now, or you want her to address those with the probation department?
Well, first let's, I'll address that when we're done here with the fines and costs. Any questions regarding the terms and conditions?
We understand them.
Okay. As the fines and costs, $300 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month or 12 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. So that's a total of $1,425. There is a personal bond, so there's not any bond to apply. Do you have any other money that you can pay today, ma'am?
How much of that can you pay today?
Pay all of it. I mean, do I have to go up to the courthouse or is there a way to pay it online?
Do you have an online payment system, correct, Your Honor?
We do.
She can pay the rest of it today.
Okay, so let me just clarify that, it would be $1,125 because since you are eligible for early discharge, we do not collect that upfront.
Got it.
All right, and as I did indicate, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making your payment. When are the dates of travel, counsel, that your client, when's the first set of dates? The first set of dates?
It's one date, May 28th, Toledo, Ohio, for her daughter's Mud Hens baseball field trip. School field trip for a baseball game.
During the day?
And I'm sorry?
That's during the day?
It is.
Okay, that should be fine. What's the next date?
June 16th through 22nd, a family vacation in Tennessee. I'll be honest, I forgot the city.
Bean Station, sorry.
Bean Station?
Bean Station, as in like green bean?
Like, yeah, I believe it's Bean Station, BEAN Station, Tennessee.
And who will be traveling there?
My sister lives down there, but not in Bean Station, but it's my mom and it's a family vacation. So my mom, my stepdad, my brother, my sister's meeting us there. We have an Airbnb.
And I can confirm it is in fact Bean Station, 2 words, Tennessee, Granger County.
Okay, so long as there aren't any violation of probation between now and the date of travel, that would be permissible.
There was one more. There was one more, yes. Assuming you approve August 16th through the 17th, Woodstock, Illinois. She was hoping to visit a college friend?
Yeah.
College friend.
That's graduation.
That doesn't sound like a recipe for reliving college days.
Well, it was for her son's graduation party. But that's fine.
If you're any better. All right, so council, at this point, I'm going to approve these two. I'm not saying that she won't be approved in August. I want to wait and see, as long as making sure she's compliant and following everything, no violations, and then we'll revisit August. I'm not denying it, but I'm not.
Understood.
I'm not approving that at this point.
Fair enough.
Okay.
Thank you.
All right.
And Wyandotte is not my everyday food. Should she touch base with the probation department today to go over those, the order of probation, or how do you work it there? I'll make sure she gets the money paid today, but does she need to contact probation?
Yes, I'm going to have her email in by 2 o'clock and they will get her set up with an instruction date, okay?
May I have that email so it's at my fingertips?
Well, you can email the one that you received the report and recommendation from, or you can email into 27dcprobation@wyandotte.mi.gov.
Wyandotte.mi.gov. All right, we'll take care of that.
Okay, thank you. All right, let's go off the record.
And then are we free to leave, Your Honor?
Yes, you sure.
Thank you.
Have a good day. Okay, hold on. All right, good afternoon. Which matter are you here?
Good afternoon, Your Honor.
Which matter are you here on?
Excuse me?
Which matter are you here on?
For rent, to avoid eviction.
Okay, is the lease in somebody else's name?
I'm on the lease as well, ma'am.
Okay,
Your
who's the
Honor.
other person?
Excuse me?
Who's the other person? With you?
Francisco Tinoco.
Okay, so Mr. Katz, this is for one of yours.
Okay.
So,
I'll talk to her.
Breakout room 1.
Okay.
All right, and then let's go on the record in the matter of the State of Michigan versus Ariel Keenan, 25370.
Afternoon, Your Honor. William Winters, P35975 on behalf of Ms. Keenan.
Thank you, and Ms. Keenan, your name for the record, please.
Ariel Keenan.
I need you to speak up, please. I'm recording on here, so I need to be able to hear you.
Ariel Keenan.
Okay, and so today's date scheduled for sentencing on your client's plea to an amended charge of controlled substance use. The original felony of possession of controlled substance was dismissed by way of resolution by counsel at the probable cause conference. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. And we have no additions or corrections to make with regard to the pre-sentence report itself, but the recommendation we'd like to speak to.
All right, and counsel?
You know, I think Ariel Keenan recognizes that she's got a substance abuse issue, and she's already been in treatment at least once. And you'll notice that she's trying desperately to try to get her children back. And she's really on the final path to try to make that happen. And you can see that she's a high school graduate and that she's got a good job at Five Guys. And part of this treatment that she's been involved in has been paid through either insurance or a third-party insurance. She also has, you might know, that she's got a case pending downtown, well, 5301 Russell Street. And we're in the process of negotiating a settlement in that case that will keep this young lady out and treating and in a position to try to get her family back together. So the court has several options, obviously. Because it is abuse, she accepted responsibility for Your Honor. And that's always the first step toward rehabilitation. You know, from a financial point of view, she really doesn't have a whole lot of assets or resources. Other than, you know, she's got a job that she maintains. So I respectfully ask the court to either consider perhaps placing her on 7411 status or delaying this sentence for about 6 months, 9 months to see how she does. And then the court's certainly free to take whatever actions the court feels appropriate.
Well, counsel, 7411 doesn't appear to have ever been on the table in this matter. However, Ms. Keenan, are you interested in drug treatment court?
Yeah.
Have you explored that at all? You spoke about it with your attorney at all?
No, I don't even know what that is. I know that from my understanding, from what you just said, it's something about dropping, which I do twice a week.
Oh, no, it's much more than dropping.
Okay.
What it is it's a much more intensive oversight probation, specifically for individuals with addiction issues.
Okay.
So you meet a lot more directly with the judge.
Okay.
And there's also the option we have based upon the report here, you may be eligible for the treatment court that we have here. We have a regional wellness and recovery court, so it's a mental health court. And so there are some individuals that are dual treatment, and so we handle both the addiction and the mental health portion of that. So that's something that if you're interested in, we can adjourn the sentencing so that you can defer and determine whether or not you are eligible, and in addition to that, whether or not that's something that you are interested in doing.
I think it's an excellent suggestion, Your Honor, and I ask respectfully that you allow counsel and Ms. Keenan to investigate, especially because there's a mental health aspect, particularly timely that March is Mental Health Awareness Month.
May or May, but you're correct.
Or May, right, yeah.
I do the same thing.
Still behind. So yes, Your Honor, we'd ask that you consider setting this over.
Okay. So let's adjourn this. Let's adjourn this to June 10th. That's 3 weeks. That should be sufficient time for eligibility screening. So you'll do a criminogenic and then a clinical screening. So what I'm going to do is I'm going to, for right now, adjourn it to June 10th. We'll do 1 p.m. If that's not enough time, then it will be rescheduled. All right, I'm going to order bond and conditions are continued. And then we will see you back then. I'm gonna have you go over to probation. And they will get you in contact with Courtney, who is our coordinator and probation officer for the program, okay?
Yeah.
All right, so just have a seat over in probation. Somebody will be with you shortly.
Thank you very much, John.
All right, thank you. Have a good day. All right, and Mr. Katz, we will be on the record in the matter of Southgate Apartments, First Francisco, Tinoco, 2500731. And counsel, your appearance, please.
Good afternoon, Your Honor. Sidney Katz on behalf of.
Okay, and Ms. Maldonado, your name for the record, please.
Susanna Maldonado.
Every day in the USA, people find themselves in court.
All right, this is 250000901 and 902R, People of the City of Troy versus Celine Brown.
Julie Dupont, on behalf of the people of the city of Troy.
Good afternoon, Your Honor. Also, Rumba Nation here on behalf of Mr. Brown, who is approaching from my way.
State your name, please.
Celine Brown.
Mr. Brown, are you still using the address on Orleans Street in the city of Detroit?
Yes.
Today is the date and time that's been set for sentencing for Mr. Brown. There was a pre-sentence investigation that was completed and a report was generated. Did you review the report with your client?
Yes, I did receive the report and I went over it with Mr. Brown. There are a couple of corrections that we would like to make on the report.
Sure, go ahead.
In the drug use section of the report, it stated that the client smoked marijuana occasionally, about 1 time a week, if I'm not mistaken, or on the weekends. He stated that that was in reference to when he was 18 or 19 and around his first use when he was using marijuana. He has not ingested marijuana in over 10 years, which is, that's what it says for DFAS. So verification, that's how regularly he used when he was about 18 or 19 years old. He does not ingest marijuana.
Okay.
Secondly, in the selected substance abuse responses, in one of those responses, it states that the client stated that his family and friends have complained about his drinking. He states that on that specific note, he meant to say no. He believed he said no. His family does not complain about his drinking. He states that he keeps that pretty secretive, so his family and friends, or at least outside of his close friends, don't know about his drinking. So nobody has complained about his drinking. Those are the only 2 corrections to be made on this report.
Okay. All right, we note that.
Thank you, Your Honor. I was waiting. So Mr. Brown has a pretty impressive background. He's worked 5 years, being able to maintain work as a supervisor for Dakota Integrated. He's done community work over 10 years, volunteered for various organizations. He's taught at schools for about 7 years between 4 different schools. He's coached. So he's been pretty ingrained in the community. He has a business and electronic repair that he started back in 2015. He's been going to a therapist. I think Turner is her last name. He's been going at least once a month via video call. He stated that, these matters in terms of what happened and what was put in the sentencing report, Your Honor, was that he parked so that he would not, put anybody in danger, put himself in danger at Tim Hortons. By the time police made contact with him, he was in the parking lot, his car was off. When police did make contact with him, he was not in the most flattering of disposition, and that's what led to this. He did accept this plea knowing that there was going to be some type of consequence for it, and based on his answers that was put in his sentencing before, Your Honor, he does at least acknowledge that he does have a relationship with alcohol that is not healthy for him. He does understand that drug treatment court would be the best for him. That is what he would like to do and have a recommendation of. He does have prior alcohol-related offenses that show an indication of this unhealthy relationship with alcohol, which is why he has been amenable and agreeable to doing drug treatment court. Mr. Brown states that this has been an eye-opener for him because this has put him at risk in terms of his occupation, his career. He understands the risk that this could put for his health long term, and if he were to drive while intoxicated, what this could do to not only himself but drivers around him. And he wants to be able to continue to to rectify the situation and make better decisions moving forward. One issue that Mr. Brown does have is the amount of testing that is recommended, with it being 10 times a month. He's not saying that he shouldn't be tested at all. That's the reason why he's here. He ought to be tested, but that puts a very significant financial strain on him, and he does not want to be put in a position where he's just set up to fail, essentially, just due to lack of finances. He would like a reduction in the number of times that he has to test a month, just to be able to make it through the program and make sure that he can at least take care of himself while he is going through probation, which has been recommended for 18 months. I would also like to ask that he has a reduction in terms of any drug testing, because he has not ingested any marijuana. That was the only reported drug that he has ever taken. He has not had it in over 10 years, and if there is any signs of intoxication due to marijuana by the probation officer, that it be requested at that point, but mandatory testing, I don't think is appropriate if he has not had any marijuana and marijuana was not related to this matter. So all the other factors that are included in his recommended terms, Your Honor, I would say are appropriate, but I just don't want him to be put in a position of where he has to test so often and then he just can't, and he's coming back here for violations, essentially for poverty reasons.
So there's a participant agreement that normally he would be reviewing in court and signing, and then they go over it with him when he goes to probation if he's placed into the treatment court. My clerk normally makes sure that that's sent over, but I don't know if it was received here. He can go over it with the case worker or the probation officer that he would be assigned to in a treatment court if that's what we decide to do today. But I was given the impression that he went over the manual or was given the manual, so he has some sense of the basic requirements of the program already. Is that a true statement?
I only got attached to him at the sentencing, so
Sure.
I was not counseled throughout these matters, and I don't know what was put in his agreement or if he received.
Yeah, so we really require, if somebody comes in and whether they're asking to be screened for the treatment court, or we identify someone that looks like they may be a good candidate or an eligible candidate for the treatment court, when they go through the PSI process, they're directed to a court probation officer that works in the treatment court. And then that person's responsible for at least giving them the manual, answering some questions, giving them some basic guidance. So you wouldn't have been a part of that process really either way, but I wanted to make sure, because I thought I saw it referenced in the rationale portion, that you were given the manual and you were at least given an opportunity to review that. Is that true?
Yes.
And just so you're aware, the testing requirements in the program, I don't want to say that they're the same for everybody, because they're not. everything about the program is individualized, but there are standards that everybody follows, and the standards for the program at the beginning, really testing at a minimum of 2 times per week. So that wouldn't be something I would change here, but I did see, because he's been using an alcohol tether, they are also open to considering the idea that he just continues on that for a period of time. So the good thing about being in the treatment court, if that's what we decide to do, and I need to hear from you still, I don't have to get from the bench really detailed about exactly the testing requirements to a T, because in the treatment court, it's much more fluid, but I want to be very clear so he doesn't have an unrealistic expectation that at the beginning of being in the program, the testing is gonna be high. And if we have concerns about traveling back and forth to get to a testing agency on a number of occasions, it sounds like there's no issue with him continuing with the tether. So that could be an option. But from where I sit here today, I'm just going to tell him that he has to test in accordance with the program requirements, and they will tell him what it is. I just don't want him to be under the impression that it's going to be something considerably less than what's recommended as he gets going. Does that make sense? You understand that? You've got another court case with a court date coming up in July. Do they have any awareness about this case?
Somewhat, not really, no. They are, yes, they will be aware. I have a probation hearing in a couple of weeks, so.
Okay.
I'm gonna go to in person.
Okay.
But I was in between probation officers for some reason, and that's why that month between March and April, I had a hearing in April for end of the probation, and come up with the probation officer.
Okay. So obviously you'll be expected to keep us apprised of what's happening there, and this court can't control the outcome there, but if you are committed to this idea that you could be in a treatment court program here, that might make a difference. You went over the rules and regulations just in a general sense, and you understand with the program, you don't get to be eligible for early discharge on a certain date. You go through the phases of the program and you graduate, correct?
Yes.
And although I'm sure you'll have a lot of questions, and we are making some adjustments actually, potentially at this point to some of the phases, so they may look just a little different. I think it would be to your benefit, but you have a general sense of what you're going to be expected to do in this program.
Yes.
You are eligible. You met all of the assessment requirements that we need to consider somebody. Is this something that you at this point would like to be considered for?
Yes.
Okay. I really think it's a good choice. I don't know that much about you yet, but I know that you've obviously had contact with the criminal justice system on a number of occasions related to the use of alcohol. So this is something that's been going on for a long time. You did meet all of our assessment requirements, someone that's been determined to be high risk for additional OWI offenses, which is really what we're trying to avoid. And I think that this structured program is probably going to be the best chance at success that you have over jail even, which at this point could significantly be a consideration for the court when you're on probation for another drinking and driving offense and you pick up another one. I'd like to give you an opportunity to see what can happen in the structured setting of the program. So I'm glad that this is something that you're willing to consider. And I'm going to sentence you today in accordance with the requirements of the program. It's an 18-month reporting probationary term in the treatment court program. I've just advised you, you agree to participate as you go through the phases and then graduate. It's actually not, the program itself is not a minimum of 18 months. So this needs to be corrected. But your probationary term is that 18-month sentence. I have placed the reasons on the record why I believe I have reasonable grounds to place you on probation, 1 day of jail, 1 day credit. You will also be participating in both substance use disorder and or mental health treatment if appropriate. I know that you were given some information about your current treatment provider and why you may need to be evaluated by a different treatment provider, but we'll ask you to follow up on those requirements of the program and then report back. Support group meetings, I didn't have record that you were attending support group meetings at this time on a regular, frequent basis. Is that wrong?
I've been attending support group meetings, however, she, she said there wasn't accurate enough, area 33 support group is virtual. So I was provided in the packet, the actual site or how they can record it. It's recorded.
So there will be some changes for you as it relates to treatment and the treatment court, the 12-step meetings, I think. But I'm not going to tell you from the bench, you have to go to one meeting or a different meeting. A lot of what you'll be doing at the beginning, though, will be more in person. So that may impact what you currently have in place and require some changes on your end. But the main goal that I have for you is to get the treatment component in place. And then the other things will flow from there, including the type of support group meetings you're attending and the frequency that you're going in a week and how you'll verify. The weekend program will be required. I'm not going to tell you the specific time frame that needs to be done within. It'll be at some point in the program. No alcohol, marijuana, illegal drugs, or drugs without a prescription. Testing is going to be required, and I will leave it either at a suggested random testing schedule, or if you keep the tether in place for a period of time, that's going to impact testing. So that's something that can be determined with the probation officer and the team, which will all weigh in on what may be appropriate. No liquids before you go to test if it's a urine screen. No driving without a valid driver's license and insurance. You would be required to be fingerprinted, but that's already been done. I will be asking you to document what you're doing for your employment, but that's not something that's required monthly beginning at your very first appointment. We'll talk to you about that. Follow all the conditions of the program and probation. The fine is going to be a $300 fine. Court costs will be $300. You have state mandated assessments of $125. Your probation assessment for the drunk driving offense is $110. There is a program fee, but that's in part why I looked at reducing some of the other fees, so it's $250. You'll have to pay monthly for probation at $40 a month. You just pay that as you go. Cost recovery to the city of Troy for the manpower that was utilized on the night of your arrest or the time of your arrest, I should say, $337.28. Any objection?
No, you're on by statute. That can be next.
A lot of information. They're going to give you everything in writing. They'll get you set up to meet with the probation officer in the program, and then they'll direct you. I'm not sure if they're going to require you to come in tomorrow. If they'll have you come in at the next session, but they'll go through all of that with you at the front counter. And then over in probation.
Just very quickly, Your Honor, I know that at this point that Mr. Brown has, in order to keep it separate, that has been one of the main reasons why he has struggled financially. Could he test instead? I think even at 10 times a month, that would be cheaper than what.
I have no issue with that. I've left it completely open-ended.
Okay.
So you can go when you meet with, I'm assuming you'll see Ms. Saylor today or somebody in probation, and they will facilitate how that change is going to take place if that's what we're doing. Okay? Thank you. And then are we ready to recall Grady?
Yes, sir.
Recalling City of Troy 25001158 and 1159. The people of the City of Troy versus Stephen. Is it Stephen or Stephen? Stephen Grady.
Julie, you're going to be having the evening, so just go.
State your name.
Oh, Stephen Grady, sorry.
Today, we've already discussed the fact that this is up for pretrial, and it sounds like the parties have had an opportunity to discuss the case. How are we proceeding?
We did, Your Honor. Thank you for that opportunity. At this
See, Mr. Burbank on Renisha Chason. Morning. Morning. Good morning. Are you Renisha Chason? And so Ms. Chason in cause number 19-33107 is on probation for burglary of a habitation. Motion to revoke that probation has been filed. And then in 24 DCCR 2351, charged with injury to a child, elderly, or disabled individual. And Mr. Burbank has filed a motion asking that I set a bond, just in the motion to revoke case, correct?
That's correct. If she has a bond in the other one.
Let me look real quick.
This is the one judge that we held last week, getting the co-defendant to rest. The marshals were able to take him into custody.
Okay. Okay, perfect. So, is it the state's position then that this would be an appropriate time to go ahead and get something set then?
I'm not necessarily opposed to that based on the conversations that we've had with Mr. Burbank. Spoke with his client. I did ask that we appear this morning rather than just trying to agree to something, so that we could request that there are some pretty specific conditions on both of those bonds with respect to her not being around any child under the age of 18 having a GPS. I don't know that there's substance abuse issues, but I don't know that a drug catch might not be a good idea, maybe for at least the first 90 days or so, to see there's a tremendous amount of drug use in underlying offense and with the code.
Let me look at this administrative, go back a little.
The only thing would be, Judge, is GPS is $300-400 a month. She has ties to the community.
Let me look at what the allegations are. Primarily, it looks like, I guess, the main allegation in that motion to revoke is the new offense.
There was a small child in the house that did some illegal substance while she was at a hospital, visiting her father. The co-defendant and another individual was in the house. But she is bound.
Where is the child now?
With my aunt.
And is that through CPS, a placement through Child Protective Service? And where will you live if you make bond?
With my aunt Shirley.
Is that a different?
No, a different one. My mom's sister. She's with the dad's aunt.
Okay.
On her dad's.
Okay.
That's her grandmother's sister.
Gotcha.
Do
you have other children?
Yes, my oldest, she's 8. She's with my older sister. My sister died.
Okay. And is that it? Just the two?
Yes, I was supposed to sign on the 13th. I told my CPS worker that I was going to be in jail on the 13th, and she was supposed to come see me. And they said if everybody was in agreement, I was supposed to keep my rights, and the judge she still hadn't come see me.
So you're going to have two different things going on with regard to your kids, obviously. If you have family law issues with regard to CPS and down in family law court, that's one thing. Any conditions that I give you on a bond or through your probation are going to override that, at least for now. So even if they say you can have visitation or certain things, if I say you cannot, then this is going to override that. You understand? Okay. Let me look at one more thing real quick before I set an amount. Mr. Burbank, are you requesting a specific? It looks like there was a bond forfeiture in the new offense. So is that currently at $100,000 bond?
And I asked it to be put back to the original judge. When they issued the warrant on the MTRP, they got off the bond, the original bond, the bail bondsman. So I'd ask that be placed back to the original amount the court.
There was a bailiff's call. She didn't show up for court. It wasn't an AFRS or anything like that, or a release.
My understanding was the bondsman got off. It wasn't an AF, because I had conversation with somebody.
It looks like on April 15th of this year, there was a bailiff's call and then a bond forfeiture issued. Right? Look at me figuring this out all by myself. Wrong. So yeah, you didn't show up for court on April 15th.
I think that's when there was a warrant from the PRP judge, and she was trying to get her affairs in order. I think I was there, I was just tired at the time, was my motion filed.
Well, you don't get to not show up.
The case was indicted before the motion was filed, which is typically goes in the reverse order. So the case was indicted in November, the motion was filed in December, and then that must have been her appearance date in CDC before the case was transferred over.
Oh, because we just got it when?
Just relatively recently. The co-defendant will be set July 1st. Ms. Holmes.
The bailiff's call was here. It was, yes, it was. It was my bailiff who made that bailiff's call. So it had already been moved at least to here by April 15th. So, all right. So what I'm going to do in cause number 19-33107, I'm going to grant the motion to set a bond in that case, which is the motion to revoke case. I'm going to set that bond amount at $35,000. Several conditions of that bond, obviously, that are very important. The first is that you are not able to, I'm not going to allow you to have contact with your children or any children for that matter under the age of 18. So where you're going to be living, are there children there?
No.
Okay. So you'll be required to reside in Jefferson County. And what is your aunt's name again?
Shirley.
Green?
Yeah.
Okay.
Or it might be Pre-Jean. It's her married last name.
Okay. But you know who I'm talking about,
Yeah,
if that's where you're gonna live, right? So I'm ordering you to stay there. So if you have some issue come up where you need to move for some reason, you need to talk to Mr. Burbank and you have to get my permission to do that, okay? I'm not going to order the GPS at this time, just due to the cost, and as long as you're living where you're supposed to live, CPS is involved too, so I think they'll be keeping an eye on the kids. I am going to order that you wear a drug patch. You'll be required to get that within 24 hours of your release. If you make your bond in your cases, then you will be required to have a drug patch put on within 24 hours of your release. That drug patch, you have to get changed every 2 weeks. Your bondsman or Mr. Burbank can let you know where you can get that. Obviously, if you test positive for anything, you're going to be right back in jail. If you don't get it tested for some reason, I'm going to assume you're positive. So it's very important to keep up with that so that I make sure that there's no underlying issues while you're out on bond, okay?
Is my probation officer here?
I don't know that they're here today, but the first thing you do also when you're released is go visit with them, make an appointment, go talk to probation because you're still on probation.
I haven't heard from her. I had my mom call me, but
Yeah.
she's like on person.
Well, and they may be waiting to see what we're doing on this, but you need to definitely, if you make your bond in your cases, go visit with her. So I want you to tell me why you didn't come to court on, before I start looking at that other case and doing anything with that bond, the new case, why weren't you in court?
I had just had surgery under my arm. Prior to wound care was coming to patch my arm. I had a 8 centimeter abscess under my arm.
When?
March 22nd, but I had to take antibiotics for like almost over a month to like April 24th or 25th. And my incision it was 2 incisions very deep under my arm.
Did you let Mr. Burbank or anybody know that? Or you just decided that you weren't going to come to court?
I called the secretary, but I didn't talk to him myself. I just spoke to the secretary.
You see what happens when you can't just not show up to court.
Yes, ma'am.
No matter what's going on in your life, right?
Yes, ma'am. Thank you.
Don't thank me yet, I'm not done. So, in 24 DCCR 2351, there's really not a motion, but based on everything else that's going on, Ms. Malfino, do you have an issue with me reducing that bond down? some. I'm not gonna reinstate it. It's already done and gone, but I will, reduce the bond in the new case to $35,000 as well. The same conditions apply. Remain in Jefferson County with your Aunt Shirley, no contact with any child under the age of 18, and you must wear a drug patch. You're obviously still on probation. You need to report, do everything you're supposed to be, stay in touch with Mr. Burbank, don't miss a court date. If you miss a court date or you test positive, then your bonds are both going to be probably at an amount where you're gonna wait for everything to happen in jail. Do you understand? Okay, all right, well, let's reset the case for an announcement then. Yes, thank you. Where do y'all want me to write that on the, for the case that I didn't really have anything? Mr. LeBlanc, are you ready on Mr. Fontenette's case? 23 DCCR 2079. Okay. So, well, let's get him out here.
We were here last week,
Yeah.
Your Honor.
All right, sir, you're Preston Fontenette?
Yes, ma'am.
So, Mr. Fontenette, I was able to kind of take a look back and get myself up to speed on everything it looked like that happened. And what I see is that you were here and entered a plea of guilty to unlawful possession of a firearm by a felon. We reset your case for sentencing. When you came back for sentencing, I tested you and you tested positive. Or was it at the plea? At the plea, you tested positive. That's right. And so I revoked your bond, put you in jail pending sentencing. We've got the pre-sentence report. And then the problem with that is that you say you didn't do it. So I guess what's everybody's position on trying to go forward either with a plea, or do we just need to set it for trial? I know you want a bond, but I want to know where we are in the case before I consider that.
Setting the bond aside, I would like to ask to revisit that sentencing and
I mean, have you
change.
talked to Mr.
Yes,
Fontenette?
I have, Judge, and that's what he wants to do.
Here's the thing, you either did it or you didn't do it, right? And so you can't come in and plead guilty and then say, well, I didn't really do anything wrong, I just took a deal. That's not how it works. Either you were in possession of it to some extent, and there's different levels of possession, but if you knew about it and you knew that it was wherever, I don't even remember now, in the car or
It
in
was
the.
kicked under a vehicle, Your Honor.
Oh, yeah, I remember this one. So, I mean, either you did that or you didn't do it. So,
I had a few words with Mr. LeBlanc. Actually, I told him I believe it was a misunderstanding. I got like question mixed up.
okay,
And he's talking about a misunderstanding.
with the PSI, not with what happened.
And it kind of like. It went-
Did you do it?
Yes, ma'am.
Okay, I mean, you dropped the gun, you kicked it under the car, you had a gun, you weren't supposed to have a gun, is that right? Okay, it's not that hard to say. Did I already
believe you rejected it.
Did I already reject it?
Yes, Your Honor, you did. We pled in March. When he
Okay.
was taken into custody, it was reset for sentencing in the middle of April. He rejected the plea at that time.
All right, do some more paperwork.
Yes, ma'am.
And then I'll recall it as soon as the paperwork's done. And obviously, we won't need a new pre-sentence report. Nothing's changed since the time since he's been in
Just that
custody.
sentence. That's changed.
Just,
That's where he said he did.
yes, yeah, just that.
Thank you, Your Honor.
Yes, sir. Good morning, Mr. Gertz. Are you ready to announce on Chad Holland? But if you violate, like I said, you'll be right back in here. You can be convicted and you could go to prison for anywhere between 5 years and up to the rest of your life in prison. You understand? All right, take advantage of this. Good luck to you.
Thank you, Your Honor.
Yes, sir.
Let me chisel this from there for a moment, Your Honor.
Okay. Mr. LeBlanc on Preston Fontanet.
It could be a future of you didn't tell me, I told you so.
Do what?
With Cora Thomas, in the future, it could be a you get to tell me, I told you.
I know, right? Every now and then it happens that way. Every now and then.
But
All right, so this one, he pled to counts 1, I guess.
paragraph 1 contains a.
Count 1 previously, so we're just gonna go through that again. All right. All right, will your client waive the formal reading of the indictment?
I'm sorry.
Will he waive the formal reading of the indictment? Mr. Fontanet, in cause number 23, DCCR 20, sorry, something just popped up.
2079.
I just had stuff start coming on my computer. 2079, the state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of unlawful possession of a firearm by a felon September 29th of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes.
Also, so the agreement is the same as before. It's a 10-year sentence in prison that would be probated. You'd be on probation for 10 years. Fine, was there a fine?
$1,000 fine.
A $1,000 fine, and you would be required to follow all of the conditions of probation. Is that your understanding? Speak up, please.
Yes. Yeah.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objection, Your Honor.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
None that I'm aware of.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. We've already gone over the pre-sentence report. Is there any reason not to go forward with sentencing?
Not in light of his renewed plea, Your Honor.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and your probation revoked, and you would be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. LeBlanc. All right? Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Jeremiah Johnson, Mr. Parker. Oh my gosh, I'm gonna need, y'all wanna, did y'all print any of those? Jeremiah Johnson by chance? It's got 4 cases. On Johnson's cases, are we going on the indictments as they are, or are there changes? Mr. Kimler, you have Christy Capel. Oh, do you need to, is it a sentencing?
Not that one, just saying.
Okay. Christy Capel?
Morning.
Morning. Morning.
Judge, can you just see real quick, is somebody in the waiting room? Zoom?
No.
Okay.
We should hear it also when it goes off, I would think. Yeah. All right, you're Christy Capel. So we were previously here, a reset sentencing to figure out something maybe about restitution. Where are we doing? What's the status?
Restitution is paid.
The restitution's paid in full.
I think it was $22,426.
So Ms. Capel, in cause number 22-40550 and 24 DCCR 0137 on deferred probation for each of those state jail felony offenses, pled true already in motions to revoke to counts 1 through 5. I received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Any additions or corrections to that report?
Just that the restitution is paid in full, Your Honor.
Okay.
I don't think that was reflected in the report.
Okay, thank you.
Nothing from the state, Judge.
All right, and there was no agreement, correct?
Yes, Your Honor.
Mr. Kimler, you may proceed.
Yes, Your Honor. Ms. Capel, I guess you're looking at the pre-sentence report, you can see that she has limited, if any, criminal history. She received deferred probation originally on these cases, obviously, and part of that, I assume from the state's perspective, was to get the restitution paid and give her an opportunity to do that. She has complied with that provision of the probation. She has, how you can phrase this, I'll just be blunt, she's really failed abysmally at probation. I don't think she has received any new offenses, but as far as complying with reporting and those types of things, the administrative aspects of probation, has failed to comply with that really abjectly. The question that arises, I suppose, in a case like this, and in other probation cases where people have received deferred and then violated the terms and conditions where it amounts to a motion to revoke probation, what now is the proper sentence that she should receive as far as the probation itself? To my mind, to me, logically, one would look back at the original case and assess it from the standpoint of what its facts and circumstances were at the time of sentencing. And in the event that she didn't take deferred adjudicated probation at the original sentencing, what would have been the appropriate sentence as far as punishment, as far as incarceration? Would it be the type of case that would be amenable to a 1244 A or B? Is it the type of offense that would require, in light of the restitution, if restitution wasn't an issue, how much state jail time would be appropriate? Is that the way the case should be evaluated for punishment at this point when somebody's failed on probation, or should she receive some sort of additional sanction on top of what that punishment would be because she's failed at probation? Are people punished in addition on the sentencings because they failed at probation? Does that entail an additional punishment? And I would suggest to the court that it shouldn't in her case. She hasn't received any new offenses. She's paid the restitution. So in looking back at what an appropriate sentence would be on the revocation, one should look at the case as it was, and the circumstances as it was when she received the deferred, and the court should ask itself, well, what would be the appropriate punishment if she hadn't taken deferred at that point? And I think in looking at that, the court hopefully would agree that a 1244, I would say 1244B, where she doesn't have the felony convictions, but certainly a 1244A is appropriate that actually convicts her of the state jail offenses, but would give her the county jail time of 180 days, 180 days state jail, or 180 days county with the state jail conviction, although I would hope that the court would consider 1244B, where she would just receive the misdemeanor convictions. That would be in line with what the facts of the case were at the time that she received the deferred. Now, obviously, she hasn't done much on probation other than pay the restitution, but should she receive some sort of additional sanction or punishment for failing at probation, separate and apart from the underlying offense? And I would argue to the court that in this circumstance, that would be inappropriate, that a 1244 would be the proper way to proceed.
Mr. Coleman?
Thank you, Your Honor. I'll be brief. This is one of those rare instances where Mr. Kimler and I agree she has failed abysmally at probation, Your Honor. Those were his words, and I join him in that sentiment. Judge, she's only paid the restitution now that an MTRP is hanging over her head. She's essentially done nothing since she was placed on probation. She goes on to probation in June of 2024, and she's not reporting the very next month or two after that. She's done nothing in the way of satisfying the conditions of her probation. Conditions, Judge, that are not recommendations by the court or suggestions by the court. It's your order. You've ordered her to do these things, and she just disregarded the court's order. Even more than that, it is a waste of time, a waste of resources that could have been devoted to another defendant or defendant's judge. And based on that, I'm asking the court to revoke this defendant's probation and sentence her to no less than 12 months in the state jail.
And I would just respond, Your Honor, briefly, is would 12 months have been appropriate when she originally pled?
Well, I don't know that I agree that, and I think it's a case by case situation, but where we give someone an opportunity, where I give someone an opportunity and resources that someone else could have taken advantage of, I don't know that I agree that it should go back to what it originally was. You had an opportunity, and there should probably be punishment for what you did and possibly something for what you didn't do when you were given an opportunity to not have 2 felony convictions on your record. I can tell you now, 1244 of either type is out of the question. So here's where I am. Ms. Capel, you've stated, you've agreed that you have a substance abuse issue. They tried to get you some help through JCDI. Your option today, I'm going to give you an option. 2 things. If you want to not have a conviction on your record, a felony conviction, you want to try to be successful and do better and get the tools to do better, then I'm willing to do that. But it's not going to be getting out today. It's going to be inpatient treatment through the ISF program, which is a 90-day program. Then you get out, and then you're go through JCDI as aftercare, so that you can hopefully live the rest of your life without being here and looking at go to prison. If you don't want to do that, then I'll sentence you to somewhere in state jail prison time. But it's not going to be 1244. You're not going to get to sit in county jail and do your time for not doing anything you were supposed to while you're on probation.
Would the court be inclined to indicate what the length of state jail would be to evaluate the court?
It would be somewhere in the range of what Mr. Coleman is asking for. I don't think that is an inappropriate ask.
What do you want to do? You have around, she's checking her back. I think she has around 2 months back.
The thing is, and I'm not going to try to talk you into doing something, because if you don't want to take advantage of what I'm offering you, that's fine. But here's the thing. If you want to just do your time, I get it. It's probably easier to do your time and get out. But you're going to be a convicted felon 2 times over. 2 felony convictions on your record. You're not going to be able to get certain jobs. You're not going to be able to live in certain places and apartments. You're not going to be able to vote. It's going to change your life. If you think your life is negative now because you're on probation, it becomes 10 times worse with the actual convictions. If you want to take your chance and do that, then you can. But if you get out and you continue to use, you continue to do things like steal and forge checks because you're using to try to get money to use, you're going to still be in the same place, and you're going to be back in here. Then you're going to be looking at felonies that are enhanced because you already have felony convictions. So that's my spiel. I'm trying to give you an option here today that is probably not what you want in the short term, but is a whole lot better in the long term. So do you want me to hold it for a minute? Y'all can go visit?
Yes, Your Honor.
All right, go talk about it. Let me know what you want to do. Can beg somebody to. Mr. Gertz on Chad Holland. I see it. Got it.
Show them the video.
Who, Mills?
Warren Mills.
All right, we'll reset Mills.
Thank you.
Thank you, sir. Mr. Kimler, are you ready on Christy Capel?
Yes, Your Honor.
That paperwork back, please, ma'am. All right, again, ma'am, you're Christy Capel.
Yes, ma'am.
And Ms. Capel has motion to revoke in each of those cases that we were talking about before. Gave you an opportunity to visit about what you wanted to do or what you wanted me to do, and what do you want to do? Okay, good. That makes me happy. I think that's better for you in the long run. So I'm going to find that you entered your pleas of true to counts 1 through 5 in each of your cases freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probations, but I'm not going to do that. I'm going to continue you on each of these probations in order that you enter and successfully complete the ISF substance abuse track, and that you then, when you're out, go through the JCDI program as your aftercare. And then any counseling that's necessary for whatever you're going through is going to be offered, and you need to take advantage of it. Keep these off your record, live your life again like the rest of us, and hopefully this is your opportunity to do that. You still don't have the convictions, and so if you successfully complete it, the cases will be dismissed. The other side of that, though, is if you're back in here, I will see everything that we've gone through and done. And the arguments and the offers, I'm sure Mr. Coleman will remind me of what he was suggesting, and it probably will be worse on that time. Do you understand? I'm going to hand you the trial court certification. This wasn't an agreement. If y'all will sign that real quick, I'll get it. Even though I didn't revoke, let's get a copy of that. Honestly, we don't even need that. Never mind. If I didn't revoke her, I don't need to do that. All right, so good luck to you, ma'am. Take advantage of this opportunity. And then, Mr. Kimler, are you ready on John Mayen? Bless you. Mr. Gertz on Chad Holland. I see it. Got it. 24 DCCR 1616.
No, I hear you. Leave no messenger shooting today.
I don't ever blame you for advocating for your client.
Maybe I should charge some extra for the crop. Maybe that was.
Run your shop the way you want to run your shop, Mr. Gertz.
That wasn't very nice. I guess it was nice.
Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with the third-degree felony offense of fraudulently securing documents by I'm saying the wrong, deception, but it says executed documents. Anyway, And that offense is from December 30th of 2023. Your indictment alleges that you were previously convicted of burglary of a habitation, March 15th of 2004. And after that was final, you were convicted of fraudulent use of identifying information, October 7th of 2020, and also possession of a controlled substance, a second-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here that shows that the district. What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? So sit up, get your hand off your head. Everybody sit up. Eyes open, pay attention, please. So I have a plea bargain rejection that you've signed with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be plea into counts 1 and 2 only for a 15-year term in the institutional division of the Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are?
Yes, sir.
And do you want to reject that offer and have your case set for trial? Yes, sir.
I'm sorry to interrupt you. I'd like to point out that that 15-year offer was a one-time today only offer. I communicated that to Mr. Gertz that I would waive one of the enhancement paragraphs or a couple of the enhancement paragraphs to get us to that 15 to 99 punishment range. But,
Okay.
I have every intention of proceeding on the habitual offender if we go to trial.
And y'all talked about that. And so, Mr. Holland, I want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different than this or to the indictment with the minimum 25, unless there's some new information or evidence that comes to light that either Mr. Gertz or Mr. Coleman don't know about today. Do you understand? And you want to reject that offer and go to trial. Is that correct? All right, we'll get it set on the trial docket. Mr. Gertz will begin preparation. Mr. Kimler on John Mayen, sentencing, 23 DCCR 0461. I'm sorry? I'm sorry? Yes, hold on Mayon, please. Somebody's here. Who's coming in?
We're about to tell them we don't need them because I think we have an agreement.
Okay.
If you follow, it's the recommendation of probation.
On who, what?
Corbin Thomas.
Corbin Thomas, sentencing.
The report suggested I accept, even though we essentially got kicked out of safety. It seems kind of limited though.
Okay.
It's a MTRP for messing up safety.
And he's fine with that?
They want to
Mr. Kimler?
Yes.
Well, on Thomas, y'all have an agreement?
Yes, sir.
Let's get Corwin Thomas, please, ma'am.
We could, I can just tell them that we reached an agreement. Where are they? Sandy, outside of Colton, Christian. That should be Lieutenant Perez here.
You're gonna examine him anyway?
No, I was gonna let them know. Hi, Lieutenant, can you hear me?
Can you unmute yourself, please?
We're not, it's just.
Okay, yes, I can hear you.
Hey, Lieutenant, this is Luke Nichols with the Jefferson County DA's office. We've reached an agreement, so we're not going to need your testimony this morning, but I want to thank you for making yourself available.
All right, sir, thank you.
Have a great day.
Thank you.
You too.
All right, sir, you are Corwin Thomas Jr. And Mr. Thomas, you were previously in court and entered pleas of not true to counts 1, 2, and 3 in a motion to revoke your probation. So I'm guessing we need to go back through that motion for change of pleas. Is that correct?
Yes, Your Honor. Yes, Your Honor.
Give me a second. Let me pull this up. And Mr. Thomas, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will he waive the formal reading again of that motion?
So wait,
So now, how do y'all want me to do it? If I've already revised one and I'm gonna do it again, take the original and do it again, or take the revised?
The revised, yeah.
So make another copy of the revised.
Yes, ma'am. Just so we have a paper.
Mm-hmm. All right, so there's a motion to revoke your unadjudicated probation, and cause number 24 DCCR 0542 shows you were placed on probation for aggravated robbery July 29th of 2024, and that was a 10-year deferred probation, correct? And so it alleges that in count 1, you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were on February 10th of 2025. And is that true or not true? True or not true?
true or not?
Listen to my question. True or not true? Thank you. So then, count 2 alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not successfully complete the SafeP program. Is that true or not true? Did you enter your pleas of true freely and voluntarily? And because those 3 counts are actually true. All right, and I've received an updated report before, if y'all both had an opportunity to review that report.
Yes, Your Honor.
Yes, Your Honor, we have.
And it's my understanding that everyone is of the opinion that even though you didn't successfully complete SafeP, that I give you an opportunity and send you to ISF to see if you can get through that and then hopefully be successful. Is that your understanding? Is that everybody's?
Yes, Your Honor. It's based on the probation officer's recommendation and my understanding and agreement that with his age and the severe consequences facing him if he is revoked, that a chance at ISF to get on better decision-making and a chance to actually complete.
And is it cognitive or substance abuse?
The recommendation appears to be substance abuse. I don't know. Is that what you suggest?
Substance abuse and followed by JCDI?
Correct.
Okay. You know, I could send you to prison today for the rest of your life. That's how serious this is. If you don't make it through ISF and you come back here without ever getting out because you did whatever was going on in SafeP, if that all continues, there won't be another chance. And you're going to go to prison before you ever even really get out to get on probation. So I want you to take advantage of this, because I'm going to look back at this and I'm going to probably think, why did I do this? And you don't want me to think that later, because it usually ends up really bad. I want you to be successful and I want you to take advantage of all of these opportunities, but you're going to have to go in there with a different mindset. You're going to have to get past however it was, whatever you were doing out on the streets, however you were living. If you want to live a normal life, have a family, have a job, just live normally without all of this in prison, then it's time for you to come to that decision and take advantage of this. Do you understand? Okay. So I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation and order that you enter and successfully complete the substance abuse track of the ISF program, and that you will then, when you're out, do the outpatient treatment through JCDI. All that's meant to help you make better decisions, get off drugs, do the right thing. If you do that, you still don't have the felony conviction on your record. And so you'll still be able to live your life without saying I'm a convicted felon. But if you violate, like I said, you'll be right back in here. You can be convicted and you could go to prison for anywhere between 5 years and up to the rest of your life in prison. You understand? All right, take advantage of this. Good luck to you.
Thank you, Mark.
Yes, sir.
Let me just with this.
Okay. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Hooper, in cause number 17-27896, I have a motion to revoke your community supervision. Shows that you were placed on probation June 11th of 2018 for the offense of driving while intoxicated, third or more. That was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
It's true, but I'll get.
Well, hold on. We're gonna get to the reasons or explanations later. Right now, I just need to, if it's true or not true. Okay. Count 2 alleges that you provided a urine sample February 18th of 2020 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample September 24th of 2020 that also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 26th of 2021 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
And then count 5 alleges that you failed to provide verification of attending 2 meetings per week of AANA. Is that true or not true?
That's true.
And then count 6 alleges that you're behind in your court assessed fees as of February 4th of 2021 in the amount of $2,109. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And because those are actually true?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Not really, no, ma'am.
Okay, what do you not understand?
Well, I don't know. This first thing, I've always been the safety, so I've never really been in trouble. I'm kind of a country boy, and I got a lot of medical issues.
Okay, so you understand that there's a reason that there's a motion to revoke your probation,
Yes, I do.
that you violated your probation, and these documents show me that you've made an agreement with the district attorney's office. If I revoke your probation for a cap of 4 years, which means if I follow this agreement, the worst I could give you is 4 years in prison. I could give you 4 years. I can give you 3, I can give you 2, I can continue on probation. It'll all depend on the information that I get when we come back for sentencing. Do you understand that?
Yes, ma'am.
Is there anything now that you don't understand about what's going on?
No.
I've explained all the options to him thoroughly, Judge, about he could go open to the judge, he could say it's not true and have a hearing and you make your finding.
Sure.
I feel confident he understands.
Okay, so state tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hooper's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so the probation department can do an updated report. We'll come back and have a hearing on that date. Anything that you think is important for me to know, make sure you discuss that with Mr. Parker and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
On Warren Mills, Judge, it's one we reset to get the offer. I was just informed yesterday about 3 o'clock that to get the video. And it was just ready yesterday, and Luke brought it to me this morning, so we can have a short reset so I can show him the video.
Who, Mills?
Warren Mills.
All right, we'll reset Mills.
Thank you.
Thank you, sir. you. Mr. Kimler on Peyton Woodruff.
That's a motion to reduce it.
Bond.
Essentially, you get the.
Late yesterday, but thank you.
So why she just not a tag and refund?
That's okay. I'll, is it in both cases?
It's, the 100,000 is in one case, the other bonds are ballpark.
I'll call it one,
Right.
but then the state filed something in both.
Gotcha. All right, are you Peyton Woodruff? And Ms. Woodruff, in cause number 25 DCCR 0426 is charged with robbery. And in cause number 24 DCCR 1710 charged with burglary of a building. Mr. Kimler has filed a motion asking that I reduce the bond in the burglary of a building case. And it looks like the state has filed.
Just filed a couple of responses, Judge. We're not necessarily opposed to a reduction in the $100,000 bond. I can see where the court would be inclined to do that, but we just made some points in our reply for the court to consider.
Let me take a look.
What happened? She was on bond for the burglary of a building and then was arrested on the robbery, alleged to have committed the robbery while on bond for the burglary of a building.
That appears to be what I'm seeing, yeah.
And that's why it was raised.
What's the bond in the robbery?
It's 15.
That's right, Judge. 15,000 in the robbery.
15?
Yes, Judge.
It's a simple robbery, not a robbery. It was basically a shoplifting case.
It's the garden variety.
It's garden variety robbery. It's not
I'm
robbery. Still, it's a second degree robbery while you're on bond for another
disparaging the severity of
felony.
or attempting to impugn the severity of But basically,
Hold.
she wants to go into rehab, if the court ready to entertain the motion. And I said as a condition of lowering the bond, that she be court ordered to attend Franklin House and work as a condition of lowering the bond. Does she want to, do you want to do that? Is that right, Paige? You want to do that?
Hold on just a second. Let me look at something else here.
And she has unindicted possession cases as well.
And I guess those are just waiting on labs.
That's my understanding, Judge.
Which could be, who knows how long.
I know. Same offense date as which one, the robbery or the burglary? Or are they different offense dates? Do y'all know?
Oh, different offense dates is my understanding. I put in my reply, it looks like she picked up the POCS while she was out on bond for the robbery. Well, let me reverse that. The defendant was out on bond for the POCS when she picked up the robbery, is my understanding.
She's out on bond for the burglary.
Burglary of a building.
Burglary of a building.
She was probably let out on accusation on the,
There is an underlying substance abuse problem, as the court may infer from the facts.
give me just a second. I'm reviewing, just for the record, I'm reviewing the probable cause affidavit in cause number 25 DCCR 0426. All right, so, Mr. Coleman, you're not necessarily opposed to some type of reduction, but I think there's some very.
That's not court would be inclined to reduce that $100,000 bond. I just would ask that it be sufficient in light of the circumstances, including the fact that she's got 5 pending criminal cases, 3 of which are felonies, and she picked those up, all 5 of those offenses within the span of 4 months, Judge. You know, there's an argument to be made for the protection of the safety of the community in light of her recidivism, but that's really a simple
But if I could briefly explain my position.
Yes, sir.
I think there's a lack of criminal history here such that I think that would the state be prepared to extend a plea offer on the indicted cases, it would probably be probation. I don't want to speak out of turn on what you're calling, but certainly the cases that she has that are presently indicted should be probation cases, but probably with the condition of safety or ISF. Since the state's not prepared to make an offer at this time because of the unindicted cases, she's just sitting in jail with the $100,000 bond and is not able to try to initiate a rehabilitation program in jail. And I don't know how long she's going to be sitting in jail waiting for these new cases to be indicted. So that's.
Well, we're not gonna, I don't know that we can wait on the possession cases, depending on the time frame that is going on with those issues right now is not something that I'm willing to.
I would like to move the indicted cases.
Well, let's do okay, all right, so in cause number 24, DCCR 1710, I'm gonna grant the motion to reduce the bond in that case to $25,000. I am going to order that you enter in, successfully complete the Franklin House North program. Also, that you are required to wear a drug patch. Your bondsman or Mr. Kimler can let you know where to get that on. You have to get it on if you make your bond within 24 hours. You have to wear it properly. You have to get it changed every 2 weeks. If it tests positive, that bond in each of your cases is going to go up. If it's not testable, then I'm going to assume it's positive. So whatever you have to do to make sure it stays on your arm, that it's testable every 2 weeks, you have to get that done. And then we'll reset the case for an announcement. If for some reason that bond's not made, we'll see where we are at that point.
And as I said, I think I would be prepared to plead.
But y'all talk about that. That's all right. Thank you. Mr. Lewis on Derek Ardwan, 25 DCCR 0350. Okay. Justin Thomas needs an evaluation. We're going to reset Justin Thomas. Good morning. You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections to the report?
No, nothing's been finished.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete this probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over and get right, live with my family, go back to work, help my mother out, give her bills, and everything else, Your Honor.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time, he was dealing with the death of his grandmother. As far as I think she was a big part of his support system. He does have. I've been in contact. Several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point. My understanding, Judge.
What is the status of the 5 new offenses that are alleged?
I believe they should all be.
What happened, so what was the deadly conduct from August of 2023? What was the outcome of the, or, I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
I mean, he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge, I didn't look him up after he pled true.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
I know those are still pending. He hasn't gone to court on those yet, right? Right. Next door.
Candy color.
Mainly the August 16th, 2023 offense dates are the 2 deadly conducts. I want to know what the status of those are.
Which,
And PCs, if you can find them.
what else is there?
There's the evading for March 3rd, 25. Our case, the one it's on, and then there was a previous trespassing case.
There's 2 deadly conducts that should be somewhere, somebody should know something about from 2023.
There was an obstruction in 2023 that was dismissed.
Birthday gentleman.
I don't have anything on deadly conducts.
What's the offense date of that one, the 2023?
5/3/23.
Daily conducts from August of 23 were refused, Your Honor.
Do you have any, I guess if they were refused, you don't have any documentation or a PC or?
I might be able to see a reason, Your Honor, for the refusal. I'm pulling that up right now.
Thank you.
There's not. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they wouldn't take him.
I think when he had the prior NTRP, I don't know if it was at the new case or a prior NTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
It looks like there was a non-prosecution affidavit on that assault based violence, which is why it wasn't.
He pled true to it.
Correct.
So,
I just want to let you know that's
yes,
why it wasn't. paid.
perfect, thank you. So this is this. So there was a motion to revoke back in 2023. And I'm guessing continued on probation in August or sometime, right? Or did we never do anything on that because then it was amended, first amended?
That's the one who's ordered us.
In March of 23, he pled true to that.
March.
Assault, family violence, the deadly conduct, obviously before it was refused, and you ordered him to ISF cognitive, plus the MRT program. And subsequently, there was another MTRP.
So you get an opportunity to be on probation for a burglary of a habitation. And I'm want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, second degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right? So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
23. You started this when you were 19. Feel like you're not taking advantage and you're not growing up and making better decisions.
And I think Ms. Faiza has tried to work with him when he would show up to work with her. So, I mean, I don't object to revocation, judges, and the opportunity that we've given him.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again and you violate again and you take off. So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. Frederick Gatlin, 2 cases. Mr. Lewis. Gosh, so tough. It's not tough. It's just, understand everything. You can go back with the bailiff. Deontay Reed, Mr. Lewis, and Mr. Coleman.
Yes.
Good morning. Are you Deontay Reed?
Yes, ma'am.
And will your client waive the formal reading of the indictment? Mr. Reed, in cause number 24 DCCR 0838, you're charged with the state jail felony offense of theft of a firearm from January 11th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a fine of $1,000 and restitution in the amount of $1,500 and follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Reed is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That way I can get more information about you, your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position with regard to bond reduction based on that plea agreement?
Your Honor, I would point out that the defendant does have a lack of adult criminal history. However, my records indicate he does have a aggravated robbery as a juvenile, and the firearm or firearms that were stolen in this case were never recovered as well. Would ask that you,
I think I'm going to wait. I want to wait and see I want to know what went on with that aggravated robbery as the juvenile. So we'll just leave the bond the way it is. We'll get a pre-sentence report done. That'll give me all that information and we'll come back for sentencing. All right, you can go back with the bailiff. Thank you, Mr. Lewis. Okay. He's probably, I guess he's got his PSI. He's going to go over his PSI. Okay, one more. Tony Fears, please.
Thank you for waiting on me, Your Honor.
Of course.
It's
Did I-
chatty down there in the 279.
It will help.
Because lawyers like to talk.
All right, sir, are you Tony Fears?
Yes, ma'am.
And this is cause number 24, DCCR 1028. Mr. Fears was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Not from the state. None from the defense.
And I'm guessing, even though there's significant history, Mr. Smith, based on the nature of the facts, or?
Based on the totality of the circumstances, I felt like this was appropriate. I did speak with the complaining witness. He was concerned when I spoke to him about the restitution, even though the PSI kind of says he downplays that. It
Was that part of the, was there?
Restitution was paid up front.
Oh, it was already paid?
Yes.
Okay,
And
okay,
I forwarded that on to the complaining witness.
okay. All right then, Mr. Fears, at this time, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Can there, we can't do it straight. It has to be deferred because there's deadly weapon.
Deadly weapon, I'm sorry, Judge.
Yeah. So, look, I caught it as I should have caught that yesterday when I was reviewing it. So, which actually, in my opinion, might be okay because that gives me the full range of punishment. So what I'm going to do then, the type of probation is left up to the court anyway. But you cannot have what we call a straight probation on an aggravated case. And this is an aggravated case. And so I'm going to kind of recall what I just did. And instead of making that finding of guilt, I'm going to defer all proceedings. You're placed on probation for 10 years. So it's still the 10-year probation, but it's a deferred probation. There's a $1,000 fine, and you're required to follow all of the rules and conditions of probation. So the difference about this is if you successfully complete this probation, then at the end, the case is dismissed, and you'll never have this felony conviction. The other side of that, and really kind of the side with your criminal history that I even like better, is that if you violate any condition of probation, you can be brought back into court and you could be found guilty and you could be sentenced anywhere in the range of punishment, which means between 2 years and up to 20 years. That 10-year cap or 10-year sentence is gone. It's now an open punishment range for me if you violate. With your criminal history, that's something that should be a deterrent for you, because I'm going to look back on this if you're back in here and wonder why in the world I agreed to this in the first place, because your criminal history does not support what's going on. I trust the attorneys. They know the case. I'm going to go along with it. But if you're back in here, it's not going to look good, because I'm going to see all of this and wonder what in the world. Do you understand?
Yes, ma'am, I do.
All right. Part of your probation, and it's part of the law anyway, is obviously because you're a convicted felon on other cases, you are not allowed to possess any firearm. I'm also going to order that you not possess any type of weapon, knife, other than a kitchen type knife. You cannot carry a knife on your person or anything like that. Do you understand?
Yes, ma'am, I do.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you leave today. Good luck to you, sir. Thank you, sir. You too.
Thank you, Judge.
Thank you, Mr. Vasquez, Mr. Smith.
Every day in the USA, people find themselves in court.
Mr. Gray, I'm going to put you in a breakout room with your attorney so he can talk to you about the payment plan in this particular case, okay? He has some FTAs. Oh, there's an iPhone 3. There's a device labeled iPhone 3. If you could please unmute your device and tell us your first and last name.
Terrence Weatherspoon.
Thank you, Mr. Weatherspoon. The court will call the matter of Terrence Weatherspoon, case number 20-3800571.
Tiffany Woods for the people.
Please state your name again, Mr. Weatherspoon.
Terrence Weatherspoon.
Please turn on your screen.
Oh, man. I don't even know how to turn it on.
Push the button that looks like a, there you go. Oh, no shirt. You can just go ahead and turn that back off. How much does he owe on this ticket? Mr. Weatherspoon, you can turn your camera back off. You're not even wearing a shirt. You need to wear a shirt in court, sir. So the total balance owed is $245. Has he been making payments?
That I showed you, it's from 2021, and it's a payment of $205.
Mr. Weatherspoon, you haven't made a payment since 2021 on your ticket?
No.
Do you plan to start paying on your ticket, sir?
Yes.
When can you make payments and how much?
I can make a payment by the end of the week.
How much?
$100.
You want to set up $100 per month to pay off this ticket?
$100 per month.
Yeah, what do you want to pay?
How much is the ticket?
225, you say 225?
245.
245.
I could take care of the whole thing by Friday.
Okay. All right, I'll put you back on the docket for June 17th. If it's paid off, you don't have to be here, okay, Mr. Weatherspoon?
Yes, ma'am.
All right, June 17th at 10 a.m. We'll see you then or not. Hopefully it's paid. Have a good day, sir.
You too.
Bye-bye. That's right. The court will call the matters of Shahid Lewis, case number 17W007. The court will call the matters of Martez Dalton, case numbers 21W003511 and 23S00057.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Mr. Lebo is in the breakout room at this time.
Hello, Your Honor. Matthew Ansur, Assistant Public Defender on behalf of Mr. Dalton. Mr. Dalton, can you state your name for the judge, please?
Martez Dalton.
Thank you. Good morning, everybody. All right, we're here for 2 pretrials in these matters, and Mr. Dalton is still suspended.
Yes, Your Honor. That's what I'm under the impression of that too. If we could request an adjournment to see if Mr. Dalton can clear up his license status, please.
One moment, let me take a look at that. Oh, is he aware of what he needs to clean up?
Yes, Your Honor. I've cleared up so many tickets in Detroit. So many of my tickets in Macomb County. Everything in Macomb County actually is done. Everything in Detroit is done. I have one more matter with I have three nope with you all driving while license. No, not four. Is it four? I believe it's four, yes. And I have one more matter with Livonia. And then after that I should be in the clear.
You you think you have them all done in Detroit? Because their record isn't showing that. So I don't know if they didn't send something off or if there's some misunderstanding.
Yes, when I spoke to my probation officer, she told me sometimes these things happen caught on there, but I definitely went to court and got time served on everything. And I mean the whole, what was it, 13 tickets?
Well, you can't get time served for no proof of insurance
And
because
right,
it's a,
that's what I was told. So I have to pay those tickets. So I mean I gotta pay that, but everything else as far as ticket status, I'm pretty much so done with. So the no
well,
proof of insurance is what I have to pay.
you have that out of the 36th District Court still, which is Detroit.
Yes, that's what I was told.
Okay. And Plymouth. I'm just trying to see if there's any possibility in all of this happening. So there's Plymouth, there's Detroit, there's Warren.
Your Honor.
Thank you.
Bless you
Bless
again.
you. I don't know. I must be allergic to something. I'm hoping I'm okay. I wasn't feeling well yesterday and now I'm sneezing today, but I feel fine. So there is also, did you know there's one in St. Clair Shores?
I thought that my bond had covered that over there, but I'll give him a call and see about it. That's what I was told on record. I thought that my bond covered the fee that I had over there. Actually, I got like a $22 check from them. I thought my bond covered everything out of St. Clair Shore.
So you have like so far three license suspendeds out of the 36 for no proof of insurance. And you have a failure to comply with no, that's Dearborn, you have a no proof of insurance. They're actually, one second, let me make sure these aren't the same. Yeah, those are the same. All right, I'm on the fourth one out of Detroit for no proof of insurance that's still suspended. 5. You have another suspension out of 41A District Court for driving while license suspended. 6 out of 36. Seven out of 36. You have 1 out of Livonia. You have a speeding ticket out of 36 that's suspending you, so that's 8 suspensions out of 36.
I thought all those tickets was taken care of, Your Honor.
They're all no proof of insurances. They don't get taken care of. And then another no proof of insurance out of the 38th, which is East Point suspension. So there's a lot still, but I'll give you guys an adjournment so we can at least talk about this and what you want to do and whether it's a possibility. So I'll adjourn it out to July 1st and see where we are.
Thank you, Your Honor.
You're
Thanks, John.
welcome. July 1st at 9:00 a.m. We'll go from there. Okay? Bond is continued.
Am I free to go, Your Honor?
Yes, I'm sorry. So yes, you're definitely free to go. Have a good day.
All right, thank you. You have a better one.
Thank you. Yes. There's a device labeled iPhone. And it's a gentleman with looks like a black or dark brown like sweater with a collar that comes. Yes, sir. Could you tell us your first and last name? Okay.
Okay.
We'll see you then. And the
Okay.
tickets.
Thank you.
Other one.
Okay. Thank you.
You're welcome.
Yeah.
Bye-bye.
Bye-bye.
I'm gonna hold on to all of those. It's too many. All right, the court will call the case of the state of Michigan versus Michael Matthias, case number 23-00780.
Tiffany Woods for the people.
Good morning. May it please the court, my name is Eric Nasland and I represent the defendant.
Mr. Matthias, please state your name.
Good morning, Your Honor. My name is Michael Matthias.
Thank you. Mr. Matthias is on non-reporting probation. Looks like he's still doing exactly what he's supposed to be doing. Ms. Woods?
I'm glad to hear that he's still doing well on probation, Judge. Thank you.
Your Honor.
Yes.
If I may, you may recall, I believe we were here about 60 days ago and we had filed a motion for early release from probation. We would like to renew that motion.
And Judge, he was supposed to send a report. You wanted to see a report about how he progressed with his family before you decided to release him from probation. I didn't receive a copy of that report. I don't know if the court did.
My apologies.
Hold on, Mac. I think he can address that to the court this morning briefly, if the court has any questions.
Mr. Naslet, it was supposed to be a written report.
I was not aware of that, Your Honor. I don't recall from the last hearing that it was specified that he had to prepare and file a written. Certainly, I would have had him do that. Could we perhaps have a very brief review date? Because I think it could be done within probably a day.
I remember this case very well because both the mother and the daughter showed up in this particular case. I said no 60 days ago. I'm not going to change my mind today. So I'm not going to do a brief adjournment. I'm going to adjourn this out by 30 days. I will consider at that time on July 1st.
Okay, not to be argumentative, Your Honor, and I appreciate that 30-day adjournment. I just want to be very, very explicit and clear what will be requested of my client. You want a handwritten report indicating, because he's had there was only one alleged victim in this case, which was his daughter. He has 3 sons, one or two of which I believe are adults, one of which is still a minor, and then the minor daughter. Because of this case, he's had absolutely no contact with the daughter. With regard to the 3 sons, he has had contact with them. If you want a detailed letter indicating the steps that he's taken to maintain a healthy relationship with his sons or to begin the healing process, I believe one of his sons appeared previously. That was Gavin. I don't recall Vera ever appearing, although she and the mother, his ex-wife, had written letters. So I want the record to be clear what has happened in this case. And I also want to be clear on what you're asking of him. He's more than happy to do it, like every step in this probation process. But I want to be clear what's going to be asked at the next hearing. Thank you.
Well, so, my memory may be failing me, but I recall that I actually talked to the son because there was an allegation that he didn't write. Let me finish speaking because I didn't interrupt you. That he didn't write the letter. So therefore, I questioned him about whether he wrote that letter. But my understanding was that the daughter was present, but I didn't ask her any questions. Now, maybe I'm wrong about that. Miss Woods?
Judge, you're correct, and I believe that the daughter also, she had written a letter from previously from when the sentencing happened, when she was quite young. And I remember that, defense counsel has said that he hadn't had no contact with any of his children. And Judge, you said that, he was just not supposed to have contact with the victim. And then you wanted him to show that he was trying to heal with his other children and to, write a letter about the progress that he had with his other children and that it should be filed at the next court hearing.
He's done that, Your Honor. He just hasn't written the letter.
My apologies, if I may. I did write letters to all 3 of my sons. I mailed them weeks ago, along with a birthday present for my eldest son's 21st birthday. I have not heard back from any of them, but I did, in fact, start the healing process. From the last meeting, it wasn't clear to me that I needed to write an additional letter for the court about the fact that I wrote the 3 letters to my 3 sons. So my apologies for that being unclear to me. But I have taken those steps to be in the healing process. And I would just like to make the court aware of that. I don't know if I need to submit the letters that I wrote to my 3 sons to the court, or if you would like me to read them, I can.
Mr. Mathias,
Yes, Your Honor.
did you kept copies of the letters, sir?
Yes, ma'am. I wrote them by hand, but then I went to the library and I scanned copies and sent them to my email on the date that I mailed them.
Are you comfortable sending those to the court, Mr. Mathias?
Oh, yeah, absolutely, ma'am.
Okay. If you could, please send those to the court, to the probation officer, so that I can review them. I want to see the efforts. Now, whether you get a response or not your fault, okay? But I'd like to at least see those. And I understand you may not have been clear about how to present the documentation.
Thank you.
But I do want to see that, and I'm not quite ready to do an early discharge just yet. So in 30 days, I will reconsider that at that time, once I've reviewed those letters, and if you keep doing what you're supposed to be doing, I will definitely.
Thank you, Your Honor.
Right. So I'll see you back here on July 1st at 10 a.m. Make sure you submit those letters to Ms. Johnson, and please talk to her about how you feel like things are going with respect to the reconciliation process. Okay?
Yes, Your Honor. I just, after I was put on non-reporting, I wasn't aware that I was to have contact with Ms. Johnson anymore. So
I understand.
I guess that's why I
understand.
didn't send her
But
the
there's
letters.
but there's a request at this point for me to early
Okay.
discharge you again. And so based on
Thank
that
you.
request, I need to have some additional information. Okay?
Thank you, Your Honor.
Thank you, Mr.
Thank you.
Matthias. All right.
Thank you. Are we all set?
Yes, we are.
Thank you.
You're welcome.
For $15. All right, good luck, sir.
Thank you.
All right, we got Tyler Grimm. Oops, I want to remove Mr. Deerduff. All right, next is Mr. Rognus' case, Tyler Grimm versus all occupants at 411 Enterprise. They were served by attachment.
I think that's 403, Your Honor.
403 Enterprise.
Your Honor, this is a situation where not really even a land contract, it's just sort of a do-it-yourselfer between Michael Christensen and Tyler Grimm. Michael Christensen's deceased, and as far as we're aware, nobody's done an estate and got letters of authority to pick up and move forward in regard to that property.
All right, we have Rich Christensen here. Mr. Christensen, are you living at 403 Enterprise?
I am not living at that address at this moment.
All right, do you have an interest in it?
Yes, I do, sir.
All right, what's your interest?
I'm the brother in it, and I went to move with the letters of authority. I've been getting that all around for us. And well, I had to consult an attorney. We've gotten some kind of vector now, and we'll go ahead and move towards probate.
All right, so you're not living there. Do you have property there?
Yes, there still remains property there, yes, sir.
So, Mr. Rognus, Tyler Grimm had some sort of unperfected land contract with Michael Christensen?
I don't know that I'd even call it a land contract, but Mr. Christensen, I think, passed away in February, and it's getting further and further behind. I've not been contacted by any attorney in regard to opening up a probate estate. Mr. Christensen can give us that information. That'd be beneficial.
But Mr. Tyler Grimm just wants his property back?
Correct.
Is that correct?
Yes, sir.
Yes, sir.
What attorney have you contacted?
The guy out of Coldwater, it was just a free consultation, something to give us a little bit of direction here. What we have is a vested interest in this property, a substantial vested interest.
Well, you don't have any vested
All right,
interest.
well, vested interest as in how?
With my brother's the payments towards the contract, he's never been late or any kind of problem with it, and it's been going on. He put down 25,000.
Exactly.
All right, well, you have to have some sort of a land contract or document to show that he had an ownership interest. And right now, you don't have any interest. You're just you have the same standing as a man on the street. Until something is actually filed in this case, you're here to give us information, but you don't have any authority to do anything. Go ahead.
Not at this present moment. I haven't got the papers yet. We tracked down his son, the rightful heir, and then the next in line and consignment would be my father, who's still alive over in Cleveland. Both are willing to sign off, and I know that now, and we're ready to go move forward.
All right, well, this is complicated. So, Mr. Christensen, do you have in your possession any sort of sales agreement or?
Yes, I have the contract. Yes, sir.
You have a contract?
I have the contract, the original.
Do you have it with you?
It's in my computer, and I can absolutely get it to you.
All right, is it a land contract?
Yes, sir. But like Mr. Rogers has said, it was a do-it-yourself kind of throw-together deal.
Well, it might not
going to record
binding effect. All right, well, you need to get on your horse, Mr. Christensen, because I have to continue this matter. I'm going to continue it to June 2nd. But at this point, until something is filed to give you some authority, you don't have any authority to act.
I will take care of that.
All right. I'm going to bump this out to June 2nd. Andy, why do you always get these really interesting cases?
Oh, because nobody else will take them.
No, because he's shady.
Let's set this for 2:15 for Monday, June 2nd.
Thank you.
Yeah, I mean, I get called from Miss Patterson and she's trying to tell me what the law is, and I'm going, no, that's not how it works. You have to have letters of authority. And she's going, well, there's no money in the estate. And I'm going, well, you can't just jump in here and assert that. You have to follow the rules.
No, you're wrong. You're wrong. You're lying through your teeth.
The end. Stop, please.
Who's speaking?
Michael's sister.
Okay, so you're involved in this also.
Yes.
All right, I didn't address you. What's your position?
My position is I am the sister to Michael. And that is not correct. I didn't understand the whole situation. So, I mean, we're not even 3 months out from my brother dying. So we're trying as fast as we can.
Well, in the meantime, the house is sitting there empty. He's not receiving any payment.
No, it's not. No, it's not sitting there empty.
Who's in it?
He has a roommate. He has a roommate in there, and I offered to pay Tyler.
Well, who's in the
payment.
property?
His name is Mike. I don't know his last name. My brother will. I offered to pay Mr. Grimm the mortgage every month until we got this matter situated, but he declined to take it.
Well, once he files the matter as a termination of tenancy, he can't accept any money.
No, it was way before. I have proof. It was like, I don't know, 2 months ago that I texted him. I said, who do I send the payment to? And he ignored my text.
All right. Well, he's pursuing a again, you have no standing. You have as much standing as somebody just walked up on the street. you're the sister to someone that had, may or may have not have had a contract. You're not a party to the contract. You don't live there. Some guy who lives there isn't even here at the hearing. Your brother also is not a party to the action. There is no estate. He's not on the lease. He's not living at the property. So you guys are here to give advisory positions, but the guy that's on the head of the pin is the person that's living in the house. Mr. Grimm doesn't want your money. He wants to get his house back. And apparently there's some sort of do-it-yourself sales agreement, which may or may not rise to the level of a land contract. I haven't seen it. But when you do these things without a benefit of an attorney, when you're dealing with the sale of land, there are very specific rules that have to be followed. So at this point, Mr. Grimm wants whoever's in the house, Michael. Mr. Christensen, what's Michael's last name?
Michael Harker.
He's in the house?
Correct.
All
He was
right,
there.
so
He's the
no
one that
one's
found my-
paying rent because he's filed a termination of tenancy, so he can't accept any money. Now, I could set up a escrow account, but actually, the only person that has any standing right now is the occupant. And he isn't here. So whoever your unnamed attorney in Coldwater is, you guys have got some stuff you need to get to by June 2nd. Then we'll address it further. But at this point, he's asking to have the property returned to him. All right, anybody else have anything wish to say?
I
All
would
right, June
indicate, John,
2nd
if
at
they
2:15.
If they
That's right.
have an attorney, have them contact me.
Yes.
Absolutely.
All right, very good. Well, we'll see where this goes by June 2nd.
Your Honor, there's a $800 utility bill due. I
was gonna ask who's paying the utilities, but I didn't.
Yeah. I called him up from October to March, and then from March to now, he put another $800 on that account. So I don't know what he's doing in there, but yeah, that's a problem.
Yes, it is. You discussed that with Mr. Rognus. All right, he's living there for free right now, which is a pretty good deal, but some point we're gonna have to figure out who gets the property. All right, Mr. Grimm, you guys are all good to go.
Thank you.
Thank you.
Thank you.
You could have them as clients, Meg.
Well, let me see whether we can remove everybody. I'm having all kinds of difficulty today.
Did you take a lightning strike on Friday?
The courthouse or me personally?
Well, I was looking at your hair. Maybe it could have been.
It did. I lost power. Yes, but turned my hair all gray.
Yeah. No, you guys were closed on Friday. Was it because of the wind or what?
No, the all of Centerville on. All right, we have 3 cases all set for 145, and they're all different wrinkles. We have to shift gears. We're going to take up the matter of LVNV funding versus Matthew Zinsmaster. Attorney Naviat Francis is here. She's already been here a couple times today, and as part of her punishment, she had to come back this afternoon. Let me give a little background here. The file number is 242109. A default judgment entered in the amount of $875.12. Mr. Zinsmaster filed a letter indicating, I'll just read it. I, Matthew Zinsnass, was never served for this case regarding LVNV funding. I've never even heard of this place or know what it was for. If I knew what it was, I would have had it resolved by making payments to them. But I didn't know this place, was never contacted prior to getting this court paperwork when I was unaware of this. The defendant was allegedly served by a process server, Samantha Donahue, from a company. I have at least 2 cases where I believe Samantha Donahue fraudulently served somebody. She swore under oath that she
I
had
was never.
process, and I don't believe that's true. And she's been fired by the serving company. I believe there's a state police investigation into false swearing in Kent County, and I have a show cause hearing to show cause why she'd not be found in contempt for fraudulently swearing that she served process. The person in the other case, which I have very strong reason to believe she was never served, she put a description of her, and the attorney in the case believed that she looked her up on social media, wrote a description, and swore that she served her. So I don't know. We're going to have a hearing on it if we could find her. So I took with a note of suspicion Mr. Zinsmaster's claim that he was never served. The claim is not that big. It's $800 and some dollars, and he says he would acknowledge it. So I could set aside the default, Mr. Zinsmaster, and then we just start all over again. What I propose,
Your Honor,
yes,
I did call this lawyer company or this place that served the papers.
yes.
I did call them and set up a payment plan.
All right, very good. So you've set up a payment
Which
plan?
Yes, I did that, and I told the lady that was on the phone to let them know, and she said, I can't do that.
Ms. Francis, do you have any knowledge of that? You're on mute.
Sorry. I was asking when he called.
How recently did you call?
It would have been Friday or Thursday.
Okay, just Thursday.
Oh yeah.
All right.
I don't have updated notes that soon. What was your payment agreement?
$80 a month.
Okay. So I guess then would you be withdrawing your motion and we'll just have the payments in place?
When were you going to start making the payment?
I already did.
All right, made first payment when?
It was Thursday or Friday, or it was Thursday or Friday.
All right, so first payment, we'll call it Friday, May 23rd. The 23rd of each month?
Oh no, I think he meant last Friday. Is that what you meant?
Oh yeah, that would be May 9.
Yes,
May
that's what I meant.
16?
16. God, I can't even get my days straight.
So then are you paying on the 16th every month?
Yes.
Okay. So then, Judge, I would ask for his motion to be denied.
All right, I'm going to find that after hearing, the motion to set aside is denied. Defendant has agreed to repayment plan on the judgment of $80 per month starting May 16th. All right, the original judgment stands You acknowledge you owe the debt. I have some suspicions about whether you were actually served, but you're here now. You acknowledge the debt. You've agreed to a repayment agreement. So there's no need to set the default aside. You'll simply make a monthly payment. So I appreciate your diligence on this. And I'm going to put you under oath here for a minute. Would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, I do.
And is it your testimony that you were never served a copy of this summons and complaint by any process server at your house or anywhere else on February 2nd?
No, I was never served.
And you never met a young woman that handed you a summons and complaint?
No, it was in my mailbox when I came home.
Oh, so she stuck it in your mailbox?
Yes.
Well, that's not the same as personal service, so you did have knowledge of it. Yeah, she must have looked you up on social media because she put a description. I would like to talk with this young woman because I'm very unhappy about this. It impugns the integrity of the whole process. Judge O'Hara in Kent County had an expansive hearing. Anyway, it is what it is. You're going to pay it at $80 per month. The matter is resolved and you're good to go.
Thank you, Judge.
All right.
Thank you.
Is that it for you, Miss Francis?
It is, Judge.
Well, I hope when I
Now-
see you next, I've got my ducks in a row here. We're still struggling from this morning. And he came in during lunch and he consulted the owner's manual and he went online and we're now working with people in Lansing to get it straightened out. All right,
Oh,
I'll
good,
see you
good
next
luck.
time.
Thank you.
All right, Mr. Zinsmaster, you're good to go. Thank you.
All right, thank you.
There we go. I got it now.
All right, Mr. Reed, we got a couple more civil matters to deal with here. They set these at 145, and each one of them is always a puzzle that needs to be unraveled, and there's never enough time to do all of them. The next one is Portfolio Recovery Associates versus Ana Fuentes Ruiz. Ana Fuentes Ruiz is here by telephone. Attorney Michael Kirschenheiter is here, and I'll be right here.
Okay.
All right. Then we have Goshen Hospital versus Terry Cousins. And Mr. Cousins is here. I don't believe there's anyone here on behalf of Goshen Hospital, unless it's Mr. Kirschenheiter. This is a claim for $5,976. Mr. Cousins has filed a motion to set aside the default. I did not know I had a court date. My wife has short-term memory loss. In order to set aside a default, you have to show good cause for missing the hearing and a meritorious defense. Right now, Mr. Cousins, nobody's here on behalf of Goshen Hospital, unless it's Mr. Kirschenheiter. I neglected to ask him. So stay with me. We'll take care of a couple other matters and then when he comes back, we'll see what the deal is.
Yes, sir.
Michelle, has anybody been in contact with us from the law firm? They're from Pittsburgh.
Yeah, okay. Have a good week. Good luck with the
I hope
Pelicans.
it gets better. Poor Chris has been working with me all of last week and certainly all day today to get back up to speed, and it hasn't happened yet. All right, we got one more civil matter. Let's take up Goshen Hospital versus Terry Cousins. The defendant was sued by Goshen Hospital by the law firm of Levy and Associates from Columbus, Ohio. There was a pretrial on November 4th. Neither Mr. Cousins appeared or the law firm appeared. And I said, well, maybe the matter was resolved. Then it was just laying there, and somebody found it in a sweep that it was unresolved. So we set the matter back on track. It was set for a pretrial on March 17th. And the law firm appeared on behalf of the hospital, and Mr. Cousins did not. Give me a moment here, Mr. Cousins.
Yes, sir.
Mr. Newell, if you go out to the court office, she'll give you a copy of this. Thank you, Elaine. I'll get back to you on those Friday cases. Now, if you could fix my Zoom, I'd be really happy.
Thank you.
All right, as I indicated, March 17th, nobody appeared on behalf of the defendant. So the defendant failed to appear in November. He failed to appear when we reset it for March 17th. I granted the motion for a default judgment. The default judgment entered on March 18th. The amount of $5,976, $195 in costs, and a $75 attorney fee for a total of $6,246. Judgment has been entered and a final unless a motion for new trial or appeal is filed within 21 days after the judgment date. So on April 9th, the defendant filed a motion to set aside the default. So 12 days in, 13 days in March and 9 days in April, when the defendant filed on April 9th, is 22 days. So the motion to set aside the default was a day late. Also, it's supposed to state a meritorious defense, a legitimate reason for failing to appear and an affidavit of meritorious defense. In his letter, my wife has short-term memory loss. My wife remembered after I got home from work, then I found out I missed court. If I had known about it, I would have been there. We tried to get a hold of them to set up payments. We will start paying $50 a month. I have a mailing address, and I'm sorry about missing the court date. They actually missed 2 court dates, and then you filed the document a day late. So have you had any contact with the law firm?
We have had contact with them last month. I made one payment of $50 to them last month. And I tried setting up a payment to come right out of my bank account, and they refused that. Because they wanted $500 a month, and I cannot afford that right now. On
Yes.
top of that, sir, I don't understand how I would manage to be a day late in doing that when I had to wait for the paper to come in the mail that was sent from the 17th. Because on the 17th, I went up to the courthouse. It was after work, and it was after the time that I was supposed to appear before you, sir. And the ladies in the office downstairs there is the one that told me I had to wait for this paper to come in the mail before I could come back and file it. And the
That is
same
an
day that I
interesting
got it in
question.
the mail, I went down to the courthouse to file that. So I'm not sure how it managed to be delayed, sir. Can you hear me?
Yes.
Okay, I'm sorry. Because there was some
All right, well, just a minute.
I'm sorry. Yes, sir.
It is what it is. You owe the debt, but they didn't even bother to
I owe
show up. This is the second time.
100% I owe part of that debt, sir. 100%. There's no way I owe that much, though.
So there is no meritorious defense, and your reason for not filing it had to do with advice from the court. So although I don't really want to wrestle with this tar ball, plaintiff failed to appear for hearing on the motion.
And what had happened in the first place, sir? I did go down to the hospital. It was in November.
Don't tell me anything about the facts here. I
Oh,
don't
okay.
want to compromise anything.
Yes, sir.
I'm going to set a pretrial. Perhaps you guys can work something out. So I've granted your motion. Plaintiff failed to appear to oppose it. We have a 1-day time issue, which may have to do with mail. So I've granted your motion. We'll set a pretrial and see where this goes. So the motion is set aside. The default has been granted. We'll set up a pretrial and deal with that. All right, thank
Yes,
you.
sir.
You're good to go. I'll remove you. Hello, booking. Judge Middleton calling. We're gonna take another shot at talking to James Harvey. James Jonathan Harvey. All right, thank you. Bye. Thank you, John. We've had a very hectic day here.
Can you hear me okay?
What?
Can you hear me okay?
Yes, I can. You're good to go. I'll remove you. Hello, booking. Judge Middleton calling. We're gonna take another shot at talking to James Harvey. James Jonathan Harvey. All right, thank you. Bye. Thank you, John. We've had a very hectic day here.
Can you hear me okay?
What?
Can you hear me okay?
Yes, I can. We've got some hookup problems here with our equipment, but we tried a shot at this morning and you weren't available. And as you know, we set this for the very following morning, which is Friday morning.
Little do we know
The
that
power went out and we couldn't do anything for anything. Mr. Gabry was here this morning. He's back this afternoon. Mr. Harvey looked good this morning. As you recall, the procedural posture of this, we're in the middle of a last pretrial, and it was the defendant's position at that point that he wanted to have his day in court when we discovered that he was 2 times the legal limit. So I didn't know if it might be beneficial to let you speak with him briefly in a breakout room to see whether he still wants what he wants to do regarding the case. And then we'll see how we proceed. What?
did he get charged with drunk driving?
I don't know that. In fact, I don't believe so. I think they started an investigation on it, but I'd be surprised if it was completed by now. Is that true?
What?
Ms. Davis professed she was going to submit it for a drunk driving charge. It may have been very hard to prove it. I don't know, but all right, well, we'll bring him in here in a minute. But I don't want to just leave him sitting in the jail indefinitely, and that wasn't ideal.
Well, we definitely not eligible for deferral. So if he enters any kind of a plea, it's going to be on his record today, so he can make that decision then.
Yes.
One of our concerns was he professes not to have a clear memory of what happened, but we'll see. Maybe his head's clear today.
It sounds like you've had a very busy day in Three Rivers, and there's internet problems between here and Three Rivers, and I'm so very frustrated today regarding my own connections.
Their phones
but,
running.
we're almost at the end of the day. Yes. When I call the jail ahead of time, almost inevitably they forget. So if I call at 1:30 and say I need James Harvey at 2:30, they always forget, get caught up in other stuff. So what we do is call right then. And then the problem is if you're in the middle of something right then, it may take a few minutes to get the person that you actually need. But I've been off base all day today. Boy.
Oh, sorry, John.
Different room. All right, good afternoon, Mr. Harvey. Again, my apologies to you. We tried to get this matter scheduled. Your lawyer, Mr. Bush, has joined us. He's in Three Rivers at the court there, and he took a recess in the middle of a number of other cases today to deal with this. Let me recall the case. This is file 24366SM versus James Jonathan Harvey. Mr. Harvey is here with us by a Zoom connection from the jail. Mr. John Bush is with us with a Zoom connection from Three Rivers. Gary Gabry from the prosecuting attorney's office is present. This matter was set for a final pretrial conference before jury last Thursday, May 22nd. The charge is a domestic violence charge. The matter was adjourned from an attorney pretrial to a final pretrial on that date. There was a question about whether Mr. Harvey would be eligible for a deferral on a domestic violence charge if he had a previous assault and battery. I looked at the statute 769A, and it does not appear that you're eligible for a deferral. So the matter was set for pretrial. It was going well enough. We were at the position where you had wished to have your day in court and have the matter set for a trial when we learned from a preliminary breath test that you were about 2 times the legal limit. So I canceled your bond, set the matter for sentencing the next morning, which would have been Friday the 16th at 10:30, and the power was out and the courthouse was closed and we weren't able to accomplish anything. So you ended up spending the rest of the weekend in jail. So I tried to get the matter scheduled as soon as I could today, and this was as soon as I could get it. Mr. Harvey, now that you're not intoxicated and clear-headed, I suggest that I let you talk to your lawyer, Mr. Bush, for a few minutes to see how you wish to proceed at that time. Is that agreeable with you?
Yes, Your Honor.
All right, I'm going to open a breakout room and let you and your attorney speak privately, and we'll wait here.
Just to clarify in the record, you said for sentencing,
Well, the sentencing would have been on the contempt,
oh, okay.
not on the principal charge. All right, thank you. Sentencing and a further pretrial. We had hoped to have a Zoom room at the new courthouse similar to the one we have here. The one we have here isn't very elaborate. It's just a TV set with a hookup on it, but we use it all the time. The circuit court uses it. Judge Pattison uses it. We use it quite often. And we'd wanted a room like that there. And we brought it up again last week at the Judiciary Committee meeting. Right now, the lawyers are logging in using their phone or something, but the logistics of having 2 courthouses as opposed to 1, not enough staff, not enough lawyers. Hopefully we can get that set up. But Mr. Bush, with the help of his staff, we managed to accomplish this time for this. I hadn't seen that room until last week. There's actually 4 rooms that they can use. There's the original Polycom room. There's the one they usually use up front. I think this is the one they call the magistrate room, and then there's another one.
Big building.
But it's always a matter of having staff to do it. And they're very accommodating. So but there's nobody that's been around long enough they can remember when they had to put them in a car and drive them up here and use that little lockup back there and bring them in the courtroom. So as much of a pain in the neck it is, Polycom is a blessing. It's also much of a less security issue. The complainants were here on Thursday, correct? And then nobody was here Friday. And this thing's been kicked around a couple of times for today. All right, everybody's returned. We were in a status conference, and let me repeat, the charge alleges that domestic violence. The allegation is that on February 28th, the defendant made an assault upon Kylie Wilma, someone he had a dating relationship with. That's domestic violence. The other charge was count 2, assault and battery upon Grayson Lewis. That is just assault and battery. Both of those are up to 93 days in jail and a fine of up to $500. I believe the offer was plea to 1 count of domestic violence. Is that true, Mr. Gabriel?
Yes, Your Honor. And dismiss the assault.
And so we were starting the discussions when we really realized we really couldn't go forward. Mr. Bush, what's your client's position here today?
Based upon our discussion, he wants to waive jury trial and have a bench trial.
Is that true, Mr. Harvey?
Yes, Your Honor.
All right, you have a right to have a jury trial. You also have the right to have the matter set for trial just in front of the judge, which presumably would be me. And that's what you wish to do here?
Yes, Your Honor.
All right. If I let you out of jail today, will you go back to 124 South Douglas Avenue?
Yes, Your Honor.
All right. I don't have a date right now to give you, but I'm going to let you out of jail and reinstate your bond.
Thank you, Your Honor.
I think you got my point. You're found guilty of contempt for appearing intoxicated for a court proceeding. On order Friday, Saturday, Sunday. Friday, no, it's Thursday to Friday to Saturday. It's 4 days jail credit, 4 days. Bond conditions remain in effect.
Yes, Your Honor.
Now, one of the bond conditions obviously was that you not drink any alcohol and that you take a test on demand of any police or probation officer or court, and that was me. The test was positive. And I know this is easy for me to say, John, don't drink when you get out. You have it really bad. No one shows up drunk for court unless they really have a serious substance abuse issue. So my suggestion, as soon as you get out, would be to start some services, one of which is free, just going to some AA meetings.
Yes,
I
Your Honor.
will set the matter for a bench trial. Lock out 2 hours. Parties to provide witness and exhibit lists 7 days in advance. I've got an idea about a potential date here. We've got some jury dates where we don't have a jury coming in. One is June 4th. Mr. Bush, are you available on June 4th?
I'd have to make a phone call and check, Your Honor.
I will
I would
check.
promptly
Then we
do that.
also have June 18th. It seems like we may have put something in June 4th, but I'd rather do this sooner than later. So I'll check and see if the morning of June 4th available. That may be too soon. That's not, well, we'll see. Or June 18th.
So
All right, thank you, Mr. Gabriel.
Or do you want me to?
All right,
check?
thank you, Mr. Bush. Mr. Harvey, I'm going to send this paperwork out to the jail. You're going to get booked out. Will somebody come pick you up?
Yes, Your Honor.
All right.
Mr.
All right,
Harvey,
we'll deal with this further. Thank you.
Judge, do you want me to confirm that date, or is your office going to check?
We'll contact your office.
Thank you very much. Thank you.
Your Honor.
Yes?
Is the no contact order still in effect?
Yes, it is.
Okay. Thank you.
Mm-hmm.
Every day in the USA, people find themselves in court.
Good afternoon. Who do we have in the county jail?
Douglas Brogan.
We're on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This comes on for hearing on our regularly scheduled Tuesday, May 20th, 2025, first appearance docket. We are on the record specifically in case number 2025 CR 66, State of Kansas versus Douglas Paul Eugene Brogan. County Attorney Jill Gillette appears for the state. Mr. Brogan appears in person and pro se. Mr. Brogan, at this time, you are charged with count 1, aggravated robbery. In that count, the state is alleging that on or about the 15th day of May, 2025 in Greenwood County, Kansas, you did then and there, contrary to the statutes of the state of Kansas, unlawfully and knowingly take a cell phone by force, kicking, punching, and grabbing the throat of Jessica Goodwater, inflicting bodily harm while doing so in violation of KSA 215420B2. As charged, this is a level 3 person felony, which means that if you were to be convicted, you could be given a sentence ranging from 55 months to 247 months with a $300,000 fine. That time would be served in the Kansas Department of Corrections, commonly known as prison. In count 2, you're charged with aggravated domestic battery on that date. You're accused of unlawfully and knowingly impeding the normal breathing by applying pressure to the throat, chest, or of a person, Jessica Goodwater, with whom you have an active no contact order, and did so in a rude, insulting, or angry manner, to wit, grabbing her by the throat and throwing her down on the road, and that the two of you have a romantic relationship. This is charged as a level 7 person felony. If convicted, your sentence would range from 11 to 34 months in prison, and your fine could be up to $100,000. In count 3, you're accused of the criminal threat to commit violence communicated with the intent to place in fear Jessica Goodwater by threatening and yelling at her that you were going to kill her before you went back to jail again. And you did this while she was on the phone with local dispatch. And this is charged as a level 9 person felony, which if convicted would range in sentencing from 5 to 17 months in prison with a $100,000 fine. In count 4, you're accused of violating a protective order issued as a condition of pretrial supervision in Greenwood County Case 24 CR 224. You were to not have contact with Jessica Goodwater, but were allegedly with her on May 15th, 2025. If convicted, that is charged as Class A misdemeanor, causing you to be looking at 12 months maximum jail sentence and a $2,500 maximum fine. In count 5, you're accused of theft of the cell phone with the intent to permanently deprive the owner, Jessica Goodwin, of the property having a value of less than $1,500, making this a Class A non-person misdemeanor, punishable by a maximum 12 months in jail and a maximum $2,500 fine. In count 6, you're accused of driving while your driver's license was revoked as a habitual violator. Another Class A misdemeanor, meaning that if you were to be convicted, you could be looking at yet another year in the county jail and another fine up to $2,500. In count 7, you're accused of domestic battery of Jessica Goodwater. That is unlawfully and knowingly causing physical contact with Jessica Goodwater, with whom you were involved in a dating relationship or household member. And this physical contact was done in a rude, insulting, or angry manner. They say you pulled out a clump of her hair, hit her, left bruises on her, and threw her on the gravel, then kicking her head, causing bleeding, swelling, and bruises. And this is charged as a Class B person misdemeanor. If convicted, you could serve up to 6 months in the county jail and pay a $1,000 fine. Finally, in count 8, you're accused of transporting an open container of alcoholic beverage, to wit, an open beer can, and that is charged as an unclassified misdemeanor. The specific penalties for that include up to $200 in fines and 6 months possible county jail time. Because some of these are felonies, we need to set this for a preliminary hearing, but we also need to determine what you're going to do about an attorney. Are you going to hire an attorney?
Yes, ma'am.
I noticed you didn't turn in an application for court-appointed attorney. Did you intend to?
No, ma'am. I have an attorney I'm going to hire.
Who are you hiring, please?
Vince Vaughn out of Iola.
Vince Vaughn?
Yes,
Out of
ma'am.
Iola. All right, we'll make a note that you're planning to hire attorney Vince Vaughn out of Iola. If you determine that you cannot afford to hire him or any other attorney, you need to come to the courthouse as soon as possible and get an application for court appointed, because these are felonies and you are looking at some serious possible consequences, as I've gone over with you. So, Missy, when will his preliminary hearing be?
1:30.
I didn't hear the date.
June 20th at 1:30.
June 20th at 1:30. That will be your preliminary hearing control. It will not be the hearing in which the evidence is presented, because I want to first make sure that you show up with your attorney and that you actually want a hearing, as opposed to waiving a hearing. So you need to be back here June 20th at 1:30. You need to have your attorney here. And then Ms. Gillette, does the state want to be heard on bond?
Your Honor, there's 2 cases now going. I have filed a motion to revoke bond in the other case. I let his attorney know that I'd be trying to set that for trial. In the previous case, I also let his attorney know where he was so that he could get in touch with him and find him.
So you've been speaking with Mr. Vaughn?
Mr. Vaughn is hired on his previous case. His previous case is 24 CR 224. There is a no contact order in that case with the victim. His preliminary hearing in the prior case is set for June 6th, 2025 at 1:30. So if we couldn't get a hearing sooner, I was going to notice up the motion to revoke bond in the prior case for that date. My recommendation and that case is aggravated domestic battery as well. And I am asking for $150,000 bond, considering this is the second aggravated battery in a very short time period. And it's against the no contact order in the prior case.
You want to be heard on the issue of bond, Mr. Brogan?
If I may, please.
Go ahead, please.
Yes, ma'am. I completely understand the severity of these charges. However, I mean, previous to this last one that she just was talking about, I've never had any convictions or charges anywhere near this, these type of charges. I'm a single father. I have property and a farm with livestock. I just was hoping that there would be a bond available, maybe not quite as high as 150,000. I'm a single parent. I'm zero flight risk, ma'am. I'm not going anywhere. I have property here in Greenwood County. My father just passed. His funeral is on the 1st of June. I was just hoping to, have some opportunity to at least try to get a bail or bond. And like I said, I'm not going anywhere. I'm zero chance of fleeing. Just realize the severity of these charges, and I would like the opportunity to somewhat get my farm in place, because obviously I probably will be, spending some time in here or in jail. It would be a blessing if I was able to get things in order, because I have property with cattle and goats and things of that nature that kind of they depend on me to survive out there. And I just was hoping to have an opportunity to bond, ma'am. That's all.
Mr. It looks like in Woodson County, he has 24 CR 28 criminal threat, driving while suspended third. And his last activity on that was April 21st of 2025 with the disposition. That must be sentencing, because it says disposition 3/20 of 25. So he must have sentencing coming up. Are you aware of that one?
I'm not, Your Honor.
May I speak on that?
If you like.
So that case is settled. We pled to that. It's just a DUI plea and driving on suspended. That was what we pled to, and I've been sentenced to that for 1 year probation.
All right.
And
What about, it looks like there's something else maybe pending that hasn't been resolved in that county?
no,
Or did they consolidate?
Yeah.
Consolidate the two cases? The DUI was in the other case, and you pled it, and
I only had one case in Woodson County, and it was originally like a criminal threat on there, but we pled down to just DUI and driving on suspended, I believe, is what the results were.
Okay.
As far as like violent crimes or anything of that nature, person crimes, I've never had anything like that whatsoever.
Any convictions, you mean?
Yes. Well, until this.
The charge.
Yes,
the charge.
yes, ma'am.
To DUI. And was the same woman the alleged victim in that case?
The last two here in Greenwood County is yes, with the same woman, Jessica Goodwater. She's been the only. No, that was towards the officer. That was with the officer the criminal threat that they were in Woodson was with like the officer. I was just.
Okay.
It wasn't.
You don't have to say anymore. That answered my question.
He does the show cause pending with court services.
And Woodson?
Or TR 79.
Okay. Oh, that's Greenwood. I think 150,000 is pretty reasonable. I think we could even justify going higher with all the activities that I'm seeing here and the serious nature of them, the threat to the community, particularly this alleged victim, but, you know, you've got other things going on in there over the years. I'm going to set the bond recommendation at 150,000. And if you go anywhere near this alleged victim again, anywhere near her, her family, her place of residence, her employment, you even drive by and wave at her, there's a good probability you'll get your bond revoked with a no bond hold, and you can sit in jail until these are all resolved. You understand that, Mr. Brogan?
Yes, ma'am.
And you're also going to, if you make bond, have an electronic monitoring device that will alert if you go anywhere near the places she's known to be. And I don't know what your history is as this woman. Maybe she calls you and says, hey, honey, come on over. If she does that, hang up the phone. She's not the one on bond, you are. I have no reason to suspect she does that, but sometimes that happens. And if it does, you have nothing to do with her, even if she initiates it. All right, if there's nothing further.
Judge,
Yes,
I didn't realize he had a case already set on June 6th. So could we put both of the cases together on June 6th?
sure. We'll need to make a condition of your bond that you reappear June 6th. And what time is that?
1:30.
June 6th instead of June 20th. Deputy, did you note that?
Yeah, I got it.
All right, June 6th, 1:30. You must be back here with your attorney. Anything else from either party? We'll
No,
be in
ma'am.
recess at this time. Thank you, Mr. Brogan. Excuse me, ma'am, who is the lady at the courthouse? Ms. Gillette, was that the alleged victim?
No.
I'm sorry, are you involved in that case? A witness? Are you a witness or an alleged victim?
Family member.
I'm sorry, I didn't hear you.
I'm a family member.
Okay, all right, well, I just needed to know if you were someone that's entitled to speak and if you wanted to speak, but thank you. You may go. All right, sir, what is your name, please?
Harry Bogart.
We are on the record in 2025 CR 64, State of Kansas versus Terry Lynn Bogart. County Attorney Jill Gillette appears for the state. And Mr. Bogart appears.
Family member.
I'm sorry, I didn't hear you.
I'm a family member.
Okay, all right. Well, I just needed to know if you were someone that's entitled to speak and if you wanted to speak, but thank you. You may go. All right, sir, what is your name, please?
Harry Bogart.
We are on the record in 2025 CR 64, State of Kansas versus Terry Lynn Bogart. County Attorney Jill Gillette appears for the state. And Mr. Bogart appears in person, in custody, and pro se. Mr. Bogart, in this case, you are charged with count 1, aggravated kidnapping. Specifically, the state alleges that on or about the 11th day of May, 2025, in Greenwood County, Kansas, you, Terry L. Bogart, then and there, contrary to the statutes of the state of Kansas, did unlawfully and knowingly take or confine any person accomplished by force, threat, or deception with the intent to terrorize the victim, and did so with bodily harm inflicted upon the person kidnapped, to wit, Nicole Sumter. This is charged as a level 1 person felony, which means that if you were to be convicted, are you hearing me okay?
Judge,
Yeah.
you're kind of quiet.
No, we can certainly fix that. Is that better?
Maybe a little bit more.
I'm
Okay.
normal, Judge. I don't know if it's their setup or if there's something wrong.
It could possibly be.
All right. Well, as I said, Mr. Bogart, in count 1, you're charged with aggravated kidnapping of Nicole Sumter. Did you hear that, or do you need me to go over that again?
Yes, I heard that.
All right. That is a level 1 person felony. That means that if you were to be convicted of this charge, you could be sentenced anywhere from at least 147 months up to 653 months in the Kansas Department of Corrections, commonly known as prison. You also could be ordered to pay a fine up to $300,000. In count 2, you are charged of aggravated battery of Nicole Sumter. That is unknowingly or unlawfully and knowingly causing physical contact with her in a manner whereby great bodily harm, disfigurement, or death could be inflicted, and you did so with a deadly weapon, hitting her in the head and the abdomen with a baseball bat. Is that comical? Is that funny?
Well, unfortunately, this woman that claims this, she's like 3 times my size. She's at least 300 pounds heavier than me. First off, secondly, this situation, all we did was argue. She was on methamphetamine.
Well, I probably ought to stop you there. Your attorney wouldn't want you speaking, but I did wonder what was comical, what was humorous in an aggravated kidnapping and aggravated battery charge. And you've told me
all I did was tell the woman she needed to go to her room and relax because she was claiming there was people running around my house out in the country.
All right. Well, your attorney again would tell you to stop talking. And we'll talk more about the attorney issue shortly. But it is alleged that you struck her with a bat, which could be a deadly weapon, and you did so in a manner where great bodily harm, disfigurement, or death could have been inflicted. As charged, this is a level 7 person felony. The penalties range from 11 months to 34 months in prison and a fine up to $100,000.
Oh, I would like to see the weapon.
All right.
You'll
be entitled to see that. You and your attorney will be entitled to see that. In count 3, you're charged with criminal threat, allegedly threatening to commit violence communicated with the intent to place another in fear, to wit, Nicole Sumter, by threatening to cut her into pieces while holding a knife to her throat. And you also threatened, apparently, they're saying, to throw her remains in a river. This is charged as a level 9 person felony. If convicted, the sentencing range you could receive would be from 5 months minimum up to 17 months maximum in prison, and you could be given another fine of up to $100,000. Then in count 4, you are charged with aggravated weapons violation by a convicted felon. In this count, the state alleges that you did unlawfully and knowingly possess a weapon, to wit, a West Point .22 caliber long rifle, having been convicted of a felony, a person felony, in Greenwood County Case 2019 CR 85, to wit, aggravated battery, and that you had not been expunged or pardoned from that. This is a level 9 non-person felony. If convicted, your sentence could range from 5 to 17 months with a fine of up to $100,000. These are all felony charges, so you will want an attorney, and I see you have applied for one.
Yeah.
I have
I've
your
also-
application in front of me.
Also, I would like to see if you could take into consideration that I'm in the process of treatment for glaucoma. I've also have experienced breathing problems here recently with COPD or something like that. I mean, my health is not at the greatest peak. This is why I'm saying all this stuff they're throwing on me is crazy because I can barely even keep up myself.
How old are you, sir?
Huh?
How old are you?
I'm 59, getting ready to turn 60.
Okay, 59, getting ready to turn 60. And are you
I
employed?
mean, no, at this time, like I said, I was in the middle of, I've already had 3 surgeries on my right eye for glaucoma. I was trying to get that pressure system in my eyes equaled out more so I could do my left eye next. I helped this woman out because she was stuck between a place of nowhere to go and a man that was willing to help her out if she slept with him. My landlord stood there and heard this, and he looked at me. He says, "It's only going to be a couple days." I said, "I really don't feel comfortable with it, but I can deal with it."
All right,
Wasn't even 24 hours later, after her doing this meth and shooting it in her arm and everything else, that she went on
again,
this.
your attorney would tell you to stop talking. Whether you listen or not, that's beyond my control. I'm not going to gag you to stop talking, but that's what your attorney would tell you. Your application, excuse me?
So hopefully we can expedite the deal with the attorney so that I can continue my medical procedures because, like I said, I've managed to get my eyesight back in my right eye. I was totally blind in it. I do have a PDF of all my medical procedures to show that I don't have time for these kid games.
Well, sir, I need to, if you're going to pursue this application for attorney, I need just a minute of your attention. You've been unemployed for 4 or more years. Why have you been unemployed? Is it the glaucoma?
Yes, I mean, I was walking into walls because I couldn't see right.
Okay.
I didn't know what was wrong with me.
Okay, well, your application says, does anyone live with you? And you said no, but I understood you to say you were giving this woman a place to live.
Just for a couple days. Yeah, it was just a couple days. Even my landlord's a witness to this.
All right.
That's what I'm saying. It was just a mutual agreement.
So you don't, sir, just a moment. You don't own the land you rented, and you've indicated that by referencing your landlord. You're single, no dependents other than yourself. Is that right?
Yeah.
Now, for monthly bills, you put worked for landlord for rent. So you're saying even though you don't,
he's 80 years old, and I more or less provide a lot of services for him for his property as well where I'm at.
All right. So you work for room, and does he pay for your food too?
No, I was getting a assistance for that.
Are you still getting that?
As far as I know, I mean.
Okay, so that's through the state of Kansas food assistance?
Yeah. I mean, it's what I get for being nice and saying yes to help somebody.
Other than your food assistance and the rent you get from your landlord, do you have any kind of income, disability, or anything of that sort?
No, I was denied disability.
I will appoint an attorney to represent you. My assistant, Missy, who's with us, will
Could you repeat that?
Missy will assign an attorney to you, and if you check back with her in a few days, she'll tell you who that is and how to get a hold of them. Missy, you don't have the appointment yet, do you?
No, I don't.
All right. So make sure you check back. The jailer can make sure you have access to Missy's phone number. And as soon as you find out who your attorney is, contact that attorney. The attorney needs to know your name, your case, and where you're located so he can talk to you. Do you have a phone out there at your landlord's?
Yeah.
Okay. So you're getting an attorney. We need to set a date for your next hearing. And Missy, when will that be?
Preliminary hearing control, June 20th at 1:30.
You need to be back here June 20th at 1:30. Why don't you come to the courthouse? Because I think otherwise trying to do this by Zoom would be very challenging. And bond, Miss Gillette, do you want to be heard on the issue of bond?
So can I make a real quick recommendation? Okay, where I'm staying at, I don't have no transportation. My landlord provides me with that, especially helping go to doctors and all that. And he could verify that I stay there on the property. I don't bother nobody. I stay to myself. I'm a recluse.
All right. What is your landlord's name?
James Meyer.
How do you spell?
Meyer, James.
Okay. James Meyer is the landlord. We might want to make a note of that. And he's your sole transportation?
Yes. We're like brothers, more or less. I mean, he takes care of me, help me with what I need, and I help him.
Okay. And do you live out in the country? Don't give me your address. Just tell me yes or no.
Yes. 2 miles away from Madison, out in the middle of nowhere.
Okay. All right. Miss Gillette, do we know where this alleged victim is at this time? Is she still on the property?
I don't know about the property owner, but James Myers is an endorsed witness. That's whose house he ran to during this incident. He went down there to James's house as this incident unfolded. So that's going to be one of the people he's not actually supposed to be having contact with unless the court allows it. My recommendations for bond is $75,000 due to the fact that he has a prior aggravated battery.
Has he been in here anytime recently?
Not since the 2019 case, Your Honor.
Okay. Did he do any time on that, or do you know?
I do not have that file pulled out today.
Okay. All right. Well, apparently, okay, there's something pending in Lyon, but it looks like it's civil in nature. And there's today's case. This older gentleman, this 80-some-year-old man that you live nearby, he isn't the victim in this past case, is he?
No.
Okay. It's like you've had some traffic issues over the course of time. Well, you have no income. You live 2 miles outside of Madison. You're looking at some cataract surgery in your left eye when?
That's where I was in the process of getting ready to start setting that appointment and stuff up when this incident happened.
I'm
through,
going to. And how do you know that lady that was there? Let me ask you how long you've known that lady that is allegedly the victim.
I've known her off and on through some friends in Emporia, and I mean she has a record in Lyon County for being violent up
All
there.
right. And how old is she?
Huh?
Do you know how old she is?
No, not right off the top of my head. I do not.
Okay. Well, I will follow the state's recommendation because of the violent nature of this and the potential threat to this lady. But
I
as
want
soon
to
as you,
understand. I want to understand the last friend I spoke to before I was arrested, that she was back in Emporia, and she was telling people that she had actually set me up and got me arrested.
well, you'll certainly want to talk to your attorney about that. And as soon as you talk to your attorney, the attorney can bring the issue of bond back in front of me so we can consider reducing that if appropriate. I'm setting the bond high now because of the nature and the possible threat to the community and the fact that I'm not sure that you have really strong ties to the community. If it sounds like you've been living there a while, but I need to know more. I need to probably hear from this gentleman that owns the land to see what your arrangement is and so forth. But as soon as you get your attorney, he can bring this back in front of me and I'll review that bond. In the meantime,
Well, could
regardless
I
of
ask
the amount,
one next question?
hang on,
Sorry,
regardless of
okay,
the
yeah.
amount of the bond, regardless of the amount of the bond, you are to have absolutely no contact with this alleged victim. I'm not going to go so far as say no contact with your landlord, even though he's a potential witness, but you are not to talk about the woman. You are not to talk about the incident that led us here today with him.
Right.
If you
Okay.
get out there and want to start plotting a strategy or talking to him about your defense or what happened, then you can go back to jail on violation of your bond. So if he tries to talk to you about it, tell him you can't.
Right.
All right. Anything further, Miss Gillette? We've got the court date. He's got it getting an attorney and bond at 75,000 professional surety. Anything else from either of you?
Honor.
Yes.
Nothing further, thank you.
Okay. And Mr. Bogart, did you have something that I didn't let you finish a while ago?
Well, I was going to say, should an agreement come with this by my landlord? I've also going to have character witnesses that'll going to be on my case about this woman and her drug problem she has.
Well, your attorney will want to know all of that information and help you decide what you want to do with it.
So this should be within the next, 3 to 5 working days, or how soon should I expect?
You'll know your attorney. Missy's pretty quick about this. As soon as the attorney confirms that he or she'll take the case, probably at the most within a couple of days. If you're still in jail, she'll let the jailer know and pass that on to you.
I'll probably more likely be here.
If you get out, you contact my office and Missy will tell you who your attorney is.
Okay.
But I want you talking to that attorney as soon as you find out who he or she is.
Okay.
All right. If there's nothing further, then Mr. Bogart, you'll be excused. Yes, sir.
Okay, as far as being able to communicate with this attorney, once I do find out who it is, what if they don't accept any collect calls or anything? What can I do about that?
Well, deputy, will you allow him to call his
We allow you guys to call your attorneys if you need to.
All right, there we go. All right, if there's nothing further, you're excused, sir. Thank you for your time.
All right, thank you.
You're welcome. Is Mr. Boyles in custody? All right, did you ever get your driver's license? Well, I'll strike that. All right, you can go, sir. You're remanded back to the custody of the sheriff. Deputy, you have anyone else that needs to be heard today?
There's one more.
Yeah, I have one more.
And his name or her name?
McConkey?
McConkey? Okay, that would be how I would say it. Are you Mr. McConkey?
Yes, yes, Your Honor.
Am I saying that correctly, McConkey?
Yes.
Thank you, sir. We are on the record in 2025 CR 70, State of Kansas versus James A. McConkey. County Attorney Jill Gillette appears for the state, and the defendant, Mr. McConkey, does appear in person, in custody, and pro se. Sir, in count one, you are accused of the crime of mistreatment of an elder person. In this charge, the state alleges that on or about May 16th, 2025, in Greenwood County, Kansas, you did then and there unlawfully and knowingly omit or deprive treatment, goods, or services, to wit, access to hot water, a shower, and food necessary to maintain physical or mental health of an elder person, to wit, Peggy Chrisman. This is filed as a level 8 person felony, which means if you were to be convicted, your sentence would range anywhere from 7 months minimum to 23 months maximum and a $100,000 fine. In count 2, you're charged with unlawful possession of the controlled substance alprazolam, also known as Xanax. This is a level 5 drug felony. If convicted, your sentence would range from 10 to 42 months in prison and a fine up to $100,000. In count 3, you're accused of theft of Peggy Chrisman's property, to wit, a Glock 25 Gen 5 pistol valued at less than $1,500. This is charged as a level 9 non-person felony with a sentencing range of 5 to 17 months and $100,000 in fines. In count 4, you're charged with misdemeanor mistreatment of an elder person, that you did unlawfully and knowingly take the personal property or financial resources of an elder person for the benefit of the elder defendant by undue influence, coercion, harassment, duress, deception, false representation, false pretenses, or without adequate consideration of the elder person, to wit, Peggy Chrisman. Being charged as a Class A person misdemeanor, the penalty could range up to 12 months in the county jail where you are now, and up to a $2,500 fine. In count 5, you're charged with unlawful possession of drug paraphernalia, to wit, a gator clip, paper cones, possessed with the intent to store, contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body. This is charged as a Class B non-person misdemeanor. If convicted, the sentence could be up to 6 months in the county jail where you are now and a fine of up to $1,000. I do have in front of me an application for court-appointed attorney that it looks like you filled out and submitted through the jailer.
Yes, ma'am.
You've been unemployed for 10 years, is that right?
Yes, I got Lyme disease. It's very bad. May I say something else?
Well, usually attorneys say not to, but if you wish, I will let you.
Very brief. I just want to say, this is my mother that we're talking about, and I've had social services at my house. Kelly, I don't know her last name, is with the Kansas Department of the Aging and Disabled. And I just talked to her like a week ago. And so I've had all these people over there. My mother is very physically and mentally sick. And that's all I wanted to say. I've never hurt my mother.
Your application says my mother lives in a little house behind mine and pays the bills. She pays the bills?
Yes, usually, but she's been not doing well handling the money. So usually I give her back part of the 500 that she gives me, because since I don't work and I'm ill, I don't go anywhere very often. I just stay home. I don't spend much money.
So your mother pays you $500 a month and she lives in the shed behind your house, is that right?
Yes, ma'am. I wouldn't call it a shed, but yes.
Okay. Do you own a home? And you said yes, valued at $41,000. Is that in your name then, the house?
Yes, Your Honor.
Is that paid for and clear? You don't make any payments?
It is paid for in full. No, it's no liens or loans against it. It's free and clear.
I will appoint an attorney to represent you. You need to check back with Missy, my assistant that's helping us today, in a couple of days, and she'll tell you who your attorney is. You will be required to contact that attorney and be ready for your court date, and Missy will give us that as well.
June 20th at 1:30.
You and your attorney must be here June 20th at 1:30. So you have your court date, you're getting your attorney, and that leaves the issue of bond. Ms. Gillette, do you want to be heard on the issue of bond?
Yes, Your Honor. In this case, the mother does live in a garage shed type building behind the house. You have to squeeze sideways to get to her mattress in order to see where she sleeps. Not the day that we're going to try this case, but she has absolutely no money to pay anything because he takes all of it.
I don't.
Hang on, you'll get your chance, sir.
Yes, sure.
Contact with his mom. I don't know if he told the other people that she slept in the house or what he told them, but my officers have seen where she's living. And he did have her gun in his truck and took it from her. He has a lot of her property in the house. Some of her property is stored out in the building she's living in that's so piled high. There's teeny tiny pathways to get to where she needs to be. I want no contact with her. I don't know why all these big cases all came on the same week. It sure makes a lot of extra work for me, but I don't usually ask for a lot of big bonds, but this week it's been very, very bad cases, and I am going to ask for a $50,000 cash or professional surety bond. No contact with the victim. We have contacted professional services to come in and help find her a place to stay. No contact with her bank. No use of her money. Period. No ifs or buts about it. Those are the conditions that I'm asking for, because we're going to have to be setting her up in an assisted living or someplace that she can actually be able to reside.
I will do whatever you say.
So you don't know if she's still in the shed or the garage or the house or where she is right now?
I have a follow-up today with the officers so they can go back out and follow up with her. And I've made emergency contact with DCF APS to see if we can help her. But I did all of that today. I made multiple calls this morning and emails to try to get her some assistance immediately.
Do you know how old she is approximately?
I think she turned 78 in October. October 18th is her birthday. She's 77, I believe.
I was looking for the birth date here.
He was born on October 18th, 1947.
Are you her only family, sir?
Yeah,
Or other
I don't have any siblings. I'm an only child. I love my mother very much.
Well, I am at this time going to follow the recommendations on bond, but I want to revisit them soon as you get an attorney. And as I said, Missy will get that for you just in a day or two. If you make bond, you're going to have to find some place to stay, even though you own the property. I don't want you kicking her out.
No, I understand that. Yes.
You can't stay with her until they'll further order.
Yes, ma'am.
I'm also following the state's recommendations that you have no contact with your mother whatsoever, her bank account, any of her money or resources. Don't call any friends she might have if she has people that she is friends with. Don't be contacting them to get through to her.
Follow your orders.
Thank you. And then you get a hold of, once she moves out, once DCF helps her find a place, and of course you're welcome to go back there anytime, and maybe by the time you bond out, she'll be gone. But make sure you get your attorney as soon as you can and contact that attorney. See about getting in front of the court as soon as possible on that bond, and also addressing the charges in the case.
Thank you, Your Honor.
You're welcome. Anything further, Ms. Gillette?
I can't think of anything else, Your Honor.
Judge, I have something.
Yes.
I didn't hear the bond recommendation.
It's 50,000 cash or surety, no contact with alleged victim, her bank account, her money.
Okay, I got that part.
Okay,
Thank you.
you're welcome. So, Mr. McConkey, you're remanded to the custody of the sheriff at this time, and we'll be in recess on your case.
Thank you, Your Honor.
You're welcome. Thank you for your time, sir. And Deputy, thank you for yours as well.
Thank you. You have a good day.
You too. Understanding that Mr. McConkey was our last in custody, we'll take up Amanda Cortez. On the record in 2025 CR 50, State of Kansas versus Amanda K. Cortez. We are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This matter comes on for our May 20th, 2025 weekly misdemeanor control docket. First on the list, I have Miss Alcala, case number 2024 CR 213, State of Kansas versus Mary Patricia Alcala. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Mary Alcala, who appears via Zoom for a separate location.
And I have some kind of indication that this is for plea counsel. Is that right?
Yes, Your Honor.
Any announcements? Is she pleading as charged? Well, she was charged with the forgery. What's she pleading to?
Yes, Your Honor. I'm working on pulling up the exact statute here. Your Honor, it's called, the statute is 58-2218, false statement and certificate.
Say that again, please, the number.
58-2218.
That does not sound like a criminal statute.
For your information, there's a specific statute in the misuse of your notary that allows you to plead to the specific statute of misusing your notary. There's two different versions. One is for making a deed. One is for any misuse of a notary stamp. 58-2218 specifically is the penalty and violation code for misuse of the notary stamp. It does have a criminal unclassified misdemeanor.
So it's not under the criminal code?
No, it's specifically in a separate statute.
All right. 58-2218. You said it's an unclassified misdemeanor?
Yes, Your Honor.
Yes, Your Honor.
All right, Miss Gillette, the state does so amend to KSA 58-2218 from forgery.
Correct, Your Honor. Any notary officer who knowingly states material untruth in either of the certificates herein contemplated, which are the deeds or transfer of deeds, may be indicted and fined in any sum not exceeding the value of the property conveyed or otherwise affected by the instrument on which said certificate is endorsed.
All right, I do have that in front of me. Miss
There's actually case law on it, Your Honor, State versus Krashar, KRAUSHAAR, that prefers the statute over the forgery statute.
all right. So you've worked with this some, Miss Gillette?
Yes, Your Honor.
All right, Miss Alcala?
Yes.
I understand you've entered into this plea agreement. Is that correct?
Yes, ma'am.
And in exchange for your plea to this unclassified misdemeanor of making a false statement and certificate, the state would be amending away from the forgery. Is that your understanding?
Yes.
So how do you wish to plead then on this violation of KSA 58-2218, making a false statement and certificate?
No contest.
No contest. You're not going to admit it, but you don't want to deny it and take it to trial either. Is that correct?
Yes.
Is anyone making you enter this no contest plea today by any threats or promises other than the plea agreement?
No, ma'am.
You understand you're giving up your right to any preliminary hearing or trial on the forgery matter?
Yes.
And that you're also giving up your right to any trial on this false statement and certificate charge?
Yes.
Miss Gillette, where did you see that that was a misdemeanor penalty in there?
And if it's not otherwise noted in the statutes, there's provisions that it is a misdemeanor unless it's noted as a felony.
Well, it says penalties in the heading, may be indicted and found in any sum not exceeding the value of the property conveyed. How much is the value of the property conveyed?
Judge, it was a deed on a house. It can be up to that amount.
And how much was that amount?
Oh, Judge, it would have been several.
Thousands, I presume, maybe hundreds of thousands.
My recommendation is not going to be thousands.
All right. Well, Miss Alcala, you understand that the penalty for this could be up to the value of the property conveyed?
Yes.
And you understand the court does not have to follow plea agreements
Yes,
for
ma'am.
sentencing? All right. Okay, so Ms. Gillette, have you a factual basis to support this no contest plea to 58-2218?
Yes, Your Honor. On October 12th of 2023, officers met with the Green Register of Deeds, Marsha Ramsey. She had explained that Ms. Sanchez, Tanya Sanchez, had been communicating with their office about deeds for a deceased brother. They had mailed a deed that was incorrect, and they were told that they would have to go through probate because the descriptions were wrong. She called back again and wanted the legal descriptions. They were emailed to Miss Alcala's email address, the same one that's on her bond, on September 27th, 2023. There was a second set of deeds that had been notarized as if they had been created a long time ago, back before Mr. Weigel had died. The notary stamp was by Miss Alcala, and the dates had been purported to be 7/10 of 2022 and 7/11 of 2022, knowing that he had passed away since then and could not have made a new deed. The signatures were remarkably different from any signature known to Mr. Weigel. Miss
Is Mr. Weigel the brother of Miss Martinez, you said?
Sanchez, Miss
Or
Sanchez.
Sanchez, I'm sorry.
Miss
Okay.
Alcala had notarized them, had sworn that she had seen the notarization in person, which is impossible since Mr. Weigel has passed away. Miss Alcala and Miss Sanchez lived together at 208 Iowa Street in the town in which they live. I don't want to give too many details because of their address being on public YouTube. But both of the documents were tried to be passed off as originals in Greenwood County at the Register of Deeds office, which gives us jurisdiction, and tried to transfer the ownership of the real estate in the deeds.
So the deceased sister and Miss Alcala were in cahoots trying to get the deceased property?
The sister is alive, Your Honor. The sister and Miss Alcala live in the same residence. Miss Alcala was a notary back at the time that 2022, when the deeds were backdated to. The first one was sent, they were told that's wrong. So they made a whole nother deed containing Mr. Weigel's signature, purporting it to be an original, and it was backdated, and Miss Alcala notarized that deed as well.
Okay. All right, well, then I find that the defendant has knowingly and voluntarily entered this no contest plea, and that the state has provided a factual basis to support the plea. And finding of guilt, I do find the defendant guilty of violation of KSA 58-2218, making a false statement and certificate. Finding the defendant guilty, recommendations for sentencing.
Your Honor, we are with our plea agreement. Our plea was 58-2218. It's a misdemeanor with special sentencing recommendations. I'm recommending 30 days underlying suspended for 6 months, non-reporting probation, court cost, booking fee, and a fine of $100. Her notary is expired, and there has been a freeze placed on her ever getting a notary again.
Well, I've heard that this type of, well, Mr. McClendon recommendations.
Judge, I join in the state's recommendations. Additionally, we would be asking for a waiver of attorney's fees. Ms. Alcala is on a fixed income, and any kind of help she can get would be appreciated.
Fixed income, you mean she's receiving Social Security benefits?
Yes, Your Honor.
And the recommendation jointly is 30 days suspended for 6 months non-reporting probation, $158 court costs, $45 booking fee, and nothing further. Is that right?
No, because there's also penalties that have been put in place through the Kansas Secretary of State's notary.
Will those need to be addressed in this hearing?
No, they've already been done administratively, Your Honor.
Well, Miss Alcala, I've been told that this stealing people's property with fake titles is a problem. It's been a growing problem, and I hope that this was just a one-time incident with you, that you're not in that ring I hear about that takes advantage of people like this, because you're getting a pretty sweet break here.
And I appreciate it.
If I follow the plea agreement. So you're on Social Security. What kind of work did you do?
I ran a tax preparation business for 35 years.
Well, it sounds like you knew what you were doing then. And the deceased sister was working with you on this?
No.
It wasn't her brother's property you were trying to get away with?
Oh, I thought you meant, was she working in my office with me?
No, I meant the two of you were on this paperwork. All right, well, and now what do you do with your time?
I retired about 2.5, 3 years ago, and I help take care of my grandchildren.
Do they know you're looking at these charges?
Yes.
It's not a very good example for the children, is it?
Oh, no, the kids don't know. My son and daughter-in-law know.
Counsel, why should I give her non-reporting probation?
Yeah, she resides over at Winfield. I mean, it can be transferred if you want to put her on reporting probation, but I'm not expecting to have too many issues out of her as long as she pays her cost. And like I said, her notary's already been seized administratively.
Apparently you don't have any reason to believe she's part of the criminal enterprise I keep hearing about in the news that does this to innocent, unsuspecting people.
I believe this was just because she is connected to Miss Sanchez.
All right. Did Miss Sanchez get charged?
Yes, ma'am.
All right. Well, at this time, I will follow the plea agreement. You are given a 30-day sentence. No fine or attorney's fees. You will be responsible for $158 in court costs and $45 booking fee. You won't have to serve the 30 days so long as you successfully complete your 6-month non-reporting probation. Conditions of that probation: number 1, do not violate any laws. Number 2, pay the court costs and fines. Can you do that within the next 2 weeks, 14 days?
I don't have that much money right now, but
30 days, if I give you 30 days?
yes, ma'am.
You have 30 days from today to pay that in full as a condition of your probation. And I'm inclined to order no contact with Miss Sanchez. I didn't hear anybody say that.
Your Honor, I live with them because I can't afford a place of my own.
Now, it sounds like you get into some pretty serious problems, or at least this time you came up with a pretty serious idea. When you say you live with them, is she related to you, this Miss Sanchez?
She's my daughter-in-law.
Oh, it's your daughter-in-law. Okay.
Yes, ma'am.
So, Ms. Gillette, we didn't make a bond condition that they have no contact like we normally do with co-defendants?
There was one, but I think we may have allowed them to live together. I knew they lived together and they had the same address when we charged this.
Well, this is an outrageous crime. And I shouldn't have to tell someone as smart as you are that, Miss Alcala, because with the kind of work you've done, you're no dummy. You didn't get just innocently duped into this. It took some real planning and some real criminal guts, if you will. All right. Well, that's my order. I'll let you go ahead and continue to live with them so long as there's no more of these kind of ideas or any other criminal activity going on between you two.
Yes, ma'am.
Anything else, counsel?
I can't think of anything else, Your Honor.
All
Nothing
right.
for me,
We'll
Your
be in
Honor.
recess. We're in recess. Excuse me, Miss Alcala.
Thank you.
You're welcome. We'll now be on the record in Boyd 2025 CR 35, State of Kansas versus Sydney Omega Sue Boyd. Please announce appearances.
Hey,
I'm
please,
here.
State appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Sydney Boyd, who appears via Zoom from a separate location.
And what announcements do we have on this, council? I'll take up Ginger Blades. If Mr. Fabre is ready on that. Not seeing him. Has he checked in today?
I don't believe so.
Has she?
I think she's in jail.
Oh, okay. Then let's take up Stubbs. Mr. Ambrose, are we ready on the two Stubbs matters? The show cause hearings?
Could I have 1 second with Mr. Gillette? As we were waiting to call, I just had an idea that I thought I'd like to talk with her for a second on. I apologize.
All right. Miss, if you please put Miss Gillette and Mr. Ambrose in a breakout room.
That's what I get for agreeing to be last.
Ah, yeah, I heard you did.
But hopefully these won't take too long, Judge.
Probably not.
And I'd like to go in a different order than alphabetical, if that's okay with you, Judge.
That'll be okay.
Okay, I'll just announce them as we come up.
Sounds good.
Thank you. Well, since they're in a breakout room, hey, Missy, could you stick me in a quick breakout room with Morgan Johnson, please?
Sorry for my lateness, everybody. Is Miss Blades present?
They said they think she's in jail, so are we gonna get her there? Are we gonna get her here, Missy? Yeah, I was gonna take you up earlier, but, they,
Yeah, I just stepped out of Judge Crumb's just a little
it's
bit
okay.
ago.
I know how busy you stay, so, yeah. I just thought
Judge,
yeah,
sorry. I guess she bought it out last Wednesday. I did not realize that. And I did not send her the Zoom link because I sent it to the jail Wednesday.
all right, well, let's take that up pretty quickly so he doesn't just have to keep hanging around then. Miss Gillette's in a breakout room right now.
I think Mr. Favre's here too as well now, Judge.
Thank you.
Present.
Miss Stubbs, if you could turn on your, there we go.
We are on the record in case numbers 2023 CR 135 and 2024 CR 182, both captions State of Kansas versus Lydia Lucille Stubbs. Please announce appearances.
May it please the court, this state appears by Gillette County Attorney.
The defendant, Ms. Stubbs, appears in person with counsel Christopher Ambrose of Harvest Legal in both cases. We are here.
Miss Morgan, are you here on this case as well?
Yes, Your Honor.
Okay, thank you. Go ahead, counsel.
Judge, we're here on a revocation motion. I've talked with Ms. Gillette about this. I think the plan today, if the court will allow us, is Ms. Stubbs is going to enter a no contest statement to the underlying violations. And then we're going to ask the court to set this out for disposition. I think the date we're going to be tentatively looking at, if the court will allow us, is July 1st. That'll give her some time. She needs to get me some documentation about some things. That'll give me a chance to get that and go over it and get it to Ms. Gillette before that disposition hearing.
I'm not inclined to set this over for disposition. I didn't share what kind of documentations, but she's had over a year to get you any documentation she needed. How's she doing on that felony case she had?
Judge, that's the 23 CR 135.
Oh, you amended it down to the misdemeanor?
Yeah, she was given the second chance option.
Okay. Well, I'm not inclined to set her the revocation over, Mr. Ambrose. Does that affect how you want to proceed?
Your Honor, and our issue is Ms. Stubbs is just getting back into some services that I think the information from that would be helpful for the court and the prosecution for disposition is my concern.
Well, it's not unusual that they get back into services right before they are looking at revocation. So I'm not inclined to give her a chance to do what she's been told to do. But first things first, we need to decide if she's in violation or not. So does she wish to have an evidentiary hearing? It looks like we have a witness ready.
And Judge, Ms. Stubbs and I talked earlier. I believe it is our plan that she's going to enter a no contest statement to the underlying violations as to the violation itself.
All right, Ms. Stubbs, do you understand you do have a right to object to the allegations that you violated your probation, and the burden would be on the state to call the probation department and for the court to see if the evidence supports the allegations? I didn't hear you. It doesn't look like you're muted. I'm just not hearing you.
Judge, Ms. Stubbs might need to exit and come back into the meeting. And then when she does, make sure that she signs on using device audio, computer audio, whatever they call that. If she could do that real quick to see if we can get this connected properly.
Typically on show causes, they're told to report in person to the courthouse.
Let me see where we are with that, Jen.
Where does she live? Madison?
I believe so, Your Honor.
If she lived in Eureka, she could just come on down to the courthouse. Well, let's see. While we're waiting on her, let's recess. And Mr. Fabry, can we take up your client?
Judge, I have not been able to reach Miss Blades, so she's not present, but we can take it up. But yeah,
If you
I don't know if Miss
realistically, if you realistically thought you could find her, I could let you wait a while, but
I don't really, Judge, to be honest with you, I don't really know because I haven't heard from Miss Blades in quite a while. So your guess is as good as mine.
Her
right.
bond sheet's in your queue, Judge, just FYI. She bonded out Friday, I think.
to be here today.
Yes.
Miss Morgan, I would just inquire, I guess, if Miss Morgan has heard from her recently, because I know Miss Morgan's her CSO.
Your Honor, I have not heard from her. We transferred her to Lyon County, and they actually sent her back, and that's when I filed because she was not reporting as directed in Lyon County. So I don't think anybody's had contact with her, and I have not spoke to her since she's been released.
Okay. And the two numbers I have for her are both disconnected, so
Disconnected.
I guess we can I guess we can just take it up.
We're on the record in Greenwood County, case number 2024, CR 122, State of Kansas versus Ginger Ray Blades, County Attorney Jill Gillette for the state. Attorney Joseph Fabre for the defendant Ginger Blades, who does fail to. And if there's nothing further, Mr. Fabre is excused as his case will be in recess.
Thank you, Judge.
You're welcome. We'll now be back on the record. In 23 CR 135 and 24 CR 82, both captioned State of Kansas versus Lydia, Lucille Stubbs, all parties appearing as before. As I was just saying in another matter, typically defendants are told to appear in person on show causes. I don't see the specific note that this defendant was. And she does appear by Zoom. Where are you located, Miss Stubbs?
I'm at home here in Madison.
Okay. So, Miss Stubbs, on this 23 CR 135, you were convicted on count 2, possession of Vivane, and count 4, possession of drug paraphernalia. A and B misdemeanors. You were given concurrent 12-month and 6-month sentences. On the other case, 24 CR 82, violation of a probation or violation of a protective order, you were given a 12-month sentence. Now your probation officer says you violated your probation, that you have not paid as you were told to do, and you have not reported to your probation as you were told to do. Your probation officer also reported that you were placed on reporting probation for 12 months on June 7 of 2024. You were ordered to pay $263 in fees, fines, costs, to follow standard conditions and the special condition to have no contact with William Connor. You had not, as of the time of filing the show cause, responded to the officer's phone call attempts to the last known phone number provided by you. And on November 20th of 24, the officer Jessica Morgan made a final attempt to contact you at the last known number, and a young male named Brody was on the voicemail. You failed to gain or maintain employment, which is a standard condition of probation, that you failed to make monthly payments and still owe the balance, that you were seen by Officer Morgan in Madison community with William Connor. So the officer is requesting that your probation be revoked, as she believes you're not amenable to probation. Now, your attorney says you wish to waive your right to an evidentiary hearing and stipulate that you have violated. Is that correct?
Yes.
Is anyone making you waive your hearing and stipulate to these violations?
No.
Are you stipulating because the allegations are true and could be proven by Ms. Morgan's testimony?
I guess.
Will you guess? Do you have some other theory that they're not true or that she couldn't testify to their truthfulness?
I would like to speak with Chris if that's possible.
All right, we'll take another recess.
Hey, Judge, while they're in the breakout room, you want to take up some other cases?
Sure. Who would you like?
Let's do Morgan Johnson.
We're on the record in 2024 CR 187, State of Kansas versus Morgan Alexis Johnson. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Morgan Johnson, who appears via Zoom at a separate location than council.
Announcements, if any?
Well, Judge, we've gotten on April 9th, I got the diversion agreement. I sent that to Miss Johnson. She advises me that she sent it in on April 13th, but I don't think it's been diverted or it wouldn't be on this docket. So,
Well, not necessarily, Mr. Paul, because I see the diversion agreement was filed April 23rd of 2025, if I'm reading my file correctly.
okay, so I guess we're finished with Miss Johnson.
That's the way I see it. Miss Gillette, anything further?
No, I had her taken off the docket.
Okay, well, it was on my list that I got on the 15th, Judge, so.
It's still on my list too.
Okay, great. Well, I'm glad it's not, so. Perfect.
Okay, Miss Johnson, you are excused. Make sure you comply with your diversion so you don't have to come back.
Okay. Thank you, Your Honor.
You're welcome.
Judge, the next one I'd like to take up is Christy Cowan.
We are on the record in 2025 CR 8, State of Kansas versus Christy Irene Cowan. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Ms. Cowan, who appears via Zoom at a separate location than council. Judge, we do have the labs back. However, in speaking with Ms. Cowan, I believe I need to file a motion to suppress in this, and I would like basically maybe a special setting to hear that.
Very well, Missy. What do you think, Mr. Paul? About an hour?
Yeah, no more than an hour, Judge, and in indulgence to the court, I'd like it about a month out so I could draft this thing. I haven't drafted it yet in all candor to the court. But
all right.
You know me, Judge. I don't try to put things off. I try to get them taken care of as quick as possible.
Right. Okay, so about 30 days or more, Missy.
I have June 24th at 9 or 10 o'clock. That's a Tuesday. Or we could do June 27th, which is a Friday.
Let's do June 24th.
9 or 10.
Let's do 10 so I have time to drink some coffee.
All right, this is continued at request of defendant for motion to suppress. That will be heard June 24th at 10. The defendant is ordered to be back here with counsel by Zoom at that time. And while filing that motion, of course, Mr. Paul, be mindful that Ms. Gillette will need a little time to respond in writing.
That's why I've asked for a month, Judge. Hopefully I'll have it done in the next week, and then she'll have 3 weeks to mull over it.
There you go. All right, we will continue the defendant on her probation with the conditions that she reappear by Zoom with counsel.
I think you meant bond, Judge. I think you meant bond.
What was I continue? Yeah, let's continue her bond.
Thank you, Judge.
Thank you.
So it does change to 10 a.m. instead of 3:30.
Correct.
Right.
Okay. Thank you.
It's gonna probably just change the seats. So I'll just move it up there.
All right.
I'd like to take up Mr. Caldwell next.
All right, we'll take up Caldwell.
Yeah, Christy, you can go.
Okay, thank you. Have a good day.
Thank you. We're on the record in 2025 CR 12, State of Kansas versus Alfonso Deshawn Caldwell. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Mr. Caldwell, who appears in my office.
Announcements, counsel?
Yes, Judge. We have come to a plea agreement. I do not believe that there are labs back. Ms. Gillette can correct me if I'm incorrect. Pardon?
We have them.
Oh, do you? Okay.
17.
I guess they're not in my file. I'm not saying. Judge, Mr. Caldwell is going to plead no contest to count one, unlawful possession of a controlled substance, that being THC. He would also plead no contest to count four, the registration offense. We would stipulate to the affidavit filed by Deputy Blake Fisher in this case. It was filed February 3rd of 2025. Mr. Caldwell was actually going to stipulate to knowing that the drugs in question was THC and or marijuana. Judge, it's a Class B misdemeanor. We would ask for 6 months underlying. We do not have an agreement on reporting or non-reporting probation. I would be asking the court for non-reporting probation. He does live in Wichita. I would also advise the court that he did get his fingerprints and mugshot taken yesterday at the Greenwood County Sheriff's Office. And Judge, he in determining court-appointed attorney's fees, he advises me that he works as a security guard for Campus High School. He makes $14 an hour and works 40 hours a week. And that he has a baby on the way. And that's all I have, Your Honor.
All right, Ms. Gillette, anything further?
No, that's the agreement of the parties. The KBI lab does show that it's THC. And the burnt cigarette with 0.45 gram.
And what is your position on probation, Ms. Gillette?
This is his second date he's been here. So he's taking quick responsibility. It's just there was a bunch of issues getting him served in the beginning. He'd had an NTA, but then we had to send a whole bunch of notices that took a while to get here.
But I would advise the court that he is in my office and taking care of it now, Judge. So I guess reporting or non is going to be at your discretion, Your Honor, because it doesn't sound like I'm asking for non.
All right, Mr.
Caldwell.
Caldwell, thank you. Mr. Caldwell, how do you plead to count one, possession of marijuana or THC, its active ingredient?
No contest.
How do you plead to count four, operating a motor vehicle without valid tag or proper registration?
No contest.
By pleading no contest, you mean that you do not want to admit these charges, but you don't want to deny them and take them to trial either?
Correct.
Do you understand that with these pleas, you're giving up your right to trial, will be found guilty, most likely, and unable to appeal your conviction, even though you're not admitting the charges?
Yes, ma'am.
Is anyone making you enter these pleas today by any threats or promises other than the plea agreement?
No, ma'am.
All right, I will find that the defendant has knowingly and voluntarily entered the no contest plea, and I will accept as the state's proffered factual basis the arrest affidavit provided by Officer Blake Fisher, the probable cause arrest report affidavit as filed February 3rd, 2025. The officer did make the traffic stop. Leading to the remaining charge. I will find there is a factual basis to support these two pleas and find the defendant guilty of count one, possession of the controlled substance, and count two, registration, or count four, registration violation. Remaining counts are dismissed with prejudice on motion of the state per plea agreement. The defendant is issued a 6-month controlling sentence on each count. These will be concurrent suspended sentences, provided the defendant successfully completes a a 6-month non-reporting probation. On count 1, there is no fine. On count 2, it seems like,
That would be count 4, Your Honor.
on count 4, it seems like there's a $50 minimum.
I believe you are correct, Your Honor, but Ms. Gillette can always correct us if we are mistaken.
All right, 50.
Dollar.
I'm sorry, Ms. Gillette. What'd you say?
Fine.
Okay. You'll also be responsible for the $400 KBI. I know you tried to avoid that, but it has been done. So $400 to the KBI, $250 court-appointed attorney fees, $158 court costs, and $45 booking fee. That's quite a bit of money for most people, Mr. Caldwell. How long would it take you to pay that?
Can I get it spread over a year, Judge, or is that too long?
No, Judge.
I would do a year, but it would be on reporting probation.
Yeah. Judge, can we give him since it's a 6-month non-reporting probation, can we give him 5 months? I have the total at 803, if my math is correct.
That's probably pretty close, if not exact.
No, it's 843. I think I'm incorrect. That booking fee tripped me up.
5, 10, 15, 20.
Well, it's more than that.
6, 7, 8, 9. How about 903?
That sounds better.
All right. So that means you're going to have to come up
About 150, a little over 150 a month for 5 months.
Can you do that?
Yes, Judge.
Otherwise, I'll have to put you on reporting probation.
No, I'm gonna have to do it.
All right.
He'll make it work,
Yeah.
Judge.
That means we're going to have to do Missy a pay or appear in about 5 months. Since he's on non-reporting, I need to do that.
How about October 28th at 3:30?
Perfect.
All right. Now, if you have that paid by October 28th at 3:30 and you have no new law violations, you won't have to come to court. Otherwise, you will need to be here.
Okay.
Anything
you,
further
Judge.
on this matter?
Nothing further, Judge.
Thank you.
And
We'll be in recess.
I'll let Mr. Ambrose jump back in, Judge.
Very well. For the third time, we are back on the record in 23 CR 135 and 24 CR 82, State of Kansas versus Lydia Lucille Stubbs. All parties as before. Mr. Ambrose, your client asked to speak to you. Are there any announcements you need to make at this time?
Yes, Your Honor. I think that we could, probably the easiest way to make this work, or most feasible way, is one of two options. One, we could do the form of this as a no contest statement. If the court's unwilling to do that, if Ms. Gillette would be willing to accept a stipulation to all of the violations but for the William Connors issue, we could do that as well.
Well,
I
I'm
don't
not.
believe it.
I need to know if she was seen with him. I need to know that. So if she's denying that, we need to see if there's any evidence to support it.
Yes, Your Honor.
So is the easiest way, so she's not stipulating to the violations?
Under that
So-
circumstance, it's not in full, Your Honor, no. So we'll have to have evidence.
I am going to continue this hearing until the next available show cause docket. I want her live in person at the courthouse. as I suspect she was told to be last time and wasn't. Missy, when is our next show cause docket? I'm just going to continue this. I'll give her partial continuance, counsel. I don't know if it's as much time as she was wanting, but can you get us back on here in 2 weeks?
I have. June 3rd is really full. What about June 10th?
It's 3 weeks.
Yeah.
And are you looking at is that a 3:30?
Yeah, it's a 3:30 docket.
That's a misdemeanor control docket.
Yeah. Or we could do something in the morning if we needed to, a special setting.
We can do that afternoon. I've got morning stuff scheduled in Chase County, it looks like most of the morning.
Well, it looks like she's going to give her continuance to June 10th at 3:30. Miss Morgan, do you want her to come see you anytime in the future?
Yeah, she can give me a call. I haven't heard from her, so that would be great. She'll give me a call after this. Do you need my phone number?
I believe I still have it.
Okay, great. Thank you.
All right. Missy, what's a week from today? We don't have anything a week from today?
We do a week from today, but you had said 2 weeks, so that's why I
that's-
didn't offer you that.
It seemed more, what time, what do we have? What's next week?
We have a misdemeanor docket with only 3 on it at 3:30.
Let's do that. What day of the month is that? June 3rd?
No, it's
May 27th.
May 27th. All right, I'm strike what I said before. I'm continuing this to May 27 at 3:30, but again, you are required to be present at the courthouse, Ms. Stubbs, no Zoom. May 27 at 3:30, both cases. I trust Mr. Ambrose, you're available at that time?
Yes, Your Honor, I've got it.
All right. Do you have any questions about that, Ms. Stubbs?
No, I just got to make sure I can find transportation.
Yeah, you do. All right, we'll be in recess.
Thank you, Your Honor.
You're
That's
welcome.
that's all I've got.
You're excused as well, Mr. Ambrose, as is Ms. Stubbs.
Thank you, Judge.
Okay, thank you.
yeah,
You're welcome.
get to court, get a hold of your bondsman.
There you go. Did you hear what she said? If you need a ride to court, get a hold of your bondsman.
Okay.
Because I'm sure he'd rather buy a tank of gas than whatever amount he posted for your bond. Thank you, Ms. Gillette. All right, we'll be in recess. Ms. Morgan, is that your only hearing on the docket?
I am covering for Miss Seeley on the Corian Green case.
Do we take up Green next then, Mr. Paul?
Yeah, I think that's,
Corian Green case.
Do we take up Green next then, Mr. Paul?
yeah, I think that's the last case.
Mr. Green? Yeah, we'll talk about that.
Oh,
See,
okay.
Mr. Green's at the courthouse. He followed the order.
Yes, he
We
did.
are on the record in 24 CR 78, State of Kansas versus Corian Green. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Mr. Green, who appears at the Greenwood County Courthouse.
This also comes on for a warrant to show cause, and Court Service Officer Jessica Morgan appears. Any announcements, Mr. Paul, on this one?
Judge, I mean, I believe Mr. Green would admit to number one. There, number three, number two. There's things about in number four about reporting virtually. Number three, those are pending cases, and he's not going to admit or deny those because they're still pending. I don't know if we just need to have a quick hearing or not, Judge. If him owing the court cost is good enough for the county attorney, he will waive and we can proceed, but I don't know what her position is.
Ms. Gillette, why don't you just call your witness? That's probably as quick as anything.
Your Honor, we'll call Jessica Morgan.
Ms. Morgan, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very well, please proceed.
Can you please state your name for the record?
Jessica Morgan.
And how are you employed?
I'm a court service officer in Greenwood County, Kansas.
And how long have you been so employed?
It is going on 4 years.
And are you in charge of Corian Green's case now while Miss Seeley is out on maternity leave?
I am covering for Miss Seeley. I can't say I've been assigned the case.
And were you aware that he had fines still outstanding?
Yes.
And has he paid any of those recent fines?
I don't believe so. I can take a look if you don't mind.
Please
Yes,
do.
I'm still seeing a balance of $463 on his case.
And did he fail to report to the probation officer as required?
Per her notes, it does look like the defendant has reported virtually, but received updates from his wife, who was also on probation with Miss Seeley, so he didn't personally report.
And does he have new violations of the law pending?
That is correct.
Did he report those to Miss Seeley within 24 hours of being arrested?
I cannot tell you that.
And was he ordered to follow all standard conditions of probation?
That is correct.
And has he and has he been reporting while he's been in custody in other counties?
I believe his wife has been reporting the information to Miss Seeley, but Miss Seeley has been out on maternity leave.
All right, Your Honor, I will pass this. Or is there anything else that you'd like to tell us about Mr. Green's supervision?
I do not have anything further.
Your Honor, I'll pass this witness to Mr. Paul.
Mr. Paul?
Miss Morgan, do you have the motion to revoke probation in front of you?
I do.
If you would look at 1, 2, 3, 4, 5, 6, basically line 6 of paragraph 4. It says the defendant has picked up numerous new cases which he has reported. Do you have any, would you agree with that statement?
I believe they have been reported, but not by Mr. Green.
Well, it says in the sentence which he has reported.
I cannot speak to that.
Okay, because you're trying to speak on Miss Seeley's behalf, correct?
That is correct.
And if we look at the warrant show cause that Miss Seeley filed on March 25th of 2025, it says, over the course of the probation, defendant has picked up numerous new cases which he has reported. Do you have any reason to doubt what Miss Seeley put in her report?
I do not.
Okay, I have no further questions.
What's the outcome of this Wilson County bond revocation? Was that revoked?
Judge, I'm going to call Mr. Green to the stand and he's going to answer those questions.
All right. Any further evidence from the state?
No, Your Honor.
Of course, if you have any evidence to the contrary, you may have to recall your witness, but go ahead, Mr. Paul.
Thank you, Your Honor. Mr. Green, can you state your name?
Corian Jamir Artrael Green.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right.
I'm going to call you Corian. Corian, is it true that you did not make any payments in the case?
That is correct. And the reason is it was around the time of my accident and stuff, but she told us, or she
Wait,
told me,
stop right there, Mr. Green. Who is she?
Miss Carrie. I know her by.
Are you referring to Miss Seeley, your CSO in this case?
Yes.
Okay, please continue.
She told me that it was going to be sent to collections because she was going out on maternity leave and that she wanted to get us off probation early because she felt like we didn't deserve what we were going through at the time.
And what were you going through at the time?
I was in the accident. I was homeless. I pretty much lost everything and had to start from ground up. And I kept her noted every step of the way.
And by this accident, was this a car accident?
Yes.
And were you driving?
No.
Okay. One of the allegation number 2 is that you failed to report on January 28th of 2025, February 28th of 2025, and March 14th of 2025. Are those allegations true?
I'm not going to say they're incorrect because there was times that I was out sick or something, like down, or on my meds that my wife reported.
Okay, and what kind of meds, and these meds, they were associated with your car crash?
Yes.
What kind of meds did they have you on?
Oxycodone. I'm on Eliquis. I'm on Gagapain. I'm on Norco. I'm on.
So I'll just cut you off there. So quite a cocktail of powerful narcotics, correct? Yes. Okay. Now, in allegation number 3, you've been charged with different crimes in Lyon County. What is the pendency of those cases right now?
They're still ongoing and undetermined at this point.
Okay, and are you do you have the presumption of innocence?
Yes, I do.
And are you into active plea negotiations, or are you going to be taking this to trial?
I'm going all the way to trial with it.
Okay, thank you. Okay, now number 4, it states that you were to report virtually on January 28th of 2025 and failed to do so. Do you remember that date?
Yes, it was the same day I had my physician appointment.
Okay, and were you still under those narcotics?
Yes.
But your wife was giving updates on your condition, correct?
Correct.
Okay, now also in that number 4, it states that you were in Shawnee County custody. Correct. And picked up on new charges. What is the pendency of that case?
Still undetermined, but soon to be dropped. I was a passenger once again.
Okay. And then there's also this bond revocation in Wilson County. Can you explain to the court on that one?
That case has now been dismissed and off my record, no longer existing.
Okay, so you don't. So your probation is closed in that case. Is that what you're telling the court?
The whole case was dismissed. So yes.
Okay. All right. Judge, I don't have any further questions.
What about the Shawnee County one? That's still pending.
That's still pending. He testified that it's still pending, Judge.
Oh, I thought he said that was the Lyon County one.
No, both are still pending, Judge. And
Okay, so he's got a 2025 Shawnee County. He has a 2024 Shawnee County. He has another 2024 Shawnee County. Those are all pending. Those 3 Shawnee counties and his Lyon are all pending.
Correct.
No. 2 of the Shawnee counties were dismissed. It's only the 2025 case that I'm dealing with actively right now.
Okay, well, I see a Wilson County dismissed, but I don't see any of the Shawnees yet. In fact, they say he's got court 5/21. I don't think we're quite, says he's got court tomorrow.
The other one's 5/29. I was gonna ask the court to take judicial notice of those cases.
Yes, Miss Gillette, please proceed with cross-examination.
Mr. Green, what was the date of your motor vehicle accident?
December 18th, 2024.
We can't.
What?
These,
18th, 2024.
Come back up there where we can hear you. I don't know why you're fading out there. Say that date.
Can you hear me now?
Yes, what was the date?
December 18th, 2024.
And on December 18th, 2024, were you also charged in a case regarding that time period?
At that point, no, I was not.
Were you eventually charged for December 18th, 2024 for fleeing and eluding as the driver of the vehicle?
They're trying to say that, but those are just false allegations. They seen my sister dragging me out of the car, is what it was.
And you're trying to contend that you weren't the driver of the vehicle that was wrecked?
Correct.
And Mr. Green, are you on probation or is your wife on probation?
Both.
Are you on probation in this case, 24 CR 78?
Is that this one right here?
Yes.
Yes.
Is it your responsibility or your wife's responsibility to report for your probation officer as to your whereabouts and your meetings?
Absolutely mine.
And so why do you keep saying, well, my wife reported for me? Who's the one responsible for reporting?
I.
Okay. So do you think that your wife reporting for you fulfills your responsibility to report in this matter?
No, not necessarily, but I was down.
Even if you're in the hospital, can you pick up a phone?
I mean, I guess.
And do you have
I have talked to her a couple of times in the hospital.
Okay. So is it your responsibility or your wife's responsibility when you're down, whether at home or in the hospital, to make sure you keep your probation officer noted of your case?
Mine.
So
I did that. Honestly, I have done that. Anytime I got in trouble with the law or anything, she was hearing my voice.
So did you report to her on January 28th, 2025 as directed?
I can't say for sure because I know I was in the physician's office that day as well. So I'm not going to say I did and I'm not going to say I didn't.
Did you report on February 28th of 2025 as directed?
I believe I did.
Did you report on March 14th of 2025 as directed?
Yes, because that's when she was telling us that she was going on leave.
Then why did she say those are the days that you were supposed to report and failed to do so?
Probably because I didn't call off my phone because I talked to her on my wife's phone. Because we were reporting together, and then she did it separately, and then she was okay with doing it together again. So it was, I guess, confusion on my end, and I'll accept the responsibility for that. I should have still called off my own phone, I guess.
I have no further questions of this witness, Your Honor.
Redirect, Mr. Paul.
no, I'm good, Judge. Thank you.
All right. Any further evidence, Mr. Paul?
No, Your Honor, thank you.
All right. I find that the defendant is in violation of his probation and do revoke it at this time. Recommendations, Ms. Gillette?
Your Honor, I have added up all of his jail credit. He has 83 days. I do know that he has had ongoing issues and been needing assistance for medical things due to the car wreck that they were in. It's the contention that he was the driver, but he's contending he's not. With that, his original sentence was 12 months on count 2 and 30 days on count 4 in the Greenwood County Jail. I don't believe he's amenable to probation, frankly. I think he's been a menace over the last several months to Southeast Kansas. And I believe that we had evidence where they even reported a car stolen when it wasn't stolen. And there was a conviction in this county regarding that. And he was involved in that with his wife. And I believe that it would be difficult for the Greenwood County Jail to be able to care for him based on his medical condition right now. So in lieu of putting him in the jail, I would ask that he serve 90 days on house arrest with an ankle monitor at his home, that he can only leave for approved medical appointments that are scheduled in advance, and that he complete 90 days in his in the facility at his house on house arrest. Again, he can leave for legal and medical reasons only. No trips to the grocery stores, no trips to the gas station, nothing other than staying in his house for 90 days.
Recommendations, Mr. Paul? Yes, sir, do you need to talk to your attorney?
Yeah, please.
All right, let's put him in a breakout room,
I
Missy.
would appreciate it.
I'll take a brief recess.
Missy, could you put us in a breakout room, please?
Missy, are you still there?
Yes, Judge, I am.
We need Mr. Paul.
Yeah,
and
I
his
got
wife.
him.
Yep,
Oh, okay.
got it.
Ms. Gillette, why don't we take up one of these pro se's? You should be getting an invitation to a breakout room, Mr.
Can you go back in that one you were just in, Mr. Green?
All right. Let's go on the record in Rojas Rodriguez. We'll be on the record now in 2025 TR 83 State of Kansas versus Gerardo Rojas Rodriguez. County Attorney Jill Gillette for the state. The defendant fails to appear for a status conference on count 1 registration, count 2 registration, and count 3 registration. On April 29th at first appearance. This was set over to today after the defendant had waived counsel and spoke with the county attorney in a breakout room. Ms. Gillette, have you heard anything more from the defendant?
I have not, Your Honor. But was he playing for diversion?
Well, I think you had made him an offer and he was going to think about it. He wasn't sure about it. That's what I understood anyway.
What was the case number you had down again?
It's 25 TR 83.
Yes, Judge, there's a journal entry order of dismissal on file.
Okay. Is it in my queue as far as you know? Is it recent?
No, it was file stamped on May 7th of 2025.
That's fairly recent, but not that recent. Let me see if I find it in Odyssey. Oops, wrong click. Ah, I do see that, Ms. Gillette. May 7th filed journal entry of dismissal. Okay.
What were you two
And
talking about while I was gone, please?
Different case.
Rojas Rodriguez, a pro se,
Oh, okay, sorry.
no problem.
I
And
just-
on this, before we move on the record in 2025 CR 14, State of Kansas versus Caden Allen Mitchell, County Attorney Jill Gillette for the state, Richard Paul for the defendant, Caden Mitchell, who does not appear in person. Counsel, I understand he has been diverted. Is that correct?
That is correct, Judge. And he called my office today and I told him he didn't need to appear.
All right, and that is consistent with the court's order, so that is removed from the docket.
Perfect.
And we will come back to the record in 24 CR 78, State of Kansas versus Corian Green. All parties as before. Mr. Paul, I believe you are,
Waiting on my recommendations.
yes, getting ready to make those.
Yes, Judge. Judge, first of all, Mr. Green, due to this accident, is unemployed and is probably going to have to go on some kind of disability because he can't carry anything. If he's on house arrest for 90 days, that is going to cause a definite hardship. He is the caregiver to his children, and he does not work. Judge, I'm not
How
saying
does
this.
he care for these, but as I recall him telling us they were babies, one of them was on the way, different baby mamas, if I remember that correctly. How does he carry the babies if he can't carry anything to work?
I don't know, Judge, but what?
My daughter walks.
Oh, okay. Judge, I think that, one, Mr. Gillette was not trying to impose any kind of jail sanction because of his health conditions in the jail. Unfortunately, the house arrest, 90 days would be definitely a financial burden, and frankly, I think it kind of sets Mr. Green up for further failure, and we'd just be right back here in front of you, Your Honor. I'm really not sure what to do in this case or my recommendations, but I don't like door number 1 or door number 2, but I think as a kind of a compromise, and I think Mr. Green might be able to make this work. What I would ask for is a 30-day house arrest instead of a 90-day, and then after he does that 30-day house arrest, I would ask for termination of probation. He's got other cases in other counties that he needs to work on, and we're just kind of spinning our wheels here. So that's
Well, I understood his testimony that those other county charges were all going to disappear for one reason or another.
Well, and he says that, Judge, but as we all know, that may or may not happen. I mean, yes, I think at least one of them was dismissed, but you know how loath a county attorney is to dismiss cases, especially if they're fleeing eludes. So sounds like something Mr. Green will probably have to go to trial on.
And you're gonna have to explain this financial hardship to me, because on one hand, I'm hearing he stays at home and takes care of the babies, and on the other, I'm hearing that if he's put on house arrest to stay home with the babies, they're gonna have a financial hardship. How does that work?
Judge, how that would work is he's gonna have to pay for the EMD. He's looking at probably $10 to $15 a day. You know, at that price, that's 300 to 450 a month. If he's
Okay.
not working, then basically the burden comes on his fiance, significant other, and having a sole income household, that would be. I mean, Judge, most 74% of all Americans do not have a $500 emergency fund. You can Google it if you don't believe me. So
Didn't I hear him tell me before that he has two women aiding in his support, his wife and his baby mama that was pregnant? Do I remember that correctly? Have I got the
I believe that he's getting support from these people, but I think that is in lieu of him raising their children together.
his children? Yes.
Yeah,
Okay.
his children. Judge,
Am I remembering that correctly, Mr. Green? Wasn't it you that had the two women that you were having children with? And am I remembering that right? You don't have a valid license?
I have a baby mother and I have my wife that's pregnant.
Okay.
My daughter is almost 2 years old. She'll be 2 in November.
And you don't ever have to pick her up?
I mean, yeah, but I mean, I do what I have to do. Nobody is there when they're at work.
Do we have any kind of
language?
I'm sorry?
Oh, I said it hurts like hell, excuse my language, but I take care of my kids.
And you take care of these two children under the influence of those severe pain medications you were talking about?
I mean, not necessarily, because I have a 14-year-old stepdaughter as well.
Okay, and does she live in the home and help with the babies?
Yes.
Does she go to school outside of the home?
Yes.
So when she's at school and the mothers are at work.
I just have my 1-year-old.
Okay, because I understood you all three live together, right? The baby mama, the girlfriend. Okay. So during the day, you have to take care of these babies at home by yourself?
Yes.
And so while you're by yourself, because of the
I do not
pain,
take my pills.
you don't take the pills during the day?
I take them when I absolutely need them, and that's pretty much at bedtime.
All right.
I use these icy hot pain patches with lidocaine in them, and that's how I get through my day.
Okay. When was the last time you saw a doctor to treat you for your back condition?
Just last Monday.
Okay, so you see the doctor regularly?
I just got a new physician in Topeka.
Oh, just got a new one. What is your diagnosis?
Which ones? Like my mental health?
Tell me.
Physical.
Oh, I have 2 broken hips and a broken femur.
And what's the plan to deal with that? Are they going to do surgery at some point?
Again, yes. I have consultation on the 27th.
And this is from an accident that happened how long ago?
This one happened in March.
This one happened in March of 25?
Yes, ma'am.
And was there a prior one?
The accident in December was
So you've
the
had
initial break.
Was what?
The initial break, the first break was in December.
So you've had 2 car accidents, both of which broke bones in your body? In the same general region? Okay. Have either counsel or the court services seen any documentation of his injuries?
Sheriff did when we went and picked him up, Your Honor.
Say that again, please.
The sheriff did when we went and picked him up.
Okay, so the sheriff saw some type of documentation that he's he has these health conditions and he takes all these pain medications.
Yeah, he was in a wheelchair when we picked him up.
Oh, I do remember that now. Yes, I do remember that.
Judge, it would be a very big stretch, but not to imagine that Mr. Green would just make up his broken bones.
Oh, come on. We've all seen all kinds of things in this business, but I'm not for a minute suggesting that he is. No.
Your Honor, I have no reason to lie to you.
I'm not saying you are, sir. No. Well, it sounds like he has 273 days left on his jail sentence. He is in need of medical care ongoing. I wasn't keen to the idea of house arrest. And it sounds like he isn't either. Sounds like the sheriff probably isn't keen, or the taxpayers maybe, to supporting his medical bills for the next 273 days. And he's not a probation candidate, it doesn't sound like. Even with his wife trying to fill in for him for probation, between the two of them, they're not getting it done. So this is a quandary of what to do with him.
I had that same quandary, Judge.
Yes.
I think
we're all there.
Quandary.
And your suggestion, Ms. Gillette, is 90 days house arrest and then close the case early termination, right?
Yep.
And yours is 30 days early termination, Mr. Paul?
Yeah, I mean, that's kind of my suggestion. I mean, if I really wanted to make a stretch is I would just ask for early termination today. I mean, Miss Seeley had already said that she at one point had indicated to Mr. Green that she was going to send this case to collections and, you know, before she went on maternity leave. I don't know why that changed, but you know.
Well, it sounds like that's the only way we're going to get the money is probably through collections.
And I'm not disputing that, Judge. I'm just saying I don't see any. I mean, in the grand scheme of things, I think, you know, Mr. Green has, I mean, he's suffering now. He's going to be suffering. You know, he's got these physical conditions. Putting him on house arrest makes a hardship. Putting him in custody makes it a hardship on everyone. So, I mean, I never liked, I'm not saying he shouldn't face some consequences, but, you know, one, he got picked up when he was in a wheelchair. Two, he's, you know, if he still has these broken bones. Did you come today in a wheelchair?
Yes.
So he came to court today in a wheelchair. I mean, Judge, I don't know if there's much more punishment that this court could do. I mean, he's got the other cases and let them deal with him, I guess.
And yet, in spite of all of this, he still continues to get new charges in different counties. So who brought you today?
My wife.
And which one is your wife?
Tanya.
I'm sorry?
Tanya.
Tanya?
Yeah,
Tanya
she's
Metcalf.
mentioned, she's
Okay.
mentioned in the motion to revoke probation, Judge.
Yes, she's the co-defendant. Okay. Tanya brought you today?
Yes, ma'am.
Is her license valid now?
It's always been, yes, ma'am.
Oh, okay. Is she still on probation? Is Tanya still on probation?
Are you asking me?
Yeah.
That's more of a question for Ms.
You ought to know if your wife's still on probation. Is she there? Ask her.
This is the thing. I don't know what's been going on with our cases.
Okay, so maybe she's not reporting either.
No, she's talking to Jessica, right? Is that your name?
No, you don't need to be talking to her.
No, I'm saying she's been talking to her. Tanya's been talking to whoever she's supposed to be reporting to.
So it sounds like she's still on probation and you know that. All right, well, I'm going to follow the state's recommendation. He'll either do 90 days on house arrest with EMD, or he can do the balance of 273 in the county jail, and Sheriff Samuel's budget, and the taxpayers will have to absorb it. So which will it be, sir? Do you want to do EMD on house arrest, or do you want to do for 90 days, or do you want to do jail for 273?
I'll do house arrest.
Excuse me, I can't hear you.
I'll do house arrest. I have to be there for my kids so they could work.
And you're going to only be allowed out of that house to go to court events and medical treatments. And you have to verify both of those. And don't be stopping at the convenience store and getting a Coke and whatever you do.
That's fine.
Judge, I'd ask that he have the GPS on today before he leaves the courthouse, or
Absolutely. So do we have a number for him to call and wait for the GPS?
I think if he goes over to the jail lobby, they can probably help him get GPS to come on over.
Mr. Green, what is your problem?
How do I get it? Okay, so I already have a monitor on. How do I get it merged?
You already have a monitor on for whom?
For
Which jurisdiction? Lion King. You have to ask the EMD guy that.
Which company are you through, Corey, on?
Honestly, I don't know.
Is it Butler County, Lyon County?
Shawnee County.
It's through Lyon County.
Said Lyon County.
Well, I want this case covered.
Okay.
And the orders for Lyon County are not going to be the same as my concerns. So if you have to pay for two of them, you have to pay for two of them.
I think he can be on one for both of them, but they'll just have to restrict his movements to be the same.
All right, well, you go on over to, well, how about the jail comes and gets him? I don't want to just turn him loose. He might not come back.
I'm
still here.
Yeah, I'm on house arrest.
And he does have an ankle bracelet on.
Who am I talking to, please?
Mr. Castle.
And Mr. Castle is the security guard.
Mm-hmm.
Yes.
Okay.
We'll
Well,
send a copy of the journal entry to the service provider. If Mr. Pa can talk with him after court and get me the service provider's name, we'll make sure they have a copy of the journal entry.
but Deputy Castle, make sure he does not leave this courthouse or the adjoining sheriff's department without an active ankle bracelet that will assure this court that he is either at home, at a medical appointment, or a court appointment. Nothing else. You can't go anywhere else. Can you do that, sir? Or give him to another deputy who can make sure that's done, or whatever you need to do?
I will take him over to the courthouse myself. Or
All right.
To the jail
jail.
myself.
The courthouse is closed. If you wouldn't mind doing it, that'd be great. Thank you, sir.
No problem, Judge.
All right, so we'll be in recess. You're excused to go with the officer to the sheriff's office to get your monitor fixed, however you need to do it. And then I have one more case on here. It's not yours, Mr. Pa, so you can be excused.
Thank you,
if
Your Honor. See you in the morning.
You guys haven't worked that jury trial out yet?
No. No.
Okay,
I'll
so
see your-
which one, I think I got my defendant mixed up. Which of your two clients is going to jury trial? Is it Michelle Turner?
Correct.
Or Heather Hunt? It is
Correct.
Michelle Turner.
Correct.
Okay. See you tomorrow morning, live and tomorrow.
Yes, Paul Dean has this case.
Oh, okay. As long as I have a prosecutor. All right, thank you all. Now, Mr. Thornburg, let's take you up. We're on the record in 2025, CR 45, State of Kansas versus Gary Dale Thornburg, County Attorney Jill Gillette for the state. Mr. Thornburg appearing in person and pro se.
Hello?
Okay. Yes, sir. You've been waiting a long time. You are here on possession of marijuana and drug paraphernalia, appearing on your bond. Not have an attorney. When you were in front of Judge Satterfield at first appearance, April 15th to 25, you were read your rights and charges, possible penalties, entered a not guilty plea. You applied for an attorney. She found you did not qualify. How do you want to proceed at this time, Mr. Thornburg?
Why did I not qualify, Your Honor?
I don't know. I wasn't the judge. It was Judge Satterfield.
Oh, well, I mean, I'm not guilty, so I got to get an attorney, but I mean, I didn't know that I didn't qualify. And or
Well,
why? Because I don't have a job, so
did you have a job when you saw her?
no, ma'am.
Okay, you didn't have a job. Why didn't you have a job?
Well, I just ain't been working. I've hurt my back, and I just haven't been working.
So how long have you been not working?
Oh, year.
And are you living with a wife or a girlfriend or someone of that sort?
Yes.
What
got a
kind
wife.
of what kind of work does your wife do?
None.
Okay,
Not
so
now. She's not working right now,
was she working when you saw Judge Satterfield?
ma'am.
Did you fill out a written application for court-appointed attorney?
Yes, ma'am.
Let me see if I can find that in the file and take a look at it. Why are neither one of you working? You've got a painful back, and what's her reason?
Well, she used to work for On My Own, and her lady passed away, so she's not picked up another client yet.
Who's paying your bills? Who's putting the roof over your head,
I
feeding
own
yourself?
it's the family home. I own it.
Well, maybe that's it. Maybe you've got enough assets that Judge Satterfield found you could get a loan or do whatever you need to do to pay for your attorney rather than have the taxpayers pay it. I'm speculating that might be one reason why she denied it, probably. I am not seeing an application in the file. I see the appearance bond, an intent to proffer from the KBI lab reports, a probable cause affidavit from the arresting officer, and a complaint. So typically, if you fill out a written paper, it goes in the file.
Okay, how do I get one of them written forms, ma'am?
You want to try to apply again?
Yes.
Well, you'd have to contact, where do you live? What town?
I live in Rich Hill, Missouri.
Well, I suppose you could, let's see, Missy could email you one. Missy could email you one and you could send it back through regular mail. Or what's the other way, Missy?
They'll have to scan it or fax it to us.
Scan it or fax it or put it in the US mail.
I can probably fax it back, ma'am, as soon as I get it.
Did you think you might qualify for diversion where you could apply? No, you don't think you would?
I don't know. I hope so.
Well, is your record clean?
No.
Okay, well then diversion is usually for first-time offenders or people with very little on their record. With you being in Missouri, I don't know what your record looks like. I only have what's been filed in the state of Kansas.
Well, I've only been in trouble once in Kansas, but
But they go by wherever you get into trouble, not
right.
just. All right, I'm going to continue this to the next docket, whichever one Missy's not so crowded. Which one is that?
You want to go into June, because by the time he gets the application, gets it back to us, it's going to take a while.
Okay, June.
How about June 24th at 3:30?
You must be back here by Zoom, June 24th at 3:30. And Missy, you're going to email that application to him?
Yes, I'll do that right now.
So you get that and you get it back to me. Put it in the mail tomorrow. You'll get it tonight. Put it in the mail tomorrow.
Yes, ma'am.
And I will see if I can track down what you told or gave Judge Satterfield at the last hearing.
He did because Judge Satterfield was in El Dorado. And he appeared by Zoom, so.
You would have asked him then orally.
Yeah.
Now, if we have time to get that at some point, that'd be great. But I know we're going to be really busy with jury trial and whatnot for the next few days. All right, so be back here at that date and time. And Mr. Gillette, anything further?
Nothing further.
They'll email that application to this link, right?
To the email I had for you, yeah, the email that you got this link at.
Okay.
All right,
Thank
but
you.
you said you're living free of rent in the family home, but who's paying your bills, paying for diapers or whatever you need there? Who's paying for that?
Well, I don't have diapers or nothing like that. It's just me and my wife. That's
Who's
my
the
daughter's
child?
kid.
So
What's
does your
that?
daughter live there? Does your
No.
daughter live there?
No, I'm at my daughter's house on Zoom right now.
Oh, I see. All right. Well, somebody's got to be feeding you, taking care of your day-to-day needs.
Yeah, I mean, odds and end things, I guess.
You
Don't
guess.
eat a
Well,
lot.
I feel like you're not being totally candid with me, sir.
I'm
That
being
there's more
totally
to
honest
this.
with you, ma'am. I mean, I do odd and end things. We just don't eat a lot. And we don't have a lot of bills. My family house is paid for. We just stay there.
I'm not buying that you don't have any expenses. So you don't eat a lot. You have to eat to survive. All right. Well, I will see you back here June 24th at 3:30, or probably issue a bench warrant if you don't get that application back to me in the next day or two. And if you don't show up,
I'll be here.
and you're probably going to need to get me some, well, never mind. All right. We'll be in recess. You may go at this time, sir.
Thank you.
You're welcome. Anything else, Missy, that we need to address before I close the docket?
I don't think so.
Ms. Gillette, anything further?
Can't think of anything else.
All right. We are adjourned. Thank you all.
Every day in the USA, people find themselves in court.
All right, I think we have Annabella Smith next. All right, is Mr. Delaney back?
Don't see him.
All right. You said you don't see him, sorry?
I don't see him. He's still in the breakout room.
All right. right, I think we'll give him a couple more minutes and I may have to close the breakout room. But I told him 10 minutes.
Your Honor, I'm not sure that Annabella's on. It appears that she's not in
Oh.
school today, so I'm gonna have Mr. Fighter give Mary a call real fast.
Okay, all right, thanks. All right, Ms. Delaney, or Mr. Delaney, I don't know if you heard that. We're just trying to locate Ms. Annabella. Okay. Ms. Wagner, before I forget, do you know, are there any arraignments today?
There are not.
Okay, thank you.
Your Honor, Mr. Fighter just spoke with Mary. We'll have to give Mary a call as she cannot log on to Zoom at her house. It does appear that Bella is now in school, so Mr. Sargent was aware of this hearing. He just has to find Bella as she showed up late.
Okay, all right. Okay. Mr. Delaney, do you know on the locker case, is that going to be a plea or an adjournment, or do you know where things stand? I'm just thinking timing wise.
I do not know, as I am the guardian ad litem.
Okay.
So
All right, are those, go ahead.
I haven't heard from the counsel for the parents what their what their status is.
I'm just wondering if I can do that while we wait. Ms. Wagner, are the folks here on the locker case? Or actually, is Mr. Summerfeld here?
He is here.
Okay, Mr. Summerfeld? I just have a question for you. We're waiting for a case that Mr. Delaney is on in the DL matter, and I have a brief intermission here. Will locker take longer, or is it going to be a plea, or probably just an adjournment? What do you anticipate will happen today?
Judge, I spoke with Mr. Brown. He's Mr. Locker's attorney. He was trying to get in touch with Mr. Locker yesterday. I see Mr. Brown is here now. I think we should toss it to him.
Mr. Brown, do you know the answer to that question? He sent out.
Okay.
And then you can have that discussion with him and Mr. Summerfield and Mr.